Mr. Shackelson?
Chair, just before we start, we asked at the end of the hearing yesterday for a series of documents from Mr. Carrim. The one was a two-page agreement with Mr. Mamela in relation to the mining venture. The one was the draft agreement that Ziggy had with Medicare 24. And then there were the details of the accountant who instructed that Mr. Matlala should pay Tamiz, not Ziggy. And lastly, we wanted to hear back from him after he'd consulted with his attorneys in relation to accessing his WhatsApps from 2024, 2025 with Mr. Mokgotsi and Mr. Matlala. I wonder if we can just get a response on the record from his legal team in that regard.
Mr. Bana?
I think we can just ask, you can just go through it with the witness and you'll hear it from him firsthand.
Sorry, if we can go through the...
Yes, he hasn't been able to get the two agreements. He needs to go to Mafeking. He'll tell you the name of the accountant. I've forgotten the name. And he'll also tell you the position with his messages.
Thanks, Mr. Carrim. Can we take them one by one, and can you just explain to me what the position is? The first is the draft agreement with Medicare 24.
Yeah, it's two documents. Medicare, we can deal with the two.
Okay, the Medicare 24 and...
Yeah, those documents and my gang. At the moment, my offices are closed because of the threats. So I have those documents. Once those threats just subside, my office is working remotely now. My people are working remotely. But those documents will be made available as soon as I get to Mafeking, as soon as it just comes down, maybe in the next week and a half.
Thank you. So that's both the Mamela agreement relating to Chrome Core and
Yes.
the draft agreement with Medicare 24.
Yes. Yes.
Then the accountant who advised you in relation to payments from Mr. Matlala.
My legal team will send an email to the instructing attorneys with the email address and the contact details. You can just send your request there.
Thank you very much. And then lastly, the issue of WhatsApps with Mr. Mokgotsi and Mr. Mamela in 2024 and 2025.
I've checked my iCloud. I don't do backups. I don't have any chats on my current cell phone from then.
So your WhatsApps for that period are not available?
I don't have backup, so they don't back up, and I changed my phone.
And would you give us your authority to approach Apple so that Apple can search on their backups?
I'll speak to my legal team about that, and they'll revert to you.
Thank you. When we left off yesterday, we were dealing with the payments to Mr. Mamela or to Lutaga for Mr. Mamela that were made by Tamiz from the proceeds of payments from Medicare. Now, at the time that you entered, I want to stay with the issue of Mr. Mamela for a while. At the time that you started this business relationship with Mr. Matlala, I assume that you were aware that Mr. Mamela had been a business associate of Mr. Matlala.
At that point, he didn't disclose that to me.
No, but you'd read articles we discussed earlier that from, I think it was April 2024, you'd read articles about allegations in relation to Mr. Mamela and Mr. Matlala at Tembisa Hospital.
Yes, we never discussed those relations. He never brought Mr. Matlala up to me.
No, yes, but I'm asking, were you aware that there was a business relationship between the two of them?
At that point, I saw articles, but there was no direct link between them.
I see. So all you knew is what you had read in the press about them?
That's correct.
Did you, at any other stage, find out about business relationships between Mr. Matlala and Mr. Mamela?
When I concluded the agreement, or when we had the handshake or the verbal agreement with Mr. Matlala in June, around August, I then asked Mr. Mamela, look, you've never raised Mr. Matlala with me. Are you and Mr. Matlala associates? What is the issue? He then said to me, yes, we are. So I asked him, but you never told me this. He said, yeah, look, I don't think it was important for you to have met this man through me. And that was his stance. He said, look, I didn't want to introduce you to Mr. Matlala. I said, why? He just said, no, I didn't want to introduce you to Mr. Matlala.
At a certain point, Mr. Matlala must have established that you and Mr. Mamela knew each other.
Not that he told me off, unless Mr. Mamela discussed it with him.
Well, your Morgan sorted email suggests that he knows that you know who Morgan is.
Yes, remember, he then said, I must make a payment to Morgan Mamela.
And at that point, did he not know that you knew Mr. Mamela?
Well, he also played to me as if he didn't know that me and Mr. Mamela are friends.
So, from your perspective, someone was asking you to make a payment to a third party who, as far as you were aware, they regarded as a complete stranger to you. So when you were asked to pay Mr. Mamela, Mr. Matlala didn't give any indication that he knew that you and Mr. Mamela were friends?
No, between the two of them, and I observed this, they did not raise how deep their relationship was to me. They did not.
But Mr. Mamela was also calling you at the same time and pressurizing you to get Mr. Matlala to pay him. What was he saying in that regard?
No, he said he's asked this man to give him money, so this man needs to pay him this monies. He's aware that this man is going to pay me, and I should then please give him the money once I receive it.
So, but by this stage, this is after August 2024. It's well after August 2024. It's February 2025. So by this stage, you have discussed with Mr. Mamela that you're now in business with Mr. Matlala. And he said, well, I didn't think it was important for me to introduce you. Didn't want to introduce you to him. But he now, in February, starts calling you and saying, Mr. Matlala is going to pay you, you must pay me. Is that what happened?
They had an arrangement, or Mr. Matlala, he asked to borrow money from Mr. Matlala. I don't know what it was exactly, but according to him, Mr. Matlala needed to pay him. Either money is owed or money is borrowed. I just can't remember what it was, but yes.
So you can't remember whether this was money that was being borrowed or money that was being paid out as an amount due to Mr. Mamela?
Yes, it's either a loan, I can't remember.
Can I take you to some other chats in relation to yourself, Mr. Matlala, and Mr. Mamela? Do you recall in January 2025 there was an exchange between you and Mr. Mamela? Sorry, and Mr. Matlala, in which he asked you to check how far payment was?
Can we go to that document?
Yes, we can. The document is on page 4.
Page 4 of, okay.
File 1, the evidence bundle.
Yes.
And we went through this yesterday. You get called on the 30th of January by Mr. Matlala, Salam, brother, can you please check with your guys how far is the payment? You come back saying checking. He says, and you say, we'll revert. He says, okay, thanks. Next morning, you say, morning, they say payment is done, I'm waiting for the remittance. If we go at this point to page 538, that's file 2.
Sorry, I'm just struggling here.
No problem.
Five.
538.
I'm on 414407.
Does your file not go to 538? File 2? Possibly in a supplementary file?
Yeah.
So at 538, we see that on the same day, the 31st of January, after you've said, I'm waiting for the remittance, and in fact, after Mr. Matlala has responded, okay, I'll be waiting, and has asked you, you're winning with the remittance, which was at 15:15 on the 31st of January. A minute later, he sends a screenshot of that chat to Mr. Mamela. You see that?
Yes,
This is his chat with Mr. Mamela.
Yes.
And the date is the 31st and the time is 15:16:10. So he is copying his chat with you to Mr. Mamela.
I have no idea why you do that.
Well, let's go further. If we go back to page 5, you see 40 seconds after he sent the screenshot to Mr. Mamela, which ends with you winning the remittance, you winning with the remittance, you responded, not yet. He sent that screenshot at 15:16:10. You respond at 15:16:52, 42 seconds later. And then you say, the lady insists it's paid. I'm just waiting for some proof. We go back to 539. And we see that after you have answered his question, you're winning with the remittance, and you've said, not yet, the lady insists it's paid. I'm just waiting for some proof. He emails that chat to Mr. Mamela. So he's now emailed to Mr. Mamela an updated version of his chat with you.
Emailed or?
WhatsApp.
WhatsApp, yes.
WhatsApp. And straight after WhatsApping to Mr. Mamela at 15:29:23, we go back to 5. He says at 15:29:46, he says to you, okay, we'll see when it appears in the account.
Yes.
So he's having a conversation with you, and he is essentially copying that conversation as it develops to Mr. Mamela.
I see that, yes.
And you have no idea why he would be
I
doing that?
have no idea. It's the first time I'm seeing this. I don't know why I would take my chats and pass them over to Mr. Maumela.
I see. Let's look at a second instance of this. Can we go to page 11? And there we see at the top of page 11 on the 18th of March, at 10:22 and 10:23, there are calls from Mr. Matlala to you. And at 10:40, you respond saying, "Salam, I'll call you at 12." And he immediately responds to you at 10:41, saying WLKM SLM, which I understand to be wa alaikum salam.
Yes.
If we then go to 5:44, we see that as soon as he has said wa alaikum salam to you, he again WhatsApps a screenshot of that chat, which just shows two empty voice calls, "Salam, I'll call you at 12, wa alaikum salam," to Mr. Maumela. And if we go down, we see at 10:41:43 there is an immediate response from Mr. Maumela. He calls Mr. Matlala back. You see that?
Yes.
Do you have any idea what you were discussing on 18 March 2025 that may have been of such importance that Mr. Maumela wanted to screenshot that exchange? Sorry, Mr. Matlala wanted to screenshot that exchange to Mr. Maumela, and Mr. Maumela immediately responded to the screenshot of what just says voice call, salam, I'll call you at 12. He immediately responded. Any recollection of what you would have been talking about on 18 March?
No, I don't know why he was sending Mr. Maumela my screenshots. I can't recall of anything important that we were discussing with Mr. Matlala.
Well, let me try to jog your memory. If you go to 5:43, you will see that almost immediately after your voice calls with Mr. Matlala, which were at 10:22, those voice calls that we just saw on the screenshot, a series of visitor codes to Zimbali Estate. Well, let's go. Were WhatsApped from Mr. Maumela to Mr. Matlala. Does that help you remember anything?
No, I don't know. I don't know why he was sending him Zimbali. I've never been in. At this point, I was not even in Zimbali.
You went in Zimbali.
Yes.
No.
But I don't know why he was sending him these.
No, he wasn't sending them to you.
Yes, he was sending them to. Yes, so
Mr. Maumela sends them to Mr. Matlala.
Agreed, but I have no idea why these were sent.
Okay. Well, the evidence will be that one of these entrance codes that Mr. Maumela sent to Mr. Matlala immediately before those calls, those voice calls to you that were then screenshot and WhatsApped to Mr. Maumela, one of those entrance codes was forwarded by Mr. Matlala to General Cele and was then used by General Cele to enter the Zimbali estate. So at 10:41, when Mr. Matlala WhatsApped Mr. Mamela your exchanges, saying that you would call at 12, it seems that they knew that Mr. Matlala was likely to be meeting with General Cele at the time. Was any of this discussed with you?
No, nothing. I know nothing about this. Any meetings, I knew nothing about all this. Not at all.
You didn't know about that?
Not at all.
And in due course, you did call back at 12:28. We see that at 11. Go back to page 11.
Yes. Yes.
And you have no recollection of what transpired in that call?
I can't recall what we were talking about. But
And no one mentioned anything about General Cele to you?
I knew nothing about this meeting.
But what it does appear is that Mr. Mamela and Mr. Matlala knew that Mr. Matlala would be meeting with General Cele at the time that you were likely to call. And they didn't seem to make any attempt to stop your call. Have any comment on that?
Yes, but it was definitely not related to General Kelly. I did not know about this meeting.
You didn't know about that?
No, I did not know about this meeting.
Let's go to another issue in relation to Mr. Mamela. In your witness statement at page 5, paragraph 47, you talk about that interdict.
What paragraph?
Paragraph 47, page 9 of the witness statement.
You said 5.
I apologize. Page 9. Page 9.
File 1.
Perhaps,
Of the witness statement file.
sorry, Mr. Chaskalson. I see from the heading it's a totally different subject. May I just ask 2 or so questions around the issue of the payment? Mr. Carrim, you'll remember that yesterday I asked you, and I think Commissioner Baloyi also asked you questions along the same lines. I asked you as to why Mr. Matlala had not paid directly to Mr. Maumela. And I think you didn't really have an explanation for that. Am I correct?
No, I did, Counsel.
You did? All right. What was the explanation? I'm sorry.
No, I said he insisted. And I said to him on numerous occasions, you can do it yourself. You can pay this money.
Yes.
Why do you want me to pay this money? He said, look, you need to help me. You need to pay this money. I'm under pressure. I need to pay him this money. And that was the explanation that he gave me.
That's not really an explanation. That's just an insistence that you must do it instead of him. So it doesn't really explain why you and not him. So I guess that's why I was saying, and you didn't really have an explanation.
Yes.
Yes. Now, it seems to me that this gets complicated in the sense that Mr. Maumela, I'll paraphrase, of course, I will not use the exact words that you used. You said something like, Mr. Maumela said to you, this man had to pay him, and that you must pay him after you've been paid. Am I correct? Is my paraphrase correct?
No, I'm saying the arrangement was between them. And once Mr. Matlala...
I'm talking about, am I correct that there was communication between you and Mr. Maumela in relation to the payment. Am I
Yes, but
correct?
before that, him and Mr. Matlala were discussing the payment.
Yeah. But now I'm talking about...
Me and Mr. Maumela, yes.
Yes. And as I say, I mean, I took cryptic notes, but what I captured was you said something like this man being Mr. Matlala, must pay must pay Mr. Maumela. And also that once you have received payment from Mr. Matlala, you must then pay Mr. Maumela. Am I correct?
Correct.
Yes. So I'm saying this, in a sense, gets complicated in addition to the questions I asked yesterday. I'm wondering, in my mind, Mr. Maumela already knows that he's going to be paid out of monies that have been paid to you. And I'm wondering, why is he not saying to Mr. Matlala, pay me? And did you ask, why must it be this secateurs? Why must it, instead of the direct payment, let me, as Mr. Carrim, just get my money, and that's it. I have nothing to do with you. Get your money directly from Mr. Matlala. Do you have any idea why it had to be secateurs?
Like I said, Commissioner, I kept on saying to them.
Now I'm addressing between you and Mr. Maumela now.
It had to go. I agree that rightfully Mr. Matlala had to pay him, but like I said, they put me under pressure for me to have paid him. And I think I didn't refer to a document yesterday, and if I can just take you to this document on the messages.
Yes.
So he wanted me to pay him, and at the same time, if we can just go to the messages.
Which page?
When he called me to make this payment, he then called me and said, look, I've got more invoices in, I think those invoices...
You are talking Mr. Matlala
Yeah,
now.
Mr. Matlala.
Yes.
So in order for him to make me or to force me to pay, he said to me, there's another 13 million rand going to be paid. So please, if you can pay this, and I'll see you good on the next payment. Because at that point, I was still asking, why don't you pay it directly? You can't pay it directly. He said, no, you must pay him. Please help me pay him.
It would have been much easier and quicker for Mr. Matlala to pay directly to Mr. Maumela. I'm sure you would agree.
Yes, I agree. But
Yes. And did you ask Mr. Maumela why the payment had to be secateurs?
according to him, he said that was the instructions from Mr. Matlala that the payment will come via me.
But did you ask Mr. Maumela?
Yes, I asked him, why don't you ask Mr. Matlala to pay you?
To pay you
Yes,
directly.
to pay you. Why is he paying me? He said, no, Mr. Matlala said, you're going to make the payment, so that's why I'm calling you. Please, when you receive this money, make my payment.
But that doesn't answer the question. But why me instead of directly? Did you ask that?
I've asked him. Like I've said, I've asked Mr. Maumela,
You see, thing is, being told that Mr. Matlala said he will pay you and you will pay me doesn't answer the question, but why is the payment not direct? Do you get what I mean?
Yes.
Did you ask why is the payment not direct?
I did ask. I just didn't get a response from Mr. Matlala was just insistent. He would just be insistent. He would say, please, you just have to do this. He would not even give a reason. And I asked him, you can make this payment directly. You don't need me to pay him. Why must I pay him? And he gave Mr. Maumela the same story and said, just call Carrim and tell Carrim to make the payment. Once he
So you basically have no explanation from Mr. Matlala. You also have no explanation from Mr. Maumela. Did you not become suspicious of all this?
No, Mr. Matlala's explanation, like I said, he either owed, I can't remember correctly, either owed or loaned, something to that effect.
Earlier I asked you, and what you said was not really an explanation, and I said to you in so many words when we commenced with this debate, I said, but that was not an explanation.
Yes, he didn't give me an explanation, Commissioner.
Yeah, so my question then is, you have no explanation from Mr. Matlala, you have no explanation from Mr. Maumela. Did you not become suspicious about this secretar's mode of payment and why it had to be so?
Yes, I did, but like I said, on Mr. Matlala's instructions, there was more money to come. So I didn't want to upset him so that I don't get money on the next payment.
So you say you did have a suspicion. What was that suspicion?
No, the suspicion was that why would he not pay directly? Why would he want to pay me?
What was the nature of the suspicion that you had? What did you suspect?
No, I just suspected between the two of them, why were they using me? They could have just dealt directly. And then Mr. Matlala then says to me, look, there's another payment coming in of 13 million. I'll see you good there, so please just do this for me, and when the next payment comes in, I'll sort you out.
And then despite that suspicion, you just went ahead and paid as requested by Mr. Matlala.
Correct.
Thank you. Thank you. Thank you.
You were referring to the chats. Are you referring to the chats of the Morgan sorted payment, which are on page 7?
No. Can we just go back to your question? We were busy with we were busy with the chats.
No, I'm just following up on the question the chair's asked you at this stage and your answer to the chair. So you said at the start of your answer you wanted to refer to the chats, and you talked about a call that you had with Mr. Matlala, and if I understood your evidence correctly, that was the call where Mr. Matlala said, just do this and now there's more money coming, I'll pay you out of the next payment.
Yes, I was going back to the issues of, I think, was it the chats between Morgan and between Mr. Maumela and Mr. Matlala?
Which chat? So there was the chat in relation to invoicing at the end of January, and then there was the chat that happened to be on the same day that Mr. Matlala met General Pele at Mr. Maumela's house in Zimbabwe. Which of those chats were you referring to?
I wanted to go back to where Mr. Matlala then sends me a payment screenshot on the 7th of March.
Look at page 6. Is that the screenshot you're looking for? The one that shows the payments that are going to reflect on the 4th?
No, I was going to the one of the 7th of March on page 8.
Yes.
Where he mentioned to me that these payments are coming, and then he then sends me the screenshot of those payments coming.
And what were you, I just didn't understand your reference to it. What were you?
I was just trying to say that the reason I made that payment was because he dangled this in front of me and said, here's more money coming, make this payment for me.
But which payment are we talking about now?
I'm saying he knew already I'm talking about here when we go back to the 4th of Feb.
Yes.
That's the first payment.
Yes. But that screenshot is sent to you on the 7th of March after you paid, sometime after you paid 500,000 rands to Mr. Maumela.
Yes, but I'm saying, sorry, Council, I'm saying he knew about this payment then already. So he called me about this payment of 13 million and said, there's a payment of 13 million coming. And I was like, can you send me something? And as time went on, I said to him, you said I must pay Mr. Maumela and there's money coming. you have to reimburse my money. That's when he sent me this screenshot to try and convince me in March that money is coming.
But then after you've seen that screenshot, he asks you to pay more to Mr. Mamela.
Yes, another 250.
Yes, and you do.
Yes, because he then says to me, I'm giving you money, here's money coming. If you can recall, Council, yesterday I said the initial amount they wanted me to pay was 750, which I refused on that first payment.
Yes, I understand that, but if I understood your evidence correctly now, what you were saying is he offered you the prospect of more money coming so that you could pay Mr. Mamela the 500 that you'd now agreed to pay, and he would give you back that 500 and more with your further payments.
Yes, he said that, but he didn't give it back to me.
Yes, but then why in the face of that, when the next payment comes through and is only 1 million, so you're now in a net position where that payment is really only 500,000 because 500,000 of it really has already been paid by you to Mr. Mamela. Why do you go ahead and then pay half of your net proceeds to Mr. Mamela, 250?
It was 250 from a million, so it was not half, it was a
but
quarter.
500 of the million was what you were owed from the first payment, was it not?
Yes, when I asked him, he then said to me, I'll make a follow-up payment, which didn't happen. And then he then said to me, I think if we can go to page 9, is it the 10th of March? This was the 7th. There's another one here also related to payments.
Are you talking about the screen at 1743 on the 10th of March?
Yeah, at the bottom there. He then says to me, no, that's still coming in. That will be still in the system and I'll see you good.
Mr. Carrim, I don't want to traverse ground that we traversed yesterday, but when we dealt with this stuff yesterday, I put it to you that you don't strike me, one, as a naive businessman, two, as a businessman who lets people walk all over you. And your response to that, and I must say, I was convinced, I found it an honest response and a response that I accepted, was yes, but I now was a bit scared because I had seen press reports and I had seen press reports. I didn't know if they were true or not, but I was scared. They may have been true. I wanted to protect my family and myself. Now, is that what your evidence is? Is your evidence that you paid Mr. Mamela the 500 and the 250 principally because you were scared not to comply with what Mr. Matlala was telling you to do?
Yes, I was, Council.
Because then I think let's just be clear about that. And promises of future money and the like, they're not really convincing. And I can accept that answer. I would also have been scared.
Okay, thank you.
But I now want to go back to the Mamela relationship. And if we go to page 9 of your statement, you talk about this Brown Mokgotsi Foundation interdict.
Yes.
And you say at paragraph 47, Brown approached me for financial assistance regarding litigation to review and set aside a tender that was prejudicing the people of the Northwest. I agreed to assist them financially because businesses in the Northwest are consistently overlooked when tenders are awarded, despite tender documents that award points to Northwest-based business. This doesn't contribute to economic growth from the Northwest. I'm from the Northwest, and this is a matter I care deeply about. So what you're saying is that the contribution to the your funding of the Brown Mokgotsi Foundation interdict was really because you're wanting Northwest money to stay in the Northwest.
That's correct.
Now, if we go to page 507, we see that although the litigant in this case was the Brown Mokgotsi Foundation, your payments didn't go to the Brown Mokgotsi Foundation, they went to Gotle Specialists. Is there a reason why you didn't pay the litigant? You paid, as it were, the principal officer of the litigant's wife, or the wife of the principal officer of the litigant. Why were these payments channeled through Gotle? Why did they not go straight to Brown Mokgotsi Foundation or indeed to the attorneys?
Brown Mokgotsi Foundation didn't have a bank account, according to what Mr. Mokgotsi said. He then asked me to please put these funds into Gotle Specialist and that he would transfer them to the attorneys, Tao Matsimela attorneys.
So this was an indirect payment which was made because you understood that Brown Mokgotsi Foundation didn't have a bank account.
That's what he told me.
That's what you've been told. Why didn't you pay directly to the attorneys?
Because I needed to show, Brown said to me they are going to refund me this money. He was approached by a few business forums, and together they would then refund this money at a later stage. So I then agreed to give it via his vehicle that he chose so that he can be the responsible person.
Now, if we go to page 511, we see the judgment in the case. It's a judgment of Brown Mokgotsi Foundation versus MEC for Health and Mediware. Mediware was the successful tenderer that was interdicted. Is that correct?
Counsel, if you go into my statement, I clearly say there, I said to Brown, I'll assist them, but I don't want to be part of the litigation. So I'm not aware, I don't know about Mediware and who he was taking to court.
So you would assist, you weren't even aware that whether Mediware was a local company or not?
No, I did not get involved in the actual litigation. I said to him, I don't want to be part of the litigation, and they went ahead with this. I was not party to this.
So you put up funds for litigation to protect local businesses without even knowing whether the successful bidder was a local business?
Like I said, I did not want to be part of the litigation, so I did not want to check what, I did not even check who's going to court, who's not going to court.
But Mr. Carrim, considering what you say in your statement, the reason for providing financial assistance is to make sure that business stays in the Northwest. I would expect that you would have looked at who is the winning bidder, because your interests, your declared interest in paragraph 48 is to make sure that that kind of business stays in the Northwest.
Yes, he approached me. He didn't give me details. He just said to me, there's these business forums. There were 3 or 4 business forums with him on the day of the meeting. They all requested that I assist them. And I said, okay, it's fine, I'll assist you, but I don't want to be part of the litigation. I'll assist you and you guys can then proceed. And they then agreed with Brown that they'll use his foundation.
Yes. No, I've heard you say you didn't want to be involved in the litigation. I've heard that part. I'm asking a different question, following up on what Mr. Chaskalson is discussing with you, that in paragraph 48, you say you provide assistance because you want business to stay in the Northwest. It must be business granted to Northwest-based businesses. That's what you say. So what I'm putting to you is that you surely would have satisfied yourself that this is the winning bidder is not a Northwest business.
Brown just told me it's a company from outside. I agreed with him and I assisted them with the funds.
So you knew it was a company from outside?
That's what he told me.
Yes, so you knew that?
That's
From
according
what Brown
from
told
Brown.
you?
Well, from what Brown told me, yes,
Thank you.
I knew that.
Now, did Brown ever meet with you and Mr. Mamela?
No,
You say no. Because after your evidence yesterday, Mr. Mogotsi called us up and said he had in fact met with you and Mr. Mamela shortly after this tender. You have no recollection of that?
no,
You have no recollection or you deny that that meeting
I
happened?
did not meet with Mr. Maumela and Mr. Mukhosi.
Okay.
So you deny that such a meeting took place?
Yes,
Do you know who Alu Construction is? A-L-O-O.
no,
Can I take you to page 399? Maybe 398 is where to start. And the document on 398 is the preservation order that SARS obtained against Mr. Mamela. If you go down to 399, you see that the 11th respondent on that preservation order was Alu Construction.
yes, I see that.
Now, Alu Construction is alleged in this preservation application to be a company of Mr. Mamela. Were you aware of that?
No,
You weren't. Alu Construction was also one of the losing bidders in the Mediware tender that you funded, that was interdicted with your money. Were you aware of that?
no,
You see, Mr. Carrim, I find this quite difficult to believe because this interdict is an interdict that is funded over the period August and September. Well, let's go back to the dates. Your payments. Your first payment comes in on the 10th of August,
which document?
page 507. The 507, your first payment to Gotle is on the 10th of August, and your second payment is on the 19th of September.
Yes, I see that.
You see that. Now, your evidence yesterday was that over the period August to October 2023, you and Mr. Mamela were busy putting together a joint venture in a chrome mining operation. You recall that?
Yes,
And you'd already become friends because you purchased his house the previous year in 2022.
yes,
So, what you're saying to us today is that in August and September 2023, you put up funds to interdict the award of a tender to a party other than Mr. Mamela's company who had lost the tender. And you successfully interdicted that, or your funds successfully contributed to the interdicting of that award. You were engaged in a joint venture with Mr. Mamela at the same time, a 50 million rand joint venture about a chrome mine. You had become friends because he had sold the house to you. But you had no idea that this interdict that you were running in the Northwest just happened to assist his company, Alu Construction, to have another attempt at winning the tender. Is that your evidence?
yes.
I'm afraid I have to put it to you that that evidence is false.
No, sir, that's not what happened.
So Mr. Mamela never mentioned to you that in your backyard he was bidding for a contract with the Department of Health?
No, he didn't.
And you just weren't aware when you put up this money to fund the litigation that just happened to be of great assistance to Mr. Mamela, that you were helping out your good friend and current business partner? You weren't aware?
No.
I see. I'm going to move away from Mr. Mamela now, so if there are any questions that anybody wants to ask, well, then let me move. Can we go back now to discuss your arrangements with Mr. Matlala around the Medicare contract? You deal with them in your statement from paragraph sorry, if you can just bear with me for a minute.
Sorry, can we put file 2 away? We need to make some space here. It gets a bit...
Yes, we can. We might need to come back to. We might need to come back to file 2. I think about 10, 15 minutes. The version in your statement about your arrangement with Mr. Matlala was that this was, and it's in paragraphs 11 and 12 on page 3 of your statement. It was a relatively simple agreement. You advanced 10 million. You will be repaid. You'll get a return of an additional 10 million over the 3-year contract, and repayments will take the form of 10% of all payments. And you explain the monies that you advanced in respect of that agreement. That was the version in the statement. You said that you had no relationship with Mr. Matlala, or no commercial relationship with Mr. Matlala before, so you would contributed to the interdicting of that award. You were engaged in a joint venture with Mr. Mamela at the same time, a 50 million rand joint venture about a chrome mine. You had become friends because he had sold a house to you. But you had no idea that this interdict that you were running in the Northwest just happened to assist his company, Alu Construction, to have another attempt at winning the tender. Is that your evidence?
Yes.
I'm afraid I have to put it to you that that evidence is false.
No, sir, that's not what happened.
So Mr. Mamela never mentioned to you that in your backyard he was bidding for a contract with the Department of Health?
No, he didn't.
And you just weren't aware when you put up this money to fund the litigation that just happened to be of great assistance to Mr. Mamela, that you were helping out your good friend and current business partner? You weren't aware?
No.
I see. I'm going to move away from Mr. Mamela now, so if there are any questions that anybody wants to ask, well, then let me move. Can we go back now to discuss your arrangements with Mr. Matlala around the Medicare contract? You deal with them in your statement from paragraph sorry, if you can just bear with me for a minute.
Sorry, can we put file 2 away? We need to make some space here. It gets a bit...
Yes, we can. We might need to come back to. We might need to come back to file 2. I think about 10, 15 minutes. The version in your statement about your arrangement with Mr. Madlanga was that this was, and it's in paragraphs 11 and 12 on page 3 of your statement. It was a relatively simple agreement. You advanced 10 million. You will be repaid. You'll get a return of an additional 10 million over the 3-year contract, and repayments will take the form of 10% of all payments. And you explain the monies that you advanced in respect of that agreement. That was the version in the statement. You said that you had no relationship with Mr. Madlanga, or no commercial relationship with Mr. Madlanga before. So you were dealing with him in a commercial context for the very first time.
Yes.
Yes. And he made an unsolicited approach to you for the money.
And
An unsolicited approach to you. It's not that you approached him, he approached you.
he approached me, yes.
And on what? How did he introduce himself? How did he say he came to you?
I explained that yesterday, Council.
Yes. You just say he knew you from the security industry and he arrived up in a Rolls Royce.
No. I said he contacted one of my security personnel who's on the website and requested my number there.
Yes. So it was, he knew you from the security industry, which is how he
Yes.
at any rate said that he came to you. You took no security for your loan, the 10 million that you were lending. There was no security.
No.
No. You didn't conclude a written contract in respect of the loan. We've covered this yesterday. I'm just setting out the curious features of this. That was the version that we saw in the statement. But it turned out that the statement didn't describe the whole story because you amplified considerably in your evidence. Your first piece of amplification was that you explained that for a while Mr. Madlanga asked you for help with an accountant.
And that was much later into the contract, much later. It was around October.
October. So he asked you for help with an accountant to assist him with his business, and that was in October.
End of October, yeah.
Yes. But you didn't mention that in your statement.
Yeah, that was not in my statement. Yes.
Is there any reason why you didn't mention it?
No, there's no reason.
And you said that you had Mr. Mohammed sitting on a board committee of Medicare 2024 for a while to look after your interests.
It wasn't on the board. It was a finance committee.
A finance committee. So it wasn't the board itself. Was it a committee of the board or just an executive committee?
No, a finance committee looking at invoices going to SAPS.
So he was looking at invoices going to SAPS, and he was there to protect both of your interests in that regard.
Yes.
And we saw, but that was also not mentioned in the statement. Is there any reason you didn't mention it in the statement?
No reason.
No reason. And we saw Mr. Madlanga expressly asking you for help with invoicing when you'd already gone off to Cape Town for the January 8th celebrations. You recall that?
He was not asking for help with invoices. At that specific time, Mr. Madlanga needed more funding he wanted a meeting so that he could show me how much invoices are going in so that he could get a top-up. At that time, he was looking for an additional 10 million rand.
Now, let's look at that message, because I don't think that answer is consistent with the message. Go to page 2. His message to you is at 7:01:41. It's the green message on page 2. Salam, brother. Now is the time to start invoicing. Was wondering if I can see you before we send invoices. I can even come to your place. Please advise. He wanted to see you before he sent the invoices.
Correct. He wanted to show me what he's going to be submitting, how much invoices he's going to be submitting, and then show me that that's why he needed the additional funding, because we're going to have to wait for this money again, and he needed to service and pay more of his subcontractors.
But if that was all that he wanted to do, why did he need to see you, and why did he need to see you before he sent the invoices? Why didn't he just show you the invoices?
He needed to come because he asked me over the phone for the money. I said no. He said, so can I please come see you? Can I please come and show you what I need to do or what I'm going to be doing? This is what I'm doing. Can I come? He wanted a face-to-face meeting for that.
I can understand why he might have wanted a face-to-face meeting, but surely he'd have been in a better position on that face-to-face if he'd already sent invoices.
He wanted to show me. That's what he told me.
So you're saying he wasn't asking for help with invoices in this message?
Even when Mr. Mohammed sat on his committee, Mr. Mohammed was not in charge of assisting with the invoices, only to sit there and have a look and see what they're doing. We had absolutely no access to his invoicing, myself and Mr. Mohammed.
So what do you think Mr. Matlala was wanting to show you? Was he wanting to show you draft invoices?
He wanted to show me all the invoices, the amounts of all the invoices that he was going to submit.
And what did you expect to see?
Invoices.
Invoices that hadn't been sent.
I'm not sure if he had sent them or not sent them yet.
Well, he hadn't sent them because he says before we send invoices.
Sorry, Mr. Chaskazon. Mr. Carrim, this discussion about this additional loan that you say this is what this WhatsApp message was about, when did that discussion happen?
It started around December when he wanted more funding.
Okay. And you say it started in December and continued when? When before this WhatsApp message?
Yeah, he continued post this message as well. He was looking for more funding.
Yes. You see, I'm asking because on that page 2, you have an afternoon. You send him afternoon on the 30th of December, and the next thing that happens in the series of communication is that WhatsApp message on the 7th of January. So there's no intervening communication between the two of you that accords with the explanation you are giving now about this WhatsApp message. Do you understand what I'm saying?
No, I don't understand, Council.
You say, you explain this WhatsApp message of the 7th of January as being about him wanting to talk to you about a loan. And what I'm saying to you, what I'm not seeing is a trail of communication between the 30th of December, which was the last message from you in 2024, where you say afternoon, and the next message from him on the 7th of January. There's nothing in between the two communication or pieces of communication which accords with your explanation or your attempted explanation of the message of the 7th. I would have expected to see either missed telephone calls in between, and then you would then testify and say, well, in those telephone calls, he told me he wanted to come and talk about the 10 million rand. But we don't have that.
There's a call on the 30th.
Yes? What about it?
I'm saying there's a call on the 30th. There was a few calls. We spoke about this additional funding.
Yes.
And I see my messages only start from the 11th of December.
Yes.
But there's many calls prior to this, and I'm sure if we can get his records, and even when he comes here, I'm sure he'll be able to tell you that he really needed extra funding. He was looking for that 10 million to top up.
Yes. He may well have needed extra funding, and he may well have had that conversation with you, but your explanation of the WhatsApp of the 7th of January, that it was to talk about the funding, it doesn't accord with this series of communication on the 30th of December, and then you get a message that's very specific. He wants to speak to you to see you rather, before he sends invoices. That's what he says to you, and then you say, well, it was about funding. It had to do with the additional funding. I don't understand that explanation. At least it's not reflected in these communications.
He wanted to show me the invoices. We spoke about this. He wanted to show me and say, here's invoices. Let's discuss. I'm sending these invoices in. Can you, based on what I'm sending in, can you then top up so much or so much? Because here's the invoices going in.
Yes.
I assisted him in no way to submit any invoices.
My point exactly, that you know that he wanted to, he's telling you about seeing you before he sends invoices. You know that he wants to show you the invoices because he wants to back up a request for payment, a request for a further loan, but there's nothing in this correspondence that supports that. You are giving an explanation to a message of the 7th, which is not backed up by anything that is on the face of that message.
But that was what transpired. We didn't even meet after that.
But you accept that this message, on the face of it, it doesn't convey what you are saying. As I understand it, what you're conveying is he wanted to show you these invoices before he sends them off because he wanted to back up his request for funding, for further funding. That's what you're saying. Do you accept what I say to you? But this message itself, when you read this message together, especially together with your last message to him, there's nothing that backs up that explanation you are giving.
I'm sure when he comes here, he'll be able to back this up. Definitely.
Thank you.
If we go back to what actually happened in the operation of the contract, your evidence yesterday was, although the agreement was that you would get 10% of the income that you were entitled to when SAP started paying in September, you didn't take it because you let Mr. Matlala keep that because he had cash flow problems.
He wanted to recover his site establishment costs.
Yes, but in terms of your agreement with him, you were entitled to take 10%. You had put up 10 million and you were going to get paid back 10% of all revenue that the contract generated.
Yes.
And you elected essentially to waive that right.
We had a meeting, and in that meeting we agreed that we'll allow that one to pass. But there were other invoices that were paid which was not disclosed to me.
Other invoices that were paid when?
I'm not sure, but in between the periods where my people were removed from, or my person was removed. That's what I suspect. I don't have the proof of that, but that's my suspicion.
And have you managed to pin down those dates with better particularity as to when your people were there and when they weren't?
I've requested them. I should be getting those, and I will hand them over to you.
Thanks. If we move on, it says, when we move on, we see that when you finally start getting your payments, you agreed to act as a conduit for Mr. Matlala to pay Mr. Maumela a third of the first payment and a quarter of the gross second payment, which was in fact the same as 50% of the net second payment.
Council, I never said that yesterday. I was given two options by the commissioner yesterday, and I refused to accept that I was a conduit. There were two options given to me yesterday, and if we can go back to the transcripts, I had said I took the first option. I just need to go there and tell you what it was. But I didn't say that I was a conduit.
Well, we can see what the record says yesterday. Let's frame it this way. You agreed to take the payment that Mr. Matlala made to you of $1.5 million and to spend 500,000 of that paying Mr. Matlala's debt or loan to Mr. Maumela.
Yes.
Yes. And then when the second payment came in, you paid 250,000 of that to discharge Mr. Matlala's obligation or to advance a loan on his behalf to Mr. Maumela.
Yes.
Yeah. And these were not, this had nothing to do with your relationship with Mr. Maumela, it had to do with Mr. Matlala's relationship with
Yes.
Mr. Maumela. So essentially you took 750,000 of your money to pay to Mr. Maumela at the request of Mr. Matlala.
It was not my money. I was going to be replaced. It was not my money. He asked me, he said, I'm giving you this money and I'm going to top you up. I'm going to make good on it.
No, but either it was your money, in which case you weren't a conduit, or it was Mr. Matlala's money, in which case you were a conduit. Because if it was Mr. Matlala's money all along, then you were really acting as a conduit for Mr. Matlala to pay Mr. Maumela. If it was your money, then you have elected essentially to use your own money to pay Mr. Maumela because that's what Mr. Matlala wants you to do, and you will now have an additional claim against Mr. Matlala to claim that back.
Mr. Matlala asked me to pay that monies and said he'll replace those monies.
So, was it Mr. Matlala's money that you were paying to Mr. Maumela, or do you accept that it was your own money that you were paying to Mr. Maumela?
It was my own money.
So that was the version of how the contract operated when we had regard to your testimony and the statement, but it now seems that you didn't tell us the full extent of your payments. Because the documents that we discovered this morning show that on the 27th of June, there was a 1 million payment from Tasmika, another one of your companies. Oh, let's clarify, is Tasmika Construction one of your companies?
Yes.
And did Tasmika pay Medicare 1 million rands on the 27th of June, 1994?
Council, when we received
2024.
Sorry, 2024, okay.
When we received your documents this morning, for me, this was something, I was confused. Because I'd instructed my office to make payments from Ziggy Investments and Tamiz Investments. 5 million from Ziggy and 5 million from Tamiz. When I saw those payments, I then made a call to my office to find out, because the instruction I gave was 5 and 5. And I'm still saying 5 and 5. That payment of the SMICA, I need to go, that's why I asked for more time. I needed to go now and check in my office who actually authorized those payments. Because I've got 2 people in the office or 4 people in the office that deal with payments. I gave them an instruction, I said 5 and 5. At no point did I give them an instruction to pay from the SMICA.
So, are you now saying that that 1 million payment on the 27th of June 2024 was a payment made without your authorization?
I give them instructions, they have access to the bank, they process payments, and they send me.
I'm sorry to interrupt you, Mr. Carrim, but this is a very simple question. Did you or did you not authorize the payment of 1 million rands from Tasmika that was paid on 27 June 2024?
Not the SMICA, not the SMICA.
Did you authorize the payment of 1 million from anyone for payment on the 27th of June?
I give instructions, they authorize payments, they do the payments.
No. We're talking past each other. Did you instruct anybody to pay an additional 1 million rands to Medicare 24 on the 27th of June?
No.
So somebody inside your organization took it upon themselves to pay 1 million rands of your company's money without your knowledge or consent?
Yes, I'm confused. Hence, I said to my legal team that I need to get all of my office, I need to get the people in my office and find out exactly who authorized that payment, because my instructions were very clear. My investment was 10 million. When these payments came, I then tried to call them this morning. They're working remotely, but I need to find out who authorizes payment from my office and who made this payment from my office.
So who have you tried to call today to find this out?
I phoned my payments manager, Mr. Hein van Vuren.
And have you spoken to him today?
Well, I've tried to get hold of him on 2 or 3 occasions now, and we've been busy in here, so.
Well, you were told about these payments, or at any rate your attorneys were told about these payments sometime around about 6 o'clock this morning, and you were aware of them before we started. Had you tried to get hold of Mr.
Yes.
van Vuren before we started?
Yes, I've tried.
Then there was an adjournment to 11:45. Have you spoken to him since you first tried to get hold of him?
In consultation with my legal team, we said once we break here, we need to call them, once we break for lunch.
I see. So you still haven't spoken to Mr. van Vuren?
No, I've called, haven't spoken to him yet.
I see. Well, Chair, we are a couple of minutes before the lunch break. This might be a good opportunity to give Mr. Carrim the chance to call Mr. van Vuren.
Sorry, on this point, I'm just trying to understand, is this payment by Tasmika Construction part of the 10 million, or is it over and above the 10 million reflected in paragraph 12 of your statement?
I'd have to go and check, because my instructions to my office was 5 and 5. That was my agreement, 10 million and nothing more. So I need to get hold of Mr. van Vuren and Mr. Sayed, who are then in charge of payments in my office, and a certain lady by the name of Shakira, and find out who authorized this payment from Tasmika.
Yeah.
Can I just follow up, because I can clarify Commissioner Kumalo's question. If you go to page S3, 3 of your statement bundle.
Yeah. Yes.
There you will see how the 10 million that you refer to there is made up. It's 5 million from Ziggy on 26 June. It's 2.5 million from Tamiz on 7 July. It's 1.5 million from Tamiz on 15 July, and it's 1 million from Tamiz on 24 July. And in Annexure SC1, at the end of your statement, you provide bank statements that show each of these payments that you refer to in 12.1 to 12.3, and those payments add up to 10 million. So the payment of 1 million on the 27th of June was over and above the 10 million. Do you accept that?
It was only brought to my attention this morning.
No, I'm not debating whether you knew about it or not, but I'm asking you, do you accept that it was over and above the 10 million?
I'll have to go and do a recon and check, Council.
Maybe you can do that recon at lunch while you wait for Mr. van Vuren to get in touch. But look also at the 1.12 million payment on the 7th of October, because what you'll see when you do that recon is that what you paid to Medicare was not 10 million. It was 12.12 million.
Let us adjourn and resume at 2 p.m. Apologies for being 1 minute late. Last minute, the legal representatives, including the evidence leaders, wanted to see us.
Chair, are we just continuing at this stage, or are we going to sort out the closing time?
I think the housekeeping matter must be placed on record right away, perhaps.
Thank you, Chair. My attorney and the witness have made arrangements to go to Mecca and Medina. I believe they're traveling tomorrow. So they've asked for an indulgence if we can finish a little earlier to get their arrangements in order. And I think what was mooted was 2:45 or 3 o'clock, if the Commission will grant that indulgence.
Between 2:45 and 3 o'clock, would 3 o'clock work? Thank you.
3 o'clock.
Thank you. 3 o'clock is better. Mr. Shaskelson?
Chair, I'm in the Commission's hands. Whatever, I certainly don't want to interfere with.
Thank you. 3 o'clock it is then. Thank you very much. Yes, Mr. Shaskelson?
Thank you, Chair. Did you manage to get hold of Mr. Van Vuren? Is it Mr. Van Vuren?
Yes, Counsel.
And what were you able to establish?
They're going to look into it. They're looking into the matter. It was 2 years ago. I just got hold of him. Like I said, the offices are closed, but I said he needs to quickly get hold of the other person and try and see exactly who authorized that payment.
So, but you didn't authorize that payment?
No.
So what we have is a situation where over and above the 10 million that you instructed to be paid in accordance with your agreement with Medicare 24 Tswani, there was a payment of 1 million from Tasmika on the 27th of June 2024, and there was another payment of 1.12 million on the 7th of October 2024. Is that correct?
The second one is
1.12, 1,120,000. Is that correct?
Yes, those are the payments, yes.
Yes. So the total amount from your companies paid to Medicare 24 was in fact 12,120,000, not 10 million.
That's what I established now.
And your evidence is that you first became aware of the extra 2,120,000 from Tasmika today, when the Commission drew to your attention.
This morning when I woke up for my morning prayers, my attorney alerted me about this.
Right. So Does anybody other than you have authority to issue instructions for payments of 1 million and more out of Tasmika's account?
There isn't, but people have access.
No, there's a separate question. The people who have access, I understand you can process banking transactions, but does anyone have authority to issue the instruction? On behalf of Tasmika, you will pay 1 million.
Only I issue instructions.
Only you. So anybody who made this payment or these two payments without your knowledge was misappropriating money from Tasmika's account.
I'm now made aware of that, Council.
One good thing to come out of this commission for you is that you've been alerted to the fact that people have stolen 2.12 million from you.
I just had that discussion with my council now. I'd like to thank the commission for that.
But let me just understand this. Where would that person have gotten bank details to pay Medicare 24? I mean, they could only have got that from you, since they have not had any interaction with Mr. Madlanga. Somebody who paid from Tasmika's account into Medicare 24, this 2.1 million or 2.2 million.
Commissioner, when you have these accounts, it's a joint account. So those beneficiaries are shared amongst all those. So I assume that's where this problem came from.
Thank you.
Mr. Carrim, does it mean that you're not a nominated signatory to the Tasmika account?
Commissioner, I have about 10 accounts that I deal with. So most of these accounts, I give it to my office to deal with. I don't deal with payments because I'm mostly on the road and I don't have time to make payments. So I delegate these payments to a certain team in my office. I am the nominated person, but they have all the details. They have all the login details.
A nominated signatory to
Yes.
the account. Okay, thank you.
And do you receive payment notifications from that account?
With FNB, from time to time, you might get an email, you might get an SMS. It's not consistent. It either comes via an email or it either comes via an SMS.
But is it possible that a transaction for 1,120,000 might go off the Tasmika account without any notification to you?
Council, it's possible. Sometimes I'm on the mine, messages don't come through, there's no networks. It's quite deep into the rural area, so there is a possibility.
No, I understand that you might not get a contemporaneous message because the signal's down. But when you go back into the land of signal, that message ought to be delivered to you.
Yes, but at that time, remember, it's not only bank messages coming in. There'll be a lot of people trying to call you, so it's multiple of messages. I just don't look at them. I don't go to the messages.
I see. Now, Mr. Carrim, you certainly don't strike me as a sleepy businessman. Have you managed to lose 2 million in your bank accounts before? Has that ever happened to you before?
Council, these days, and I've been looking at a lot of the companies, there's a lot of siphoning going on. There's a lot of money being lost in accounts, a lot.
It's a separate question I'm asking. Has anyone ever made a payment of 1 million rands in one payment out of your account without your noticing?
No.
Not your knowledge, at any rate.
Not my knowledge, yes.
And, of course, no one's made a payment of 1.12 million rands out of your account without you seeing it.
Yes, and that also sounds like a very 1120 doesn't sound like a payment that I would instruct to make.
Yes, it's a payment that attracts attention. 1,120,000, is it not?
Correct.
Are you a director? What's an official relationship other than a shareholder? What other relationship do you have?
I'm the director.
You're a director. And the company does prepare financials. You would expect something like this to have been picked up by whoever prepares financial records?
Well, if they don't pick up, if it's not suspicion and went off the bank accounts, the accountants will continue and process with the payments because they would have thought I authorized. So accountants work off the bank statement and process according to the bank statement. They will not call me for every transaction.
So they would think you have authorized because you are the person with authority to authorize.
No. They would think that I gave the instruction for payment.
That's what I mean.
Yes.
You are the only person that gives instructions for
Yes.
payment. Thank you.
Yes, but they'd have to know how to enter it in the books. And if they went to the bank statement, they would see, let's look at page 555.
Can our learned friend perhaps just give us a description of the document? I'm sure we have it, because it's just not paginated.
Sorry, I apologize. Do we have, if we go to the June bank statement, have we not?
Are they this morning's documents?
This morning's documents, yes, but can I just clarify, because there was a set that should have been paginated and given to the commissioners and to the witness and to the witnesses' attorneys.
No.
We don't
This
have
morning's
a paginated
documents.
set.
Sorry.
Mr. Chaskalson, if I could just check, what you're referring to is the Tasmika construction
Yes.
statement.
Yes, I must apologize to my colleagues for this, because I'm told that the witness has a paginated file, the commissioners have a paginated file, but the witness's legal team does not. What we're referring to is the Tasmika, it's this morning's documents, it's the Tasmika construction statement for June. And if we go down to the 27th of June.
Have you managed to locate it, Mr. Banner?
We'll try and follow. Or can we just can we get one of your files and we'll just paginate it quickly?
Can we display?
What is the last page of your file 2? 544.
Does Medicare June 24? Is that the first one?
My colleague, Commissioner Baloi, is lending you hers.
Thank you.
Yes, please. Thank you.
So if we look at the bottom of the page, the only reference for that payment on the 27th of June is F&B app payment to loan. Now, whoever is preparing your accounts, if they're going to prepare the accounts, would need to know who the loan was made to or from. So there'd have to be, so the accountants ought to have asked a question, how do we book this 1 million? How do we describe the loan? Because it doesn't say Medicare 24.
Yes, correct. So,
So, sorry, Mr. Carrim, I thought you were about to say something.
no.
So ordinarily, what would happen when your accountant sees a payment of 1 million rands that just says payment to loan and it doesn't describe who that loan is to or from? Who do they ask?
They talk to the office. I've got a lady that captures on the instructions of Mr. Van Vieren.
So someone in the office would then have had to have looked at this 1 million payment to say, account for it this way.
Yes, Mr. Van Vieren would look at it and then instruct the capturer who captures these for accounting purposes and give them the reasons.
And how often are Tasmika's accounts prepared? Do you have 6 monthly accounts, annual accounts? I mean, obviously you're going to have a sort of working accounts, but do you prepare 6 monthly financial statements? Do you prepare annual financial statements?
Annual financial statements.
And Tasmika tenders for local government and provincial contracts, does it not?
Yes,
So it needs audited financial statements.
yes,
So auditors will then have to look at these accounts.
yes.
And an auditor, when is financial year end for Tasmika?
It should be Feb.
Feb. So this payment would have been financial year end February last year.
Yes,
And do you have audited financial statements for 2025 yet?
I'd have to check with the auditors and the
How long does it ordinarily take for your auditors to prepare audited financial statements?
I have 2 accountants or 3. I just need to check who's looking after this.
No, my question's slightly different. It's how long does it ordinarily take them to prepare audited financial statements? How long do you normally have to wait before you get your
A
financial
couple of
statements?
months. We have to
Couple of
wait a
months.
minute, yeah.
By mid-year, you should have financials for the previous February, shouldn't
I
you?
speak under correction, but yes, around my
So you would,
Do you mean from date of year end?
from date of year end. So by now, you ought to have audited financial statements for year end February 2025.
It was last year. Yeah, I'd have to check, yes.
We're 13 months down the line.
Yes, I presume, yes.
So these payments of 1 million on 27 June and 1,120,000 to loan on 7 October seem to have escaped the auditors as well.
Yes, we need to check. That's why I'm saying something doesn't look good here.
No, something certainly doesn't look good here.
Yes, so even for me, that's why I requested more time and postponement so that I could get to the bottom of this, because this is troubling me now. It's a lot of money, and between Mr. Van Vieren and the capturer, I need to find out what happened here.
It may not just be Mr. Van Vuren and the capturer, because these amounts were paid to Medicare 24. And certainly the October amount, the 1.12 million payment, was paid in a period where either Mr. Kerr or Mr. Mohammed would have had sight of payments into Medicare 24's account.
No, Council, they were not in. Mr. Khair was already removed at that time. Mr. Mohammed got in a bit later.
So this was just in a window between Mr. Kerr and Mr. Mohammed.
Yes.
Have you established what those dates are?
I will get them, and they will be sent to you by tonight.
I see. So this 1.12 million payment you believe to have been made in a window between their 2 periods of oversight of the Medicare 24 accounts.
Yes.
Now, as far as you're concerned, this is an unauthorized payment. It's just money misappropriated from Tasmika.
Yes, I didn't authorize these payments.
So what Medicare 24 owes you, in fact, is not 8.25 million, well, is not 18.25 million. It's actually more than 20 million, because it owes you another 2.12 million. Do you agree with that?
I think after we check and confirm from all these bank accounts, we'll then be able to determine the correct figure.
But as you stand today, your position is that Medicare, or before you were alerted to these payments, your position was that Medicare owed you the 8.25 that it hadn't paid you back, together with the 10 million that it was obliged to pay you over and above what you'd put in. So that was 18.25 was what Medicare owed you.
Correct.
And now it seems to be that there is another 2,120,000 that you paid Medicare and that ought to be paid back to you from Medicare.
From these bank statements, yes.
Before we leave these bank statements, can I ask you to go to the October bank statement? The bank statement of Medicare, not of Tasmika.
Now, what page is that, Councillor?
My page is 551. But it's the Medicare bank statement. Maybe let's start on the previous page, 550, where we will see the Tasmika payment. Do you see on 7th of October in the Medicare accounts, there is a payment of 1,120,000. That's the Tasmika payment at the foot of the page on 550.
550.
550, yes. I'm starting with the Tasmika payment.
Yes.
And then if you go to the next page, 551, 9th October, about 7 or 8 lines from the bottom, you'll see that there was a 3 million payment into Medicare, 3 million CR. You see that? F&B OB payment loan.
Yeah.
Do you know anything about that 3 million payment?
No, it's the first time I'm seeing this payment. I don't know about that payment.
And do you know anything, so as far as you're concerned, none of your companies have anything to do with that 3 million payment?
Sorry, our Leonard friend's going a bit quickly for us. 3 million payment on page?
It's page 551, 9th of October.
Thank you.
It's 8 from the bottom. So that payment of a 3 million loan into Medicare 24, you say you know nothing about?
No.
Have you ever made payments through a Hawala system in commercial dealings?
Excuse me, can you repeat that?
Hawala payments. Have you made payments through a Hawala system in commercial dealings?
No.
No. And to the best of your knowledge, if we investigate this payment, we won't find a trail back to any of your companies.
I guarantee you, Council.
Well, I don't think you can guarantee it to me because you've just told me 2.12 million went missing out of your accounts without your knowledge.
You said it came via an Havala system. I don't use Havala system.
Yes, but it seems that you don't, you can't speak with total authority about what goes in and out of your accounts.
True.
On any scenario, you went into proceedings, or you came to this commission a few days ago thinking that Medicare 24 owed you 18.25 million, plus interest, I would imagine.
No, I said 8.25.
Now, 8.25 is what you put in, but you were supposed to get a return of 10.
Yes, but once the contract was cancelled, I was just wanting to get my capital back.
Now, I know you probably would have been happy to walk away with your capital, but in terms of legal rights, if your agreement is what you say your agreement was, you were entitled to the 10 million over and above what you put in.
Yes.
Why haven't you sued Medicare 24?
So as soon as these things started happening towards around April, May, I had a meeting with my lawyers, and we then agreed that we needed to start the legal process of receiving my monies. We had these discussions around April. In May, we then agreed, yes, we are going to institute legal proceedings. And my attorneys I had briefed to continue to pursue and get my money back.
Sorry, that was April, May last year.
Yes, just before Mr. Madlanga got arrested.
Yes. And what has happened between April, May, and today?
I can get a brief from them and then revert to you with that. We can send you the correspondence.
And what is your claim going to be? How much are you claiming back?
I'm not sure what they agreed to claim back, but I'll check for you. We'll send it to you on an email so that you have it on record.
I see. When I suggested to you that 18.5 million was what Medicare 24 owed you, you said no, 18.25 million. You said no, it's just 8.25, I just want my money back. Had your attorneys not explained to you that you were entitled to the extra 10 million as well?
Yes, we discussed that, but I don't know what did they do, if they finalized on what they were going to claim back.
I see.
Can I just check something? Have you cancelled your agreement with Medicare 24? What became of that agreement?
Commissioner, remember, as I explained, once I received the SLA in October, to get Mr. Madlanga to sign that agreement was a bit of a uphill. He kept on saying, we'll sign. So the agreement with him was, once the SLA is out, we'll sign this funding agreement, and then we'll draw up another agreement. And he just never got to sign this funding agreement.
So are you saying there's no agreement between your company and Medicare 24? What's the legal position as we are sitting here today?
What we have is the proofs of payment that we paid him, and we have this funding agreement that was not signed.
But did you shake hands on it?
Yes, we had
So it's an oral agreement?
this verbal agreement. We shook hands, post come the funding agreement.
Thank you.
I just check, Mr. Carrim, the accountants of Ziggy and Tamiz, they haven't raised any issue about there being no record of these, record as in agreement, the source of these payments that are huge payments that have been made to Medicare. That's never been an issue with the accountants.
From my instruction to Mr. Hine, on the 5 million, I'm sure that is recorded in my books, yes. It is
Say
recorded.
that again, you say?
They are recorded. These loans are recorded.
Yeah, I'm asking a slightly different question, that you have a 5 million rand amount coming out of the Ziggy account, and there is no agreement, there's no written agreement that explains to an accountant why that money is being paid to Medicare. The same with Tamiz. You don't have a record that explains why that payment is being made to Medicare. Is that not an issue that your accountants would have raised with you?
No.
They did not. Not even the people who prepare your financial statements, not even those.
No, we brief them on, obviously they go through the bank statements. Mr. Hine will then brief them, this is a loan, that's a loan, this is going to this is an invoice payment. So he would brief them on what the transactions are.
Yeah, I'm asking a different question. Your auditors have never raised an issue about the absence of a written agreement that authorizes or that explains these payments. The auditors have not done that.
No.
Okay, thank you.
Can I just follow on with that? Because it seems to me that, I mean, Ziggy pays 5 million rands on loan to a company that is ostensibly at arm's length, Medicare 24. Presumably in the books of Ziggy, that amount of 5 million would be reflected as loan Medicare 24, because that's what it says on the bank statement.
Yes, I'm sure the accountants will be able to take and produce that.
But when the auditors come to audit Ziggy's financial accounts, surely they'll ask for an underlying loan agreement in respect of a loan as big as 5 million rands.
They didn't ask for one.
Again, we'd need to speak to those auditors. Who audits Ziggy's financials?
I think I've given you an email address. They're going to give you an email address.
Is it the same auditors for all companies,
Yes.
all of your companies?
Not all. I'll just check who they're handling, but they'll be able to tell you which companies they're looking after.
Thanks. And if they don't look after Ziggy, who do we speak to get an instruction as to who does audit Ziggy's books?
These ones look after Ziggy.
These ones audit Ziggy's books.
Sorry, one more thing. What's the position between Ziggy and Tamiz? Does Ziggy or does Tamiz owe 5 million to Ziggy or the other way around? What's the position? Because I understood from paragraph 12 of your statement that Tamiz made payments to Medicare on behalf of Ziggy.
So
Is there an underlying agreement?
there's internal loan agreements, yes.
Thank you, Mr. Chaskos.
I want to wait until we get the explanations from Mr. Van Vuren and your follow-up explanation in relation to these payments before I close off this topic. But I will come back to it once we've seen that. And I do, for now, I need to put to you a series of concerns that I have about this agreement between yourself and between Ziggy and Medicare 24. You just need to hear them. I'll ask you for comment later when we see you again. But in fairness to you, you need to know my concerns, which may well also be reflected among some of the commissioners. My first concern is my first concern is with the numbers. There is your version in the statement is a loan of 10 million. It turns out that there were payments of 12.12 million. We need an explanation for where the extra 2.12 million comes from. My second concern is that even on the version on the statement, what you have is a loan of 10 million to a relative stranger without any security, which seems commercially odd to me, to say the least. My second concern is that this loan to a relative stranger without security is not just without security, it's without a written contract. That also seems commercially odd to me. My third concern is that for a party whose stated relationship to Medicare 24 is that of simply lender, it does seem to me that Ziggy or yourself or your companies or your group generally performed a role much more akin to a partnering investor than a lender. You provided accounting support. You had a representative on a finance committee. You agreed to forego your rights on your loan when the money first started to flow in September. You agreed when you were finally paid to pay what seems to have been a debt of Mr. Matlala out of the monies paid to you. So you agreed to pay a total of 750,000 of the 2.5 million that you were paid. 750,000 of that you paid on to Mr. Mamela. All of these elements concern me, and they, in my view, cast doubt on the correctness or the truth of your version of a loan. And what I want to put to you is what it looks like to me. It looks much more like you were an investing partner in this contract, and that you were an investing partner together with Mr. Mamela, and that while you were in business with Mr. Mamela in relation to a Chrome project, while you were funding an interdict that served to protect Mr. Mamela's company, you might also have been investing with Mr. Mamela in this contract. Because Mr. Mamela keeps on getting screenshots of your communications with Mr. Matlala. Mr. Mamela gets paid out of your payments from Mr. Matlala. So those are my concerns, and I think that's what you need to address when you come back. There are two further topics that I could address with you today. Let me first ask you, just get some clarity about, which relates to the Mr. Mamela relationship. You spoke about the origins of your relationship with Mr. Mamela in the house sale, and that you then went into this joint business in relation to a chrome mining operation. You mentioned that you were each going to put in 55 million, and that to raise his 55 million, he had to sell an asset, and he sold it. And you said you got notified that the money had been transferred to the lawyer's trust account from the sale of the asset, and you said you were overjoyed because now you could start the project. When were you notified that the money went into the lawyer's trust account? Approximately when was this?
Sometime in December 23, November.
November, December. And then you say, subsequent to me receiving the funds, Mamela approached you and told you, subsequent to you receiving the funds, Mamela approached you and told you that he's got challenges with his current house, he's paying penalties, he's losing $1 million a month on penalties, so could he please take some of his money and complete his house, then he'd bring back the funds so he could continue with the project. How long was that after you had received the funds?
It was immediately. It was, you mean when did he approach me?
Yes, when did he approach you? You get the funds, you've now got the money in Ziggy.
Yes, that same day he approached me.
The same day he approached you?
Yeah.
So when were the funds paid out? So were the funds in Ziggy for more than a day?
The funds were there for a couple of hours, and that's exactly what my problem was with him. And that's exactly where I had an issue. As I said to him, I've already committed. You cannot backtrack on this. We had a gentleman's agreement. Paperwork is to follow. I've made commitments. People are waiting. This is not acceptable.
But within a couple of hours, you'd paid him the money.
I had to pay him the money. It's his money.
Well, it wasn't actually his money. It was money that he had committed to a joint project with you. So you had a contract with him that he had to put up 55 million.
Yes, a verbal contract.
You had to put up 55 million.
Yes.
And that 110 million was now going to be used for some mining project.
Yes.
But you agreed immediately he put up the 55 million. that, or I think you said it was 56, that he could take his money back.
Mr. Shackleton, if someone comes to you and you're holding that kind of money of theirs and they're sitting in front of you and he says, I'll bring back the money, I want my money back. I had no choice. I said, it's fine. What time frames are we looking at? When will you bring this money back? He said, he's busy with a disposal of another asset. He'll come back to me, but for now he needs to finish his house.
You see, again, one of the things that strikes me as odd about this arrangement is that he sells an asset. The money gets paid into trust at his lawyers. He can instruct those lawyers what to do with that money. He can instruct those lawyers to pay you, or he can instruct those lawyers to pay him. If he wanted the money back, why would he instruct the lawyers to pay you for you to pay the money to him? Why wouldn't he just instruct the lawyers pay me directly?
We'll have to ask him, because the instruction was to pay to me based on the agreement we had on this mining operation.
So he gave you an instruction based on a contract. Well, he gave his attorneys an instruction based on a contract with you. He had a contract with you to pay 55 or 56 million. He told his attorneys, pay 56 million, and no sooner had the 56 million landed than he said, pay me, what was it, 35 million?
No, he requested 40 million at that time.
Sorry, he requested?
40.
40. Again, the arrangement strikes me as concerning, and it strikes me as particularly concerning because it happens 10 days before a preservation order is issued against him by SARS, and at a time when he must have known that SARS were coming after him. Did it not strike you as funny that the money came to you, and then as soon as it came to you, the person who had effectively directed that it be paid to you said, pay it to me?
No, because he committed, and remember, I still had a balance of the money left over with me. He didn't take all his money.
I appreciate that, but he took 35 million out of 56 million.
Yes, he did.
I have another substantive topic to address now, but we're not going to finish before 3 o'clock. So I'd rather get to it when we resume.
Were dates agreed?
What we have at the moment, we just need to find out when. Chair, might I ask if we stand down for a couple of minutes just to find out when Mr. Carrim and his attorney return to South Africa and what dates are available thereafter?
We'll adjourn and we'll come back when it's indicated that we should. The legal representative who's traveling and Mr. Carrim are excused. Yes, Mr. Chaselson.
Chair, we've agreed on the 16th of April.
Mr. Carrim, the hearing of your testimony will be resumed on 16 April 2026. So you must be here on that day. Let us adjourn and resume at 9:30 tomorrow.
Thank you, Chair.
Let's adjourn.
Mecca and Medina, I believe they're traveling tomorrow. So they've asked for an indulgence if we can finish a little earlier to get those quarters.
Thank you.
Chair, I'm in the Commission's hands. Whatever, I certainly don't want to interfere with.
Thank you. 3 o'clock it is then. Thank you very much. Yes, Mr. Chaselson.
Thank you, Chair. Did you manage to get hold of Mr. Van Vuren? Is it Mr. Van Vuren?
Yes, Council.
And what were you able to establish?
They're going to look into it. They're looking into the matter. It was 2 years ago. I just got hold of him. Like I said, the offices are closed, but I said he needs to quickly get hold of the other person and try and see exactly who authorized that payment.
So, but you didn't authorize that payment?
No.
So what we have is a situation where over and above the 10 million that you instructed to be paid in accordance with your agreement with Medicare 24 Tswani, there was a payment of 1 million from Tasmika on the 27th of June 2024, and there was another payment of 1.12 million on the 7th of October 2024. Is that correct?
The second one is 1.12.
1,120,000. Is that correct?
Yes, those are the payments, yes.
Yes. So the total amount from your companies paid to Medicare 24 was in fact 12,120,000, not 10 million.
That's what I established now.
And your evidence is that you first became aware of the extra 2,120,000 from Tasmika today, when the Commission drew to your attention.
This morning when I woke up from my morning prayers, my attorney alerted me about this.
Right. So, does anybody other than you have authority to issue instructions for payments of 1 million and more out of Tasmika's account?
There isn't, but people have access.
No, there's a separate question. The people who have access, I understand you can process banking transactions, but does anyone have authority to issue the instruction? On behalf of Tasmika, you will pay 1 million.
Only I issue instructions.
Only you. So anybody who made this payment or these two payments without your knowledge was misappropriating money from Tasmika's account.
I'm now made aware of that, Council.
So, one good thing to come out of this commission for you is that you've been alerted to the fact that people have stolen 2.12 million from you.
I just had that discussion with my counsel now. I'd like to thank the Commission for that.
But let me just understand this. Where would that person have gotten bank details to pay Medicare 24? I mean, they could only have got that from you. since they have not had any interaction with Mr. Matlala. Somebody who paid from Tasmika's account into Medicare 24, this 2.1 million or 2.2 million.
Commissioner, when you have these accounts, it's a joint account. So those beneficiaries are shared amongst all those. So I assume that's where this problem came from.
Thank you.
Mr. Carrim, does it mean that you're not a nominated signatory to the Tasmika account?
Commissioner, I have about 10 accounts that I deal with. So most of these accounts, I give it to my office to deal with. I don't deal with payments because I'm mostly on the road and I don't have time to make payments. So I delegate these payments to a certain team in my office. I am the nominated person, but they have all the details. They have all the login details.
You are a nominated signatory to
Yes.
the account. Okay, thank you.
And do you receive payment notifications from that account?
With FNB, from time to time, you might get an email, you might get an SMS. It's not consistent. It either comes via an email or it either comes via an SMS.
But is it possible that a transaction for 1,120,000 might go off the Tasmika account without any notification to you?
Counsel, it's possible. Sometimes I'm on the mine, messages don't come through, there's no networks. It's quite deep into the rural area, so there is a possibility.
No, I understand that you might not get a contemporaneous message because the signal's down. But when you go back into the land of signal, that message ought to be delivered to you.
Yes, but at that time, remember, it's not only bank messages coming in. There'll be a lot of people trying to call you, so it's multiple of messages. I just don't look at them. I don't go to the messages.
I see. Now, Mr. Carrim, you certainly don't strike me as a sleepy businessman. Have you managed to lose 2 million in your bank accounts before? Has that ever happened to you before?
Counsel, these days, and I've been looking at a lot of the companies, there's a lot of siphoning going on. There's a lot of money being lost in accounts, a lot.
It's a separate question I'm asking. Has anyone ever made a payment of 1 million rands in one payment out of your account without your noticing?
No,
Not your knowledge, at any rate.
not my knowledge, yes.
And, of course, no one's made a payment of 1.12 million rands out of your account without you seeing it.
Yes, and that also sounds like a very, 1120 doesn't sound like a payment that I would instruct to make.
Yes, it's a payment that attracts attention. 1,120,000, is it not?
Correct.
Are you a director? What's an official relationship other than a shareholder? What other relationship do you have?
I'm the director.
You're a director. And the company does prepare financials. You would expect something like this to have been picked up by whoever prepares financial records?
Well, if they don't pick up, if it's not suspicion and went off the bank accounts, the accountants will continue and process with the payments because they would have thought I authorized. So accountants work off the bank statement and process according to the bank statement. They will not call me for every transaction.
So they would think you have authorized because you are the person with authority to authorize.
No. They would think that I gave the instruction for payment.
That's what I mean.
Yes.
You are the only person that gives instructions for
Yes.
payment. Thank you.
Yes, but they'd have to know how to enter it in the books. And if they went to the bank statement, they would see, let's look at page 555.
Can our learned friend perhaps just give us a description of the document? I'm sure we have it because it's just not paginated.
Sorry, I apologize. Do we have, if we go to the June bank statement, Have we not?
Are they this morning's documents?
This morning's documents, yes, but can I just clarify, because there was a set that should have been paginated and given to the commissioners and to the witness and to the witnesses' attorneys.
No.
We don't
This
have
morning's
the
documents.
set.
Sorry.
Mr. Chairperson, if I could just check, what you're referring to is the Tasmika construction
Yes.
statement.
Yes, I
have
must
it.
apologize to my colleagues for this, because I'm told that the witness has a paginated file, the commissioners have a paginated file, but the witness's legal team does not. What we're referring to is the Tasmika, it's this morning's documents, it's the Tasmika construction statement for June. And if we go down to the 27th of June,
Have you managed to locate it, Mr. Banner?
We'll try and follow. Or can we just can we get one of your files and we'll just paginate it quickly?
can we display?
What is the last page of your file 2? 544.
Does Medicare June 24? Is that the first one?
My colleague, Commissioner Baloi, is lending you hers.
Thank you.
Yes. Thank you.
So if we look at the bottom of the page, the only reference for that payment on the 27th of June is F&B app payment to loan. Now, whoever is preparing your accounts, if they're going to prepare the accounts, would need to know who the loan was made to or from. So there'd have to be, so the accountants ought to have asked a question, how do we book this 1 million? How do we describe the loan? Because it doesn't say Medicare 24.
Yes, correct. So, okay.
So, sorry, Mr. Carrim, I thought you were about to say something.
No.
So ordinarily, what would happen when your accountant sees a payment of 1 million rands that just says payment to loan and it doesn't describe who that loan is to or from? Who do they ask?
They talk to the office. I've got a lady that captures on the instructions of Mr. Van Vieren.
So someone in the office would then have had to have looked at this 1 million payment to say, account for it this way.
Yes, Mr. Van Vieren would look at it and then instruct the capturer who captures these for accounting purposes and give them the reasons.
And how often are Tasmika's accounts prepared? Do you have 6 monthly accounts, annual accounts? I mean, obviously you're going to have a sort of working accounts, but do you prepare 6 monthly financial statements? Do you prepare annual financial statements?
Annual financial statements.
And Tasmika tenders for local government and provincial contracts, does it not?
Yes,
So it needs audited financial statements.
yes,
So auditors will then have to look at these accounts.
yes.
And an auditor, when is financial year end for Tasmika?
Should be Feb.
Feb. So this payment would have been financial year end February last year.
Yes,
And do you have audited financial statements for 2025 yet?
I'd have to check with the auditors in the.
How long does it ordinarily take for your auditors to prepare audited financial statements?
I have 2 accountants or 3. I just need to check who's looking after this.
No, my question's slightly different. It's how long does it ordinarily take them to prepare audited financial statements? How long do you normally have to wait before you get your financial statements?
A
Couple of months.
Yeah.
By mid-year, you should have financials for the previous February, shouldn't
I
you?
speak under correction, but yes, around my
So you would,
Do you mean from date of year end?
from date of year end. So by now, you ought to have audited financial statements for year end February 2025.
That was last year. Yeah, I'd have to check, yes.
We're 13 months down the line.
Yes, I presume, yes.
So these payments of 1 million on 27 June and 1,120,000 to loan on 7 October seem to have escaped the auditors as well.
Yes, we need to check. That's why I'm saying something doesn't look good here.
No, something certainly doesn't look good here.
Yes, so even for me, that's why I requested more time and a postponement so that I could get to the bottom of this, because this is troubling me now. It's a lot of money, and between Mr. Van Vieren and the capturer, I need to find out what happened here.
It may not just be Mr. Van Vuren and the capturer, because these amounts were paid to Medicare 24. And certainly the October amount, the 1.12 million payment, was paid in a period where either Mr. Kerr or Mr. Mohammed would have had sight of payments into Medicare 24's account.
No, Council, they were not in. Mr. Khair was already removed at that time. Mr. Mohammed got in a bit later.
So this was just in a window between Mr. Kerr and Mr. Mohammed.
Yes.
Have you established what those dates are?
I will get them, and they will be sent to you by tonight.
I see. So this 1.12 million payment you believe to have been made in a window between their 2 periods of oversight of the Medicare 24 accounts.
Yes.
Now, as far as you're concerned, this is an unauthorized payment. It's just money misappropriated from Tasmika.
Yes, I didn't authorize these payments.
So what Medicare 24 owes you, in fact, is not 8.25 million, well, is not 18.25 million. It's actually more than 20 million, because it owes you another 2.12 million. Do you agree with that?
I think after we check and confirm from all these bank accounts, we'll then be able to determine the correct figure.
But as you stand today, your position is that Medicare, or before you were alerted to these payments, your position was that Medicare owed you the 8.25 that it hadn't paid you back, together with the 10 million that it was obliged to pay you over and above what you'd put in. So that was 18.25 was what Medicare owed you.
Correct.
And now it seems to be that there is another 2,120,000 that you paid Medicare and that ought to be paid back to you from Medicare.
From these bank statements, yes.
Before we leave these bank statements, can I ask you to go to the October bank statement? The bank statement of Medicare, not of Tasmika.
Now, what page is that, Council?
My page is 551. But it's the Medicare bank statement. Maybe let's start on the previous page, 550, where we will see the Tasmika payment. Do you see on 7th of October in the Medicare accounts, there is a payment of 1,120,000. That's the Tasmika payment at the foot of the page on 550.
550.
550, yes. I'm starting with the Tasmika payment.
Yes.
And then if you go to the next page, 551, 9th October, about 7 or 8 lines from the bottom, you'll see that there was a 3 million payment into Medicare, 3 million CR. You see that? F&B OB payment loan.
Yeah.
Do you know anything about that 3 million payment?
No, it's the first time I'm seeing this payment. I don't know about that payment.
And do you know anything, so as far as you're concerned, none of your companies have anything to do with that 3 million payment?
Sorry, our Leonard friend's going a bit quickly for us. 3 million payment on page.
It's page 551, 9th of October. So,
Thank you.
it's 8 from the bottom. So that payment of a 3 million loan into Medicare 24, you say you know nothing about.
No.
Have you ever made payments through a Hawala system in commercial dealings?
Excuse me, can you repeat that?
Hawala payments. Have you made payments through a Hawala system in commercial dealings?
No.
No. And to the best of your knowledge, if we investigate this payment, we won't find a trail back to any of your companies.
I guarantee you, Council.
Well, I don't think you can guarantee it to me because you've just told me 2.12 million went missing out of your accounts without your knowledge.
You said it came via an Havala system. I don't use Havala system.
Yes, but it seems that you don't, you can't speak with total authority about what goes in and out of your accounts.
True.
On any scenario, you went into proceedings, or you came to this commission a few days ago thinking that Medicare 24 owed you 18.25 million, plus interest, I would imagine.
No, I said 8.25.
Now, 8.25 is what you put in, but you were supposed to get a return of 10.
Yes, but once the contract was cancelled, I was just wanting to get my capital back.
Now, I know you probably would have been happy to walk away with your capital, but in terms of legal rights, if your agreement is what you say your agreement was, you were entitled to the 10 million over and above what you put in.
Yes.
Why haven't you sued Medicare 24?
So as soon as these things started happening towards around April, May, I had a meeting with my lawyers, and we then agreed that we needed to start the legal process of receiving my monies. We had these discussions around April. In May, we then agreed, yes, we are going to institute legal proceedings. And my attorneys I had briefed to continue to pursue and get my money back.
Sorry, that was April, May last year.
Yes, just before Mr. Madlanga got arrested.
Yes. And what has happened between April, May, and today?
I can get a brief from them and then revert to you with that. We can send you the correspondence.
And what is your claim going to be? How much are you claiming back?
I'm not sure what they agreed to claim back, but I'll check for you. We'll send it to you on an email so that you have it on record.
I see. When I suggested to you that 18.5 million was what Medicare 24 owed you, you said no, 18.25 million. You said no, it's just 8.25, I just want my money back. Had your attorneys not explained to you that you were entitled to the extra 10 million as well?
Yes, we discussed that, but I don't know what did they do, if they finalized on what they were going to claim back.
I see.
Can I just check something? Have you cancelled your agreement with Medicare 24? What became of that agreement?
Commissioner, remember, as I explained, once I received the SLA in October, to get Mr. Matlala to sign that agreement was a bit of a uphill. He kept on saying, we'll sign. So the agreement with him was, once the SLA is out, we'll sign this funding agreement, and then we'll draw up another agreement. And he just never got to sign this funding agreement.
So are you saying there's no agreement between your company and Medicare 24? What's the legal position as we are sitting here today?
What we have is the proofs of payment that we paid him, and we have this funding agreement that was not signed.
But did you shake hands on it?
Yes, we had
So it's an oral agreement?
this verbal agreement. We shook hands, post come the funding agreement.
Thank you.
I just check, Mr. Carrim, the accountants of Ziggy and Tamiz, they haven't raised any issue about there being no record of these, record as in agreement, the source of these payments that are huge payments that have been made to Medicare. That's never been an issue with the accountants.
From my instruction to Mr. Hine, on the 5 million, I'm sure that is recorded in my books, yes. It is
Say
recorded.
that again, you say?
They are recorded. These loans are recorded.
Yeah, I'm asking a slightly different question, that you have a 5 million rand amount coming out of the Ziggy account, and there is no agreement, there's no written agreement that explains to an accountant why that money is being paid to Medicare. The same with Tamiz. You don't have a record that explains why that payment is being made to Medicare. Is that not an issue that your accountants would have raised with you?
No.
They did not. Not even the people who prepare your financial statements, not even those.
No, we brief them on, obviously they go through the bank statements. Mr. Hine will then brief them, this is a loan, that's a loan, this is going to this is an invoice payment. So he would brief them on what the transactions are.
Yeah, I'm asking a different question. Your auditors have never raised an issue about the absence of a written agreement that authorizes or that explains these payments. The auditors have not done that.
No.
Okay, thank you.
Can I just follow on with that? Because it seems to me that, I mean, Ziggy pays 5 million rands on loan to a company that is ostensibly at arm's length, Medicare 24. Presumably in the books of Ziggy, that amount of 5 million would be reflected as loan Medicare 24, because that's what it says on the bank statement.
Yes, I'm sure the accountants will be able to take and produce that.
But when the auditors come to audit Ziggy's financial accounts, surely they'll ask for an underlying loan agreement in respect of a loan as big as 5 million rands.
They didn't ask for one.
Again, we'd need to speak to those auditors. Who audits Ziggy's financials?
I think I've given you an email address. They're going to give you an email address.
Is it the same auditors for all all companies, all of your companies?
Not all. I'll just check who they're handling, but they'll be able to tell you which companies they're looking after.
Thanks. And if they don't look after Ziggy, who do we speak to get an instruction as to who does audit Ziggy's books?
These ones look after Ziggy.
These ones audit Ziggy's books.
Sorry, one more thing. What's the position between Ziggy and Tamiz? Does Ziggy or does Tamiz owe 5 million to Ziggy or the other way around? What's the position? Because I understood from paragraph 12 of your statement that Tamiz made payments to Medicare on behalf of Ziggy.
So
is there an underlying agreement?
there's internal loan agreements, yes.
Thank you, Mr. Chaskos.
I want to wait until we get the explanations from Mr. Van Vuren and your follow-up explanation in relation to these payments before I close off this topic. But I will come back to it once we've seen that. And I do, for now, I need to put to you a series of concerns that I have about this agreement between yourself and between Ziggy and Medicare 24. You just need to hear them. I'll ask you for comment later when we see you again. But in fairness to you, you need to know my concerns, which may well also be reflected by among some of the commissioners. My first concern is my first concern is with the numbers. There is your version in the statement is a loan of 10 million. It turns out that there were payments of 12.12 million. We need an explanation for where the extra 2.12 million comes from. My second concern is that even on the version on the statement, what you have is a loan of 10 million to a relative stranger without any security, which seems commercially odd to me, to say the least. My second concern is that this loan to a relative stranger without security is not just without security, it's without a written contract. That also seems commercially odd to me. My third concern is that for a party whose stated relationship to Medicare 24 is that of simply lender, it does seem to me that Ziggy or yourself or your companies or your group generally performed a role much more akin to a partnering investor than a lender. You provided accounting support. You had a representative on a finance committee. You agreed to forego your rights on your loan when the money first started to flow in September. You agreed when you were finally paid to pay what seems to have been a debt of Mr. Matlala out of the monies paid to you. So you agreed to pay a total of 750,000 of the 2.5 million that you were paid. 750,000 of that you paid on to Mr. Mamela. All of these elements concern me, and they, in my view, cast doubt on the correctness or the truth of your version of a loan. And what I want to put to you is what it looks like to me. It looks much more like you were an investing partner in this contract, and that you were an investing partner together with Mr. Mamela, and that while you were in business with Mr. Mamela in relation to a Chrome project, while you were funding an interdict that served to protect Mr. Mamela's company. You might also have been investing with Mr. Mamela in this contract, because Mr. Mamela keeps on getting screenshots of your communications with Mr. Matlala. Mr. Mamela gets paid out of your payments from Mr. Matlala. So those are my concerns, and I think that's what you need to address when you come back. There are two further topics that I could address with you today. Let me first ask you, just get some clarity about, which relates to the Mr. Mamela relationship. You spoke about the origins of your relationship with Mr. Mamela in the house sale, and that you then went into this joint business in relation to a chrome mining operation. You mentioned that you were each going to put in 55 million, and that to raise his 55 million, he had to sell an asset, and he sold it. And you said you got notified that the money had been transferred to the lawyer's trust account from the sale of the asset, and you said you were overjoyed because now you could start the project. When were you notified that the money went into the lawyer's trust account? Approximately when was this?
Sometime in December 23, November.
November, December. And then you say, subsequent to me receiving the funds, Mamela approached you and told you, subsequent to you receiving the funds, Mamela approached you and told you that he's got challenges with his current house, he's paying penalties, he's losing $1 million a month on penalties, so could he please take some of his money and complete his house, then he'd bring back the funds so he could continue with the project. How long was that after you had received the funds?
It was immediately. It was, you mean when did he approach me?
Yes, when did he approach you? You get the funds, you've now got the money in Ziggy.
Yes, that same day he approached me.
The same day he approached you?
Yeah.
So when were the funds paid out? So were the funds in Ziggy for more than a day?
The funds were there for a couple of hours, and that's exactly what my problem was with him. And that's exactly where I had an issue. So I said to him, I've already committed. You cannot backtrack on this. We had a gentleman's agreement. Paperwork is to follow. I've made commitments. People are waiting. This is not acceptable.
But within a couple of hours, you'd paid him the money.
I had to pay him the money. It's his money.
Well, it wasn't actually his money. It was money that he had committed to a joint project with you. So you had a contract with him that he had to put up 55 million.
Yes, a verbal contract.
You had to put up 55 million.
Yes.
And that 110 million was now going to be used for some mining project.
Yes.
But you agreed immediately he put up the 55 million. Or I think you said it was 56, that he could take his money back.
Mr. Shackleton, if someone comes to you and you're holding that kind of money of theirs and they're sitting in front of you and he says, I'll bring back the money, I want my money back. I had no choice. I said, it's fine. What time frames are we looking at? When will you bring this money back? He said he's busy with a disposal of another asset. He'll come back to me, but for now he needs to finish his house.
You see, again, one of the things that strikes me as odd about this arrangement is that he sells an asset. The money gets paid into trust at his lawyers. He can instruct those lawyers what to do with that money. He can instruct those lawyers to pay you, or he can instruct those lawyers to pay him. If he wanted the money back, why would he instruct the lawyers to pay you for you to pay the money to him? Why wouldn't he just instruct the lawyers pay me directly?
We'll have to ask him, because the instruction was to pay to me based on the agreement we had on this mining operation.
So he gave you an instruction based on a contract. Well, he gave his attorneys an instruction based on a contract with you. He had a contract with you to pay 55 or 56 million. He told his attorneys, pay 56 million, and no sooner had the 56 million landed than he said, pay me, what was it, 35 million?
No, he requested 40 million at that time.
Sorry, he requested?
40.
40. Again, the arrangement strikes me as concerning, and it strikes me as particularly concerning because it happens 10 days before a preservation order is issued against him by SARS, and at a time when he must have known that SARS were coming after him. Did it not strike you as funny that the money came to you, and then as soon as it came to you, the person who had effectively directed that it be paid to you said, pay it to me?
No, because he committed, and remember, I still had a balance of the money left over with me. He didn't take all his money.
I appreciate that, but he took 35 million out of 56 million.
Yes, he did.
I have another substantive topic to address now, but we're not going to finish before 3 o'clock. So I'd rather get to it when we resume.
Were dates agreed?
What we have at the moment, we just need to find out when. Chair, might I ask if we stand down for a couple of minutes just to find out when Mr. Carrim and his attorney return to South Africa and what dates are available thereafter?
We'll adjourn and we'll come back when it's indicated that we should. The legal representative who's traveling and Mr. Carrim are excused. Yes, Mr. Chairperson.
Chair, we've agreed on the 16th of April.
Mr. Carrim, the hearing of your testimony will be resumed on 16 April 2026. So you must be here on that day. Let us adjourn and resume at 9:30 tomorrow.
Thank you, Chair.
Let's adjourn. during the break, it was brought to our attention that there was an altercation inside the auditorium. It has also since been brought to our attention that this is now all over television. For the record, I think in the light of the broadcast, I should bring it to the public that we called all the legal representatives outside, and we were briefly advised as to what had taken place. But most importantly, Mr. Premhid tendered an unequivocal apology to the Commission Secretary, which the Commission Secretary accepted. I think we should leave it there. Thank you all. Mr. Shaskalsin?
Thank you, Chair. If we're going to go on record, I should also...
Yes, Mr. Bana.
Are we simply going on record because there's something that we want to deal with once we're all on record?
Oh, I forgot because there's now an additional counsel. I think there is a need for the formality for you, Mr. Bana, to place yourself on record.
Yes.
Yes.
I am Rafiq Bana, Chair, and I appear with my legal team who will be introduced previously, Mr. Camille Premid and Brandon Casey on behalf of the witness, instructed by Mr. Teo.
Thank you, thank you. Was there an issue you wish to raise?
Yes, I'm not sure what Mr. Chaskelson wanted to deal with. Perhaps he could just deal with what he needed.
Or just a minute. Commissioner Baloyi is saying she got the sense that Mr. Shaskalsin wanted to say something about...
No, Chair, if things are going to be said publicly, I need to place on record that I behaved rudely to the legal team of Mr. Carrim before that altercation, and I apologize for that.
Thank you very much for the apology. Is it accepted?
Yes, we have no issue with accepting.
Thank you. Thank you very much. And thanks, Commissioner Baloyi, for bringing that to my attention. Yes, Mr. Bana.
Thank you, Chair. Chair, I just want to place on record two matters. The first deals with documents that we have been drip-fed since Friday and over the weekend. You will recall, and I was not involved, on the 6th of February, the postponement was caused by late documents that were handed to Mr. Karim's legal team by the Commission's evidence leaders. Following upon that, we received documents on Friday in terms of the directive, and I'll deal with why those documents should not have been produced earlier. In terms of...
Mr. Bana, may I just raise this? We've seen the correspondence, and may I just find out from Mr. Shaskalsin if he will be referring to or relying on the documents that were served after the postponement, not the supplementary bundle that was to be served on the 6th. The other documents, will you be using those today? Because what I have in mind, so as to save time, because a lot of time has been lost already, what I have in mind is whether it's possible for you to only use that documentation tomorrow and not today.
Chair, if we're talking about the documents, there was one written page and an electronic spreadsheet, which is the underlying source material for a document already in the bundle. I don't intend to refer to either of those today. There was as well, so there were the Friday documents, and then there were 6 pages.
I wanted to refer to the 6 pages because I saw reference to 6 pages.
The 6 pages I will refer to today.
Today. Mr. Bana, what do you think would practically cure? But 6 pages, when were the 6 pages served?
On Saturday.
On Saturday.
May I say this? It's not just a question of the number of pages in one spreadsheet. That spreadsheet I haven't even looked at. We received notice of it this morning at 8 o'clock. We asked for hard copies. We understand they're being printed, but people that have viewed it electronically say it's dense information. But whether it's 1 page or 6, consultations are set up with the witness, consultations are held, and despite correspondence from my attorney saying, please don't drip feed us with documents, documents just keep appearing with no explanation as to why they were not given. In fact, even the Friday documents, it's clear the Commission was in possession of that ages ago. They could have been included when we were given the bundle on the 6th February. Instead, they were not. And attitude was taken, we'll see what's in your statement, and then we'll decide to give you the documents. That's a classic ambush. Giving us documents on the morning when we're traveling to court is a classic ambush. And it's no comfort to say we won't use those documents today, we'll deal with them tomorrow. We're all under constraints. Most of the legal team are fasting. It's Ramadan. The witness is fasting. We have a full day here. There's no time for after-hours consultation. And we've then got to deal on the hoof, so to speak, with documents that could have been provided. The Commission knew it was going to be using this. When I say the Commission, I obviously refer to the evidence leaders. And it's not acceptable where this rule of fairness is just ignored, and we're given documents. A letter was literally written at noon on Sunday saying we're being drip-fed documents. Please tell us there won't be any further documents in unequivocal terms. And despite being told there won't be further documents, we get those documents today. So it's a question of fairness. It's a question of why these documents are not produced, and it's a question of in our view, the evidence leaders trying to ambush Mr. Carrim by producing documents at a very late stage, which he hasn't had a full and proper opportunity to consult on. There's no reason we should be put through this in the holy month to have to expect to consult with a witness after hours when people are taken up by the breaking of the fast, by prayers and other such methods. The second issue is more concerning, though. Having looked at some of the documents given on Friday, it appears, and we'll wait to hear the questions, it appears that there's an attempt to introduce matter that is entirely irrelevant to the terms and the mandate of the Commission. So, for example, there are documents produced in an SIU investigation which don't concern Mr. Carrim in any way. Obviously, they're put up there. There's going to be an examination for the purpose of examination, and we are going to note that any attempt to ask questions which are not relevant or rationally connected to the purpose of the Commission and its mandate, in our view, transgresses the principles of legality and transgresses the principles of fairness. I put that out up front, Chair, because you're going to hear if there's an attempt to cross-examine on matters that are not rationally connected to that purpose, there are going to be constant objections from our side. And those objections are not because we in any way want to be obstructive, but Mr. Carrim's rights have to be protected. The terms of reference of the Commission have to be respected, and the principle of legality has to be upheld. Thank you, Chair.
Thank you. Mr. Shaskalson?
Chair, it is regrettable that some of these documents were furnished late, but it's important to put it in context. There was a ruling by this Commission that a statement had to be furnished last week, Friday. Mr. Carrim and his legal team unilaterally took it upon themselves to defy that ruling. They furnished their statement 5 days after this Commission ordered it to be furnished. If they had complied with the ruling, they would have received our statements, our additional documents having regard to what is said in their statement 5 days earlier. If they are complaining now that Friday was too late for them, well, then they should have thought about that before they decided to defy a ruling of this Commission and file their own statement 5 days late. They would have had an extra 5 days with the documents that they now complain were filed late, had they not unilaterally defied
What
the
do you say
ruling of
to the
this commission.
submission? What do you say to the submission that these are documents that the commission had all along and which it could have provided to Mr. Carrim much earlier anyway, instead of waiting until his statement had been filed?
Some of the documents, there are ongoing investigations by this commission. We don't have documents. Every day we discover new documents. We can't, if every time we come across a potentially relevant document, we hand it over and add it to the bundle, it would be an unmanageable situation. We also don't know what is going to be relevant and what is not going to be relevant until we have done the whole exercise. We were probably in a position to hand over all of these documents by Wednesday, but we still hadn't received a statement. Once we got a statement, some of the documents may have become irrelevant. There may have been other statements that became relevant. The whole purpose of this schedule was to ensure that we were given a statement, and then, if as a result of a statement we wanted to supplement the bundle, we would. And they defied that ruling, not us. We gave them our documents within 2 days of receiving their statement. And that was what the original ruling was.
And your submission on the documents that Mr. Bana says are irrelevant?
Oh no, they are most definitely relevant. The relevance will emerge in the course of the questioning. Mr. Bana, who comes late to this party, may not understand the relevance, but they are very relevant. And if he wants to object, we will deal with his objections as and when they come.
So there isn't even a possibility of anticipating the objections in the sense of, in broad terms perhaps, unless you are going to give away something, in broad terms perhaps indicating the relevance at this stage. I'm not pushing you to.
Chair, I would rather deal with an objection as and when it comes, because, and when I deal with the objections, I'm not going to identify my entire line of questioning, because that would defeat the entire line of questioning. But I will deal with any objection that comes. I don't think we're going to save time by attempting to preempt the objection now, because we will then get objections at a later stage when specific questions are asked, which the connection to whatever argument is put forward here may not be immediately apparent to Mr. Bana, who has joined this party late.
And lastly, on the point about a consultation not having taken place with regard to some of the documents?
There are literally 6 pages of documents that came after Friday that I intend to refer to today. Mr. Carrim and his team have had more than enough time to consider how to respond to those 6 pages. And and let me flag something in this regard. Both those 6 pages concern issues relating to Mr. Morgan Mamela. Mr. Carrim and his legal team know that issues relating to Morgan Mamela are directly are going to be traversed in this matter. They were listed both in the notice in terms of Regulation 10.6, requesting the statement, and in the summons. For reasons which I don't know, and which hopefully Mr. Carrim will explain, despite being instructed to issue a statement concerning the nature and extent of his relationship with Mr. Morgan Mamela, he declined to do so. He says nothing about Mr. Morgan Mamela. He clearly doesn't want to speak about Mr. Morgan Mamela. Those 6 pages raise important issues relating to Mr. Morgan Mamela. He's chosen not to engage with them. The attitude from the Commission side is he must, and he must answer whether he would prefer not to, whether or not he would prefer to stay silent in that regard.
Yes. Chair, firstly...
Oh, sorry. Let me repeat that my mic was off. I was saying I'm inclined to make a ruling subject to submissions you may wish to make in response, which would not be more than 5 minutes.
Yes. Chair, firstly, you've given several bits of incorrect information, which the evidence leader knows is incorrect. Firstly, Mr. Carrim did not defy the Commission in not producing the statement. The Commission is well aware of the circumstances. There was
We are past that, Mr. Bana,
Yes.
please. Yes, we are past that.
No, but I need to
Yes.
I need to deal with my learned friend can't go publicly with statements that are incorrect, and I don't have the opportunity to deal with that. So there was the in-camera hearing, and there was correspondence exchange that the statement was equally confidential, and because of that was not produced.
We are aware of that, and
Yes.
the attitude we took as a commission was that despite whatever correspondence may have taken place, nobody ever said to Mr. Carrim he should not file
Yes.
his statement. Please move on.
Absolutely.
Please move on.
And you made a second directive that that statement had to be filed, I think, by Wednesday. And as soon as you did that, the statement. And as soon as you did that, the statement was filed. So there was no defiance of the Commission, and that is incorrect. The further incorrect statement that Mr. Marmela is referred to in the 10-6 notice, if you look at the 10-6 notice, you will see, and I think this is the notice given on 5 December 2025. There have been several notices. This is the last notice that we have on record. 5 December 2025, there is no mention of Mr. Marmela there. People such as Mr. Brown, Mahotsi, etc. are referred to. No mention of Mr. Marmela. There is a reference to Mr. Marmela in the summons, but the summons requires that to be dealt with here and not in the statement. The 10-6 notice pertains to what should be in the statement, and there was nothing relating to Mr. Marmela. But all of that is also, by the way, the Commission knew and had these documents and knew it was going to rely on it. It shouldn't play a cat and mouse game to say, we'll wait and see what you say, and then we'll produce what we have. This is not an adversarial proceeding. It's not an attempt to try and ambush and catch witnesses out. We all know the purpose is fact-finding, and in the spirit of acting in a manner which is transparent and fair, those documents could all have been put up and should have been put up. The explanation that you're given that the relevance only appears from the statement is also incorrect, because our learned friends knew they were going to examine on this because it's in the summons, and it is incorrect to say they had to wait for the statement. Chair, I have raised a general objection as to documents being put into the bundle in an examination. That remains as a general objection, and we will raise specific objections to specific questions. But we do place on record that this is not what the Commission's mandate is, to deal with matters that concern the SIU, tenders that are not even related to the police services. And whilst Mr. Carrim will no doubt be able to deal with whatever is put to him, that is not the point. The point is that this Commission should stay within its mandate, and the evidence leaders should stay within their mandate. Thank you, Chair.
Thank you, Mr. Bana.
Sorry, Chair, I do need
What I did not get to hear, sorry, Mr. Chair. What I did not get to hear was what Mr. Karim's bottom line is for
Yes.
today.
Chair, that the spreadsheet itself might be one page, but that page is a collation of a number of source documents, and we will have to see how far we get today, and if we need more time, which is not the type of scenario that we adjourn at 4, and we expect it to be here at 9:30 to deal with this, we'll ask you to stand down further,
Stand down at what point?
depending how far we get today.
How far we get.
So
All
let's
right,
assume
all right.
that the
Let's-
questions today go till midday. We might be able to consult on the spreadsheet. And also there may be some consequential applications coming from that. There's an issue of confidentiality which I need to consider as well. And I want to give you the heads up for that.
Yes. You wanted to, thank you, Mr. Bana.
Thank
you
you,
wanted
Chair.
to respond, Mr. Shoskov?
Chair, there was a notice in terms of Rule 10.6 issued on the 24th of October that specifically referred to Mr. Marmela.
Let me direct that we should commence. Anything else we will deal with as and when it arises. May we commence?
Thank you, Chair. Mr. Carrim, the way we structure these processes...
The witness has not been, has not taken the oath. Mr. Carrim, will you swear or affirm? You will swear.
I swear.
Oh, okay. Do you swear that the evidence you are going to give is the truth, the whole truth, nothing but the truth? If so, raise your right hand and say, "So help me God."
So help me God.
Thank you. I see you leaning forward. Are the mics not...
Let me just get
bring them
yeah.
closer so that you don't have to keep moving forward and backwards.
Thank you, Chair.
Thank you.
Mr. Carrim, just to explain the process, the first part of this process will just involve me leading you through your statement without any intrusive questioning. So in the first stage of the process, you don't need to be suspicious of me. There will come a point at which you do need to be suspicious of me. We will give you warning when that point is reached. But so that you know where we're going and how it is going to run, just know that until we reach the end of your statement, I'm not going to ask you any questions that are of any intrusive nature or designed to trap you in any way. The purpose of the first part of the questioning is merely to enable you to have the opportunity to put your version on record without being interrupted or disturbed. So there are really two ways in which you can do it. If you would like simply to read your statement into the record, we could do that. We could do it that way. If you would like me to ask you a couple of questions to facilitate that process, we can do it. We can do it that way. You must choose.
I think, Council, you can proceed.
Okay. So to begin with, let me just clarify that you have what you need to have in front of you. You should have 3 files, a small file with your statement in it.
Yeah.
We'll call that the statement file. And then 2 larger files which have exhibits in them.
Yes, I've got them.
Great. If we can start with the statement file and maybe start at the end of the statement, just confirm, first of all, that on page 11, the signature is yours.
Yes.
And can you confirm that the contents of the statement are true and correct?
Yes, they're true and correct.
And then if we can take the Commission through the statement, going back to page 1, in pages 1 to 3, you set out certain concerns that you have and reservations of rights. The statements, the paragraphs speak for themselves. Is there anything you would want to add or emphasize in that regard?
No, Chair. No, Council, sorry.
Then if we move to paragraph 4 onwards, you describe your relationship with Medicare 24 Tshwane District and Mr. Madlanga. Maybe if I can ask you to deal first with, essentially to read paragraphs 4 to 7, which deal with your relationship with Mr. Madlanga before we get to the contract with Medicare 24.
Thank you, Council. So in this section, I deal with the nature of the relationship. I deal with the nature of the relationship with Medicare Tshwane. This will provide the Commission with inside detail and into the topics identified in Rule 10.6. As I have stated elsewhere, I provided funding to Medicare 24 to the amount of 10 million rand. At some stage, to the best of my recollection, during June 2024, I received a call from Mr.
Sorry, Mr. Carrim, it sounds like you are too close to the mic here.
Okay. I'm just worried that you won't hear me from here. Is it fine from there?
usually gets indicated to us if there are problems with the sound. Just go, yes.
Am I audible? Am I audible now?
Yes.
Can I suggest the problem may be that there are two microphones on? Maybe switch one of them on.
We've always used them.
Oh.
Yes. No, switch it on.
Let me switch it on.
Yeah.
Okay.
Sorry about
No problem. Yes, Mr. Carrim.
At some stage, to the best of my recollection, during June 2024, I received a telephone call from Mr. Matlala requesting a meeting with me. I know Vusi in the private, I know Vusi as we both operate in the private security sector. I'm a director and shareholder of Fusion Tactical Team, which is my security company. Prior to this, to the best of my recollection, I had no engagement, relationships, or dealing with Vusi beyond knowing in a general sense who he is.
And then from paragraphs 8 and 9, you describe Mr. Matlala's approach to you in relation to his tender with SAPS and wanting finance or funding from you. Can you read 8 and 9, and if there's anything you want to amplify, please do.
So at the meeting, Vusi, he had obviously told me he's the director of Med24 and that he had won this contract to provide medical services to SAPS. He then needed or required funds to perform under the tender as he had overcapitalized on the establishment of his tender and therefore encountered cash flow problems. He insisted that he was geared up for rendering the services in respect of the tender. He invited me to see his business premises in Pretoria. I visited the business premises and I confirmed it was state-of-the-art. I was impressed from what I had seen, and I could appreciate that Mr. Matlala could spend a considerable amount of monies in the capitalization of this tender. At the same time, when I visited the site, I then met also a Michael van Wyk, who was introduced to me as the CEO of Medcare24. Michael advised that he owned the Medcare24 franchise and that Mr. Matlala was a franchisee. Michael had, during our discussions, confirmed that he'd be assisting Vusi in operating and executing this tender. At the same time, I needed to verify this. I then reached out to a friend of mine, Mr. Opa Brown Khotsi, who is from Mafikeng as well, and who's someone that's known, who's connected. I then asked him to please verify and check if really this tender exists, and can he come back to me? Mr. Mokhotsi then agreed to check for me. He reverted and said, yes, it is a valid contract. Vusi and I agreed that if I advanced the 10 million, I would be paid an additional amount of 10 million over a 3-year contract period. The repayment would be made at an equivalent of 10% of all payments received until the amount of 20 million was going to be paid. In terms of our agreement, we then set out the payment structure, which is attached. After July 2024, I would call Vusi from time to time and ask him whether he had received a signed SLA from SAPS and when can I expect a copy of this agreement between Medcare and SAPS, as we all had an agreement confirming our agreement. Because we had an agreement which was not signed, we agreed that we'll sign the agreement once the SLA was signed by SAPS. He experienced some delays in obtaining the SLA from SAPS, but there was no cause for concern as Med24 had already commenced in rendering services to them. This seemed quite plausible to me, as in my experience, formal contracts often lag behind and before implementing the contract. I asked him if he had issued any invoices and when could I start expecting payments. He then stated to me that he stated to me he would commence payments upon receipt of sufficient funds from SAPS, including the payments due to me. Towards the end of 2024, we had still not got any payments in from what Vusi told me, and I began pressing Vusi to provide me with invoices and payments details from SAPS. At this stage, I was becoming despondent due to the non-payment from Vusi. I again then reached out to Mr. Brown Mukhotsi. I then asked Brown to please check if Vusi is really receiving work and if the contract was going to be paid. Brown confirmed that he is delivering and we will be paid. During about December 2024, after being pressed to start making payments, Vusi advised that I would commence receiving payments shortly. This was a relief to me. Shortly thereafter, in January 2025, Vusi contacted me, requested further money to service the tender. I advised Vusi that I could not provide further funding at this stage because I was not receiving any payments towards the funds advanced, and that Ziggy needed cash for other projects and ventures. I was also concerned that the 10 million rand had already been advanced and I have not received a single payment. I would then, to verify this, contact Brown, for example, inquire whether payments were being made under the tender. Brown would always revert back to me based on what he allegedly knew, and also I had no way of how Brown was verifying this. I need to place that on record. During these exchanges, Brown confirmed that the tender was still in operation and that payments were in progress. In February 2025, payments started trickling in. By mid-March 2025, I received net payment of 1.75 million, which was paid into Tamiz Investments business account. Before any other payments could be received unexpectedly in March, Vusi
All right. We are ready to start the day's proceedings. It's 13:50.
Good afternoon, Ms. Hassan. Good afternoon, Mr. Premhead.
Afternoon, Chair. Good afternoon, Commissioners.
An important housekeeping matter. I will afford each council 1 hour to argue, and I will afford you 15 minutes to reply, Mr. Premhead. So organize the flow of your argument in accordance with that. And so that should mean it's still two, it's actually two still, so I won't add anything. Up to 1,500 hours. Thank you, you may start.
Chair, I'm just putting my timer on so that I'm conscious of the time. Good afternoon to you, Chair and Commissioners. May I say that I don't intend to be as long as 1 hour. I think it will depend on the level of engagement between the Commissioners and myself as to whether we will need 1 hour. And can I say the reason I'm not going to need 1 hour is because the Commission has itself now conceded that a postponement is appropriate. The Commission has chosen a date of 14 August 2026, and that means the postponement application which has been brought by my client in respect of his evidence for the 15th of July rolled over to the 17th of July, rolled over to the 24th of July, is effectively unopposed.
Yeah, but a crucial issue is that the effect of what we have before us would be that Mr. Carrim never ever testifies. So that's a serious issue that needs to be dealt with.
I'm not sure I agree with that characterization, Chair, but I accept the point that you make that the postponement as to whether or not it's by a postponement to a fixed date as opposed to a postponement not to a fixed date but subject to some...
But with what we have before us, the doctor's report, the effect as we sit here now is that even on a later date to which we may postpone, we will be told the same thing.
Indeed, sir.
So ultimately, the effect will exactly be what I'm saying, which is that Mr. Carrim will never ever testify.
Well, I don't know if I agree with the characterization that you'll necessarily be told the same thing, because what you'll remember from the treating doctor's report to you, and again, I'm not going to go into the specifics of that in light of the ruling on the in-camera issue, but what the treating doctor says is that the position of my client is dynamic and it is subject to change. And that's why one of the things that the treating doctor himself proposes is to account to the Commission under oath once every 2 weeks to update the Commission regarding the client's position and whether he can or cannot testify. It's also why the doctor's evidence under oath is to suggest that there are alternative means that can be explored.
No, continue.
No.
I wanted to say, based on what we have, an educated guess would lead one to say, even though you've just made the submission that you've made, we can't hold our breath.
No, fair enough. But I was responding to the characterization that you'll necessarily be told the same thing in future. It was simply to say that that's not entirely correct.
I guess
you may be told the same thing in future, but you may not be as well.
I guess I'm saying exactly the same thing I said earlier when I say we can't really hold our breath.
No, indeed so. Yes. Indeed so.
Can I also just check your characterization of where and how we got here? You say the application for the postponement is not opposed. I don't see that is correct, a correct proposition. You're asking for a postponement to an indefinite date, which is completely subject to what the treating medical person is going to determine whether he ever comes back and on what date he comes back. But more importantly, you are bringing an application for a deferral of Mr. Carrim's evidence to an undetermined date. That's your application, as I understand it. And the evidence leaders oppose that. And in their opposition, they say, we want him to come back on a specific date. So there is an opposition to your application.
Yes, it's a limited, that's the word they use in their correspondence of about the 23rd of July, if I'm not mistaken, where they say it's a limited opposition. And it's, if I can say this, the difference between my learned friend and myself is the mechanics of the postponement. What's not opposed is that a postponement is appropriate now. It's just subject to whether, as Commissioner Baloy correctly says, it's an open-ended date or it's a fixed date. And that's what I was saying to the chairperson as well. So it's not to say that it's no opposition in the sense that there's no disagreement. There is disagreement, but it's on the mechanics of the postponement rather than the narrower question that I was addressing, which is that the postponement being sought today, in principle, is unopposed between the Commission and ourselves.
But if it was being opposed in the wide sense, whatever that means, but at this point I wasn't engaging on the technicalities of indefinite, and I was simply saying, but this application is opposed. That's the position. Your application, as formulated by you, is being met with an opposition.
Yes, it's described as a limited opposition in paragraph 1.14 of the attorney's letter on behalf of the Commission of the 23rd of July. So that's where I was going to focus the bulk of my submissions, on the limited nature of the opposition, rather than whether or not a postponement today ab initio is being opposed. I think that's where I'm directing myself, Commissioner Baloyi.
Yes, all right. But you accept it is opposed?
Yes,
right?
yes,
Okay.
within the confines of what I've said. Yes, absolutely so.
Thank you.
I'm not, it's like in litigation where the parties might...
Please, I think.
Okay.
Please go ahead.
No, thank
please
you.
Continue.
I'm indebted. So by means of introduction, that's the first of the 12 points I wanted to make. The question in front of you is actually a narrower question about the mechanics of this postponement and what it ultimately looks like, whether it's to a fixed date or whether it's to an indefinite date. And what I will say to the Commission in that regard is two things. Number one, you have our submissions on paper justifying why it should be an indefinite date. But obviously the Commission, through the evidence leaders, have put up a series of considerations as to why it should be to a limited date. And practically speaking, that's something that, practically speaking, that's something the commissioners will apply their minds to and make a ruling on. And all I'm going to say is that the mechanics of that ruling will be whatever it is. I'm not going to focus my submissions on the harder element, if I can call it that, which is to say it should be to an absolute indefinite date. I'm going to focus on my submissions on the appropriateness of the postponement in the circumstances in light of the evidence that you have in front of you. So that's where that's what I'm going to focus on. Can I just say that, and the reason for that is because of the limited nature of this opposition, but I'm not going to repeat myself. Can I say on the second point, please, that there are two potential directives that we would ask the Commission to consider granting in respect of the proceedings today and the argument as it unfolds in front of you today, and before my learned friend has an opportunity to address you. The first one is that I'm not sure what the status of these application papers will be or become once the Commission makes its decision on the postponement. But the request is that should any part of the record become public, that it is subject to the limitations already imposed by the Chair in the in-camera ruling. So that is that the record of papers itself must not reveal or identify the very things that the Chair has said we're not allowed to say in the oral argument, because that would effectively render that ruling pointless if the paper record reveals the very things that we aren't allowed to refer to in the oral hearing. I don't think that should be controversial. That's actually asking for a logical extension of the Chair's ruling as it applies to the papers. The second directive, and this might be the more controversial one, is I know my learned friend has given me advance notice that she intends to rely on certain CCTV camera footage. I don't know if that is still the case, but there are other pieces of information that the Commission has subsequently shared with us that may also need to be treated carefully. In particular, there is mobile data geolocation information which may or may not be projected. I don't know if my learned friend intends to project it on the screen when she makes her submissions. But if she does, the point that I would request the Commission to please consider and make a directive on is some of that information contains highly specific GPS coordinates. And the reason that when it is projected onto the Commission's screen, if the Commission intends on doing that, to prevent the publication of exact GPS coordinates is because it opens the threat that the GPS coordinates, when projected onto the screen, can be used to reverse engineer exact locations. Obviously, if the CCTV footage puts my client at a Durbanville mall, I can hardly complain about that. but I'm raising a concern in respect of the facility, for example, and geolocation data near the facility. I would also humbly request that in making such a directive, when my learned friend is going to refer to or reference the suburb that the facility is located in, that the name of the suburb is not mentioned explicitly, because it doesn't take a genius to run a Google search or a ChatGPT search to ask it what medical facilities are in the particular suburb, with the effect that it gets close to the very things that the chair has said should not be identified. So I don't know, practically speaking, when chair will make those directives or consider them, but I think even in just flighting the fact that those are the directives I'm asking for, I'm hoping my learned friend will approach it with some degree of sensitivity, even in the absence of a directive. That's not to say my learned friend mustn't say what she wants to say or use whatever footage she does. I'm just raising the concern about certain of the information which is not necessarily expressly covered by the in-camera ruling might nonetheless be utilized to undermine the very purpose of the in-camera ruling. And that's the second request that I make. Chair, I'm in your hands as to practically whether you want me to go on.
I think for now, yes, for now, please continue
Okay.
with your argument. I don't want to eat into your time. What we will do, we'll raise this issue before Ms. Hassim starts arguing.
I'm indebted.
Yes. I don't think there's an issue with the
first one, I
with the
hope.
first one, really, but we can't make rulings piecemeal. Yeah.
Yes, indeed,
Yes,
indeed,
yes,
indeed.
yes.
So that's point number 2.
Please continue.
Thank you, Chair. I'm indebted. Point number 3, now talking about the video footage. With all due respect, in light of the affidavits that have been exchanged between the respective parties, I'm going to respectfully submit that the video footage is unnecessary today. And more than being unnecessary, it's also not appropriate and does not serve a legitimate purpose. And there are 3 reasons why. The first one is, by and large, the allegations made by the Commission have now been admitted, answered to, and amplified by my client and the people deposing on his behalf. So the footage is not necessary because the footage is not needed to prove admitted facts. You don't need to lead the evidence to deal with admitted facts. That's point number 1 as to why it's inappropriate. Point number 2 is that the footage is an inappropriate form of evidence in light of the fact that, and you will know this because this is dealt with explicitly by my client's treating doctor, that things like video footage and geolocation footage or geolocation information and so on does not have clinical value.
Sorry, what noun did you use? It's inappropriate what? It's inappropriate? After inappropriate, what's the noun you use?
Oh, inappropriate form
Okay.
of evidence.
Oh, all right, thank you.
Inappropriate form of evidence because ultimately what underlies the Commission's concern and the Commission's complaint regarding my client's postponement is a medical issue. And so this geodata information or CCTV footage or whatever it is, on its own, not being led through a clinician, and not being analyzed by a clinician or responded to by a clinician, is inappropriate secondary evidence, which is being used to gainsay the medical opinion expressed about that exact approach.
Are you talking about Durbanville? Or
Yes, Durbanville.
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 Can you please explain your point about it relating to what may have to be attended to by a medical practitioner?
Yes. May I just ask Ms. Matlingwane for some
Because
assistance?
let me tell you why I'm asking you this. I see it as objective material which says he was there.
Yes.
So I don't see the connection with what a medical practitioner might have to say on the issue.
May I respond?
Yes,
Give two
yes,
responses. The
yes,
first response
yes.
is that it's also accepted that he was there. So it's unnecessary because it's an admitted fact between the parties. There's no need to lead the evidence. But the secondary line of reasoning, and this is where I need Ms. Madlangwa's assistance, but she'll hear me in response to you, Commissioner. I'll give you the reference after the fact, is this. The medical practitioner says that the Commission relies on a bunch of evidence, such as CCTV footage, Apple Pay data regarding payment accounts, movement data gleaned through geolocation data. And the position of the clinician, for reasons that you know which are recorded on the papers, is all that demonstrates is movement of some kind, but that the movement of some kind, the fact of the existence of the movement of some kind, is of no value in determining the clinical issue as to why the client cannot attend or attend the commission to give evidence. So the point as to inappropriate is that it doesn't deal squarely, with all due respect, with that clinical issue, and particularly in circumstances where the clinician has raised doubt about why it's being used in the manner in it's being used.
I get you on your first point, which is why flight that footage if there is no dispute about his location on the day and at the time. I get your point. I'm not sure that, one, you need the second point, and two, I am not subject to whatever else you may say. I'm not convinced by your second point. But please continue. But I stress that you don't, in the face of your first point, I'm not altogether sure that you need the second point.
That's where
on this issue, it's a very weak point.
I think we're ad idem on the first point, and what I would say is that if those facts are not in dispute, then needing to flight the footage so as to prove something that's not in dispute is unnecessary. And
you see, your second point would make sense if the flighting would be for the purpose of showing that by being there, the medical condition relied on simply does not exist. If that was the purpose, I would understand your point.
Yes.
I'm not necessarily saying that Ms. Hassim is not going to argue that.
Yes.
I do not know what she's going to argue. But perhaps until she has argued that point, as I say, from where I'm sitting, I don't think you need the second point, and I repeat, I think it's a weak point for purposes of this should not be flighted.
well, let me accept the invitation then to simply say, if my learned friend, well, I'm caught between a rock and a hard place, because during my learned friend's submissions, she may flight the exact footage to make the exact point that Chair is putting to me, which is because he was at X place, that brings into doubt the medical evidence. And in fact, that is the Commission's case, because you know, in their affidavit, they call my client, with all due respect, gratuitously an inverse outpatient. So the very attitude of the Commission, through the evidence leaders, is not to say that, oh, this is a benign piece of evidence, the CCTV footage. The entire thesis underlying their opposition to the postponement and why they want to tie down my client to a specific date is to say the fact of these movements, the fact of these payments, the fact of that he's not in the hospital all the time brings into doubt the medical diagnosis that the clinician has given him. And that's the further reason as to why we need an independent medical exam. So may I just finish on this, please, Chair?
By all means.
If my learned friend is not going to push that line of argument today in front of you, then I don't need the second point. But if my learned friend is going to push that point, then I do need the second point, even if Chair says he's not convinced that it's a strong one.
You see, just to make sure that I will not be misunderstood, The question whether Mr. Carrim's movements show a pattern that is at odds with what we have been told, that's central to the evidence leader's case. So what I said earlier did not suggest that Ms. Hassim is likely not to argue such a case.
Agreed.
But I'm making a different point. That case can be argued without the need to actually flight the footage.
Agreed.
Why not? Exactly because it's agreed that at the time, on the day, Mr. Carrim was at a shopping complex in Durbanville.
Agreed.
So that point can still be made, or that argument can still. But as I said, whether Ms. Hassim will actually want to flight the footage, we'll hear her when she says so.
Indeed.
Yeah. Shouldn't we leave
Move
it
on.
there and move on,
Yes,
please?
I'm
Yes.
happy to. Can I just give you one reference, if I may?
Yes.
If you look at paginated page 94 of your pleadings bundle in the postponement, paginated page 94, you'll see the heading, its geolocation data and its clinical significance. The basis for the submission that I was making to you comes from paragraph 45 on that page, as to why flighting that is unnecessary over and above the reason that Chair has already identified that it's not in dispute. So I'll just leave that, if I may. What Ms. Madlanga is doing is she's looking through the Commission's papers to give me the reference, the exact reference of where this debate arises from in the way that Chair posits it to me. So Ms. Madlanga will give me that reference shortly. Can I also just say this? This moves me on to point number 4, 23 minutes in. Point number 4 is this, is that the medical evidence in front of you from Mr. Carrim's treating clinician is undisputed on the clinical diagnosis and the clinical observations that Mr. Carrim's treating medical professional makes. There is an expert report, and I'm not even going to mention the expert's name, put up by the Commission, which generously doesn't actually dispute that clinical observation. What it does is it speaks to 2 collateral issues. The first one, which with the greatest of respect to the expert is an invention of his own, is he talks about it being inappropriate for Mr. Carrim's physician, Mr. Carrim's medical practitioner, to perform what is called an independent medical exam on Mr. Carrim. It's referred to in the document as an IME. The simple point about that IME and why then it can't be used as a basis to impugn Mr. Carrim's medical doctor's clinical observations is Mr. Carrim's medical doctor never performed an IME. An IME is an entirely separate form of medical examination that is performed in a forensic context where there needs to be, understandably, a degree of separation or independence between the medical examiner and the ultimate patient. But in this particular instance,
how do you describe forensic in this context?
when you say in this context,
or rather, let me leave out in this context. How do you
let's say,
describe
like,
forensic?
Chair, this goes back to that discussion you and I had the last time. If we were in Uniform Rule 36 territory, and you'll remember you and I had the discussion about Uniform Rule 36 as a parallel mechanism through which examinations occur in instances of medical negligence claims. That's the forensic parallel that I would say the IME concern arises in.
I would understand the rule to be the vehicle in terms of which you get to
Yes.
whatever it is the medical practitioner
Yes.
has to do.
Yes.
That doesn't necessarily answer my question, I don't think.
Well, the difficulty in answering the question is that I'm trying to distinguish what the Commission's expert report criticizes Mr. Carrim's medical practitioner for allegedly doing and why it's inappropriate. And I'm responding.
Let's take, for example, the context of criminal proceedings where the rule you are referring to would not apply at all. I would imagine that even in that context, you can talk forensic when medical practitioners
Yes.
are involved.
Yes.
So it's on that basis that I'm saying, how would you describe or define forensic in a way that, for example, would exclude what we have been given here? Why is it not forensic here?
Because, and that's the exact criticism that the Commission's expert attempts to make, is that the Commission's expert, as we understand it, says that the treatment Mr. Carrim is receiving can never be an IME exercise because he's not, in inverted commas, independent enough of Mr. Carrim. And the point I'm making is that's exactly correct because the treating doctor is not performing an IME for some forensic, independent, objective, evaluative purpose, like under a Section 79 inquiry or under a Rule 36 type inquiry. He is the patient's, Mr. Carrim's, own treating doctor. So he doesn't, the point I'm simply making is that the basis upon which the Commission's expert, it seems to undermine the clinical evidence in front of you from that doctor is to say he's not entitled to perform an IME and what he's given you is not an IME. And we're agreeing with that because we're saying the treating doctor is doing something fundamentally different. So that's the first point that I was making.
Please continue.
The second point that I was making, to the extent that that report is relevant in front of you, is that that report itself emphasizes the role to be played by Mr. Carrim's own treating doctors before any such directive can be given that he's subject to the medical examination of another. And you can find that at Annexure MT1 at paragraphs 18 to 19. And it's also referred to in the evidence leaders' submissions at paragraph 47. So the very point is to say that the medical evidence of Mr. Carrim's doctor is unchallenged directly. To the extent it is challenged, it starts from an incorrect premise. But even if it does start from the correct premise, it emphasizes the very point as to the centrality of Mr. Carrim's own treating doctor and Mr. Carrim's treating doctor's clinical observations as it influences any future process. And you know Mr. Carrim's treating doctor's clinical view speaks to Mr. Carrim's non-ability to give evidence. And I'm using ability deliberately because that obfuscates what is known to us but not to the world at large. So even that report ultimately draws a point to say that the medical doctor's observations who's treating Mr. Carrim have a central role to play in any determination in how Mr. Carrim is treated. And we would say that the evidence speaks for itself and it's unchallenged in front of you. But there are a few more things I'd just like to say in that regard, if I may. The first one is, our learned friends provided us a bundle of authorities. A lot of it is foreign authorities.
Before you go to authorities.
Yes, Chair.
I think the first point that doctor makes, that is Mr. Carrim's, is that, and I'm going to an assessment by an independent doctor. So Mr. Carrim's doctor says such an assessment, in fact, I think the doctor uses the word interpositioning. So if another doctor is interposed, that will be deleterious to the treatment that Mr. Carrim is undergoing.
Correct.
So the first point or the first prize is that no other doctor should be interposed. But as I understand it, your expression seems to suggest that I'm misunderstanding the situation. But let me continue. You will respond.
You and I have read each other's facial expressions for a long time now, Judge. You'll know what I'm talking about.
I know. Then the second point, as I understand it, is that if, despite my opposition as the doctor, as the treating doctor, if despite that the position is that another doctor should be interposed, that should be done in, I'm paraphrasing here, forgotten the actual wording, that should be done in consultation with me. I should be involved. As to how exactly, I'm not altogether sure now. Should be done in consultation with me. Now, what I wanted to raise is, if the doctor does say that as an alternative, would Mr. Carrim oppose this? That is the alternative. Would Mr. Carrim totally oppose it?
Well, I have no instructions on that, and as you know, the legal team have had to obtain instructions.
No, in the manner in which you and I know, yes, how this is.
So I would have to take an instruction, but if I may, I don't know if you are done, Chair, and I don't want to interrupt you.
Yes,
but
yes.
Having regard to my facial expression earlier, the reason that it was of that kind is, if you can go to the paginated pleadings, please, paginated page 49.
Yes.
If you look at the heading just above paragraph 68, the consequence of compelled attendance. Mm-hmm. So I think how I understand the treating doctor's position is this. And I think, Chair, this goes back to the debate you and I had last time, and can you draw any inference from a compelled attendance where it's chosen not to attend or a voluntary attendance. The position of the doctor is that it's not to say that none should be interposed as a blanket position. It's to say none can be interposed unilaterally or in a compelled sense that the doctor resists. And then the doctor's position in respect of what then. So in other words, if it's voluntary, does it come through me, or whatever the case might be, is expressly dealt with in that same affidavit at, I see Ms. Madlanga is marking paginated page 51. For example, he doesn't deal with it in express terms, but he's talking about in paragraph 71 on page 51, he's talking about less intrusive formats of engagement and his ability to manage the downstream consequences of the format ultimately chosen as a consequence of what the Commission chooses to do or not do. This paragraph admittedly is talking about, in part, the in-camera question, should it be open or should it be closed? But it's an answer to you, Chair, about the extent to which the doctor's position is not to say, I am the block, so to speak, and if I say no, it's no. The doctor's position is to say that I must be consulted, and if I can facilitate something which is not clinically detrimental to my client's, my patient's current position or future position, then I would have to give medical advice in that regard. So it's to say that it's not perhaps as blunt as the way in which the chair was positing it to me.
Yeah. Now, exactly on what you've said last, my question relates exactly to that. If, in a sense, even if qualified, the doctor is not altogether rejecting the idea of interposing another doctor, what would Mr. Carrim's position be? And that, I think that's the point on which you already said you have no instructions.
Yes.
Okay. If we were to say, please get instructions, by when would we get a response on that?
I can't commit because it would have to be relayed to the two individuals who would then have to engage with Mr. Carrim when he's available and then have to come back to us as the legal team. As you know, one of the issues is that in present circumstances, we don't have direct access.
But I would imagine, on my understanding of the protocol, the existing protocol, surely there must have been a good few interactions following that protocol. I would imagine that should give you an idea of possible time frames.
No, because in as much as I thought advocates were busy and have busy diaries, I've never dealt with medical professionals whose diaries are even more challenging than ours. And that's why, for example, some of our papers reached late because of when we could consult with the medical professional in particular concerned. Can I say this? In principle, on what's in front of you and what the doctor himself has said, there should be no objection. But that's obviously subject to his ability to speak on behalf of Mr. Carrim with or without Mr. Carrim's consent. Whilst maybe my learned friend is on her feet, so to speak, proverbially, maybe what I can ask is Mr. Bismillah, who's sitting behind me and from my instructing firm of attorneys, can try and get in touch with our other attorneys and the relevant individuals to try and take a specific instruction on what Chair has put to me. That's the best I can offer in the circumstances.
Yes. I must make the comment that what you've just said now is quite useful, which is that there is no in principle objection to the idea.
Well, because from my reading of what the doctor has said, is his opposition, in inverted commas, was on the unilateral imposition of a third-party medical practitioner. But the doctor has himself spoken about less intrusive means in a multitude of manifestations. And if the doctor interposing in respect of a third party to obtain voluntary consent, whether it's given or not given, is within the basket of those less intrusive means, as I see it, because it's not the compelled examination. And so that's why I say, in principle, I don't understand that could be an issue, but I will ask Mr. Bismillah to get the specific instruction.
Thank you. Please continue. Are you moving on to another point?
I see Commissioner Beloy.
Yeah, before you move on, let me just clarify. You and the chair seem to be of a common understanding of what the doctor is saying. So it may be I misunderstand. I'm looking at reading from 73.1 up to 73.3. I understand the doctor to say that there must first be engagement with him on these medical issues. And if we are not happy, and I'm reading now at paragraph 73.2, what is clinically objectionable.
May I ask for the page, please, Commissioner?
Sorry, 52.
Thank you,
52.
Commissioner.
73.1 up to 73.3, but the clarification that I would like to have is because of what he said in 73.3. He says, a properly constituted assessment stands in a different footing. If after engaging me, the commission remains unsatisfied, I do not object in principle. So on the doctor's offer, he anticipates he's given a report, then he must be engaged with about his report by the commission. And if we land at not being satisfied out of our engagement with him arising from his report, then he does not have an objection to the interposition subject to whatever he says there. I understand you and the chairperson to have formulated it as follows, that as matters stand, the doctor does not have an objection to an interposition provided there's a condition, the conditions in there met. Am I misunderstanding?
No, we were past the original stage, which is about the conditionalities. I was on what I referred to as a fallback position, as it were, and I don't think it differs from what you've just said.
I see.
Yeah.
I think we're all ad idem because Commissioner Baloy, you looked at 73
Perhaps I think Commissioner Baloy has just said yes.
Oh.
When I made I think you should move on to another point if you are about to.
Okay.
Yeah. I don't want you in the end to say the hour was too short because of our engagement.
Yes. Could I, all I'll say to Commissioner Baloy, if I may, is I know, Commissioner, you looked at 73.3. When you probably have looked at it already, but the way in which I would look at what he's saying in 73.3 follows on particularly 73.1 and 73.2 on the same page, but as it relates to that earlier statement, which is where the chair and I started about a compelled examination. And I think what he's addressing in those circumstances is what the deleterious effect of a compelled imposition of a third-party medical practitioner would be for what he is doing, but not to say that that's a total out ruling of less intrusive means, provided that whatever the less intrusive means are, plays a suitably respectful role of him as the treating doctor, which I said at the very beginning, even the Commission's own expert accepts that that's the role to be played by his treating doctor.
Okay, I understand. Thank you.
Thank you, Commissioner Baloy. Just so that I was making the point about the authorities, and I now see it's 44 minutes, I'll be quick.
And I took only 3 minutes at that time, please.
Don't worry, I'm not going to ask for an accounting exercise between the commissioners and myself. But very quickly, if I may, the point about unchallenged medical evidence and proceeding in the face of unchallenged medical evidence, and you know I say that my client's doctor's evidence, when properly understood, is unchallenged. That point is made by the same authorities relied on by our learned friends. So, for example, at paragraph 16 of the Hyatt case, which can be found at pages 6 and 7 of their authority bundles, that point is made. That point is also made again later on in that paragraph, in that judgment at paragraph 32b on page 12. And interestingly, it says, it would be wrong for a committee which has the livelihood and reputation of a professional individual in the palms of its hands to go with a hearing where there is unchallenged medical evidence that the individual is simply not able, and I'm using the word able to not use the word in the quotation, to withstand the rigors of the disciplinary process. And why I emphasize that is because you know the position taken by my client is that the secondary evidence, the CCTV footage, the geolocation data, even their own doctor's report, doesn't challenge the medical evidence properly in the way that the medical evidence is in front of you.
I'm not sure that that's a good point because I think at the last appearance, you strongly oppose any idea of an assessment by an independent doctor. So on that basis, there can be no question of us having a report by a doctor challenging what Mr. Carrim's doctor says. So we all understand why there is no opposition.
No, with all-
It's not as if with an opportunity available for another doctor to counter this doctor's report, no counter was furnished. It's on that basis that I feel that's not a strong point at all.
I respectfully disagree with you, Chair, in the following two respects. On the last occasion, it was not that I had any objection to an independent exam being performed. It was whether or not it could be compelled and whether or not any inference could be drawn.
That boils down basically to the same thing, because in expressing your view that compulsion was not possible, the upshot of that was that you were opposing. That was opposition. And you even, that was the context in which you referred to the rule in the context of civil proceedings. You said, you questioned our power.
Correct.
Our legal power to even compel.
Correct.
That's opposition. So
Yes,
I don't understand.
But then
your
you and
point
I
now.
landed on the agreement that no adverse inference could be drawn if it's a voluntary process.
That's something else.
No, but that's
something
the point
else.
I'm making. The point I'm making is my opposition, so to speak, at that time, in the way in which we understood the Commission's case, was on the issue of the compelled examination. What I'm saying in response to this issue as a continuation of what just happened between yourself, Chair Commissioner Baloy, and myself as well, is that if the voluntary examination is the mechanism, with the interposition of Mr. Carrim's own doctor or not, then that would be fine, because that also means that no adverse inference can be drawn if he declines to not participate in that. That's where we landed last time.
No, you never. I accept that today you have made the point that in principle there is no objection to this happening, but that's subject to instructions being, or rather your instructing attaining, finding out what the position will be in terms of an acceptance or otherwise of the assessment. You are saying something like that for the first time now. On the previous occasion, you strongly argued against it, making the point that we simply do not have the power. And you distinguish the fact that we do not have the power by making reference to the power that a high court has in civil proceedings in terms of the rules. At no stage did you ever get to a point that said, no, we are amenable to we are voluntarily amenable to an assessment by another doctor. You never got to that point.
Because the debate didn't get that far, with due respect. Where we ended, and we were having a general conversation, is that I ultimately accepted that if it were a voluntary process and that no adverse inference could be drawn as to the participation in that voluntary process,
but
that's where we left it.
But Mr. Premier, did you, because more than one letter, in fact, at least two that I remember from reading these papers for this postponement application, more than one letter was written to Mr. Carrim's attorneys requesting him to avail himself for an assessment by an independent doctor. Initially, there was no response. And was there a response the second time around? I'm not sure. But here, in open session in this commission, what we got was the vehement argument by you against that as a possibility. That's all that we know. So for you to suggest that, however, there could have been the possibility of a voluntarily agreed to assessment comes as a complete surprise to me, because the attitude throughout, especially in the face of the two letters that were specifically asking for this assessment. What you say now simply does not accord with that history. That history culminating in your argument before us here. If Mr. Carrim was prepared at all to subject himself to the assessment, we should by now have received something from him or his attorneys saying that here I am willing to subject myself to that assessment that the Commission's attorneys have asked for more than once. So I don't understand your argument. Insofar as it relates to the possibility of Mr. Carrim subjecting himself to the assessment voluntarily, I do not understand that part of your, not in the face of the history I'm referring to.
No, I accept that, and I'm not going to try and relitigate that history now. I think I'm going to go and read the transcript, because at this stage, I'm going to respectfully say recollections may vary, and then I can come back to you and reply and clarify that as needed, because as I say, I remember the debate having happened slightly differently, and it was on the characterization issue about voluntary or compelled, and it didn't go beyond specifics about what if it's voluntary, then what is the instruction in the way that it was put to me today. And in light of the new evidence that has come about less intrusive means, that's why I gave an in-principle answer subject to my instructions. But I'll read the transcript and I will come back, and if I'm wrong about that, then obviously I will be wrong and I will apologize to the Commission accordingly. But if I can move on.
Just to protect myself from a full-on egg on my face, let me say I'm also only human and fallible. So my memory may also be inaccurate. Please continue.
Yeah, well, that's why they have appeal courts. They can correct the lower court judge's memory. But no, Judge, thank you. I accept that. Let me just say this. The other mechanism available is that there could have been, in terms of direct challenge to Mr. Carrim's doctor's evidence, is that instead of the report that was put up, which talks about a subsequent process, which is I'm going to describe as collateral, a rebuttal witness could have been brought. And the rebuttal witness, like ordinarily happens in civil litigation where there are contesting expert witnesses, which doesn't necessarily involve an inspection in loco per se of the incident or the person, is possible, and that wasn't done either. You've already heard me. I was going to take you through the authorities, but I don't think that that's necessary for me to do so, except to refer to one judgment, if I may, which is one that's cited, I think, by both of us. It's a South African judgment. It's Michael versus Linksfield Park, 2001, Volume 3, SA 1188, SCA, at paragraph 39 in particular. I just gently point out that there the SCA said, the assessment of medical risks and benefits is a matter of clinical judgment which the court would not normally be able to make without expert evidence. And so that's the point that I'm making. Insofar as there's direct medical expert evidence in front of you is concerned, there is no rebuttal of that. It remains unchallenged, and the Commission should be slow to draw any inferences from alternative sources of evidence as to what clinical value it has or it doesn't have. Because that alternative evidence is not clinical evidence, and with all due respect, you don't have a duly qualified clinician in front of you who offers an alternative view about Mr. Carrim's clinician's view of Mr. Carrim. In fact, the expert report put up by the Commission itself expressly qualifies itself by saying, I don't offer an opinion on the underlying medical assessment made by that clinician. So, insofar as the clash of evidence and the weight to be attached to the evidence is concerned, in the exercise of your discretion as to whether a postponement should be granted, I come back to the point that the stronger evidence is Mr. Carrim's clinician's direct evidence and not all these alternative sources of evidence that the Commission may rely upon. You've already heard me on the issue of the electronic data cannot answer the medical question. I've made that point a few times. I don't think I'm going to go there unless the Commission wants me to. You've got that in front of you. All I would say, and having read the papers this morning again, as well as the correspondence, you also know that there's I'm going to use the word challenge, but I'm going to say it's in inverted commas. There's a challenge to some of the evidence in front of you, how it was obtained, but more than just simply how it was obtained, whether it's reliable because of identified instances of errors in that evidence. I don't think that you necessarily have to make a ruling or determination on that today. It's simply to say that in the assessment of the evidence is concerned, you've got questions about at least reliability, and to the extent then any weight is going to be placed on that, you should place less weight on that than you should the direct medical evidence in front of you. Could I then just make progress in the 3 minutes I have available? I think we've already foreshadowed the debate about my sixth point, which is about the 14th of August versus some open-ended date. The Commission heard right up front, I said that that would be a judgment made by the Commission as to how it fixes it or doesn't fix it, having regard to the medical evidence in front of you. I'm not going to deal with that further. May I just say then on this issue of the independent assessment, I think we've debated that extensively already. It turns on the characterization of whether it's voluntary or not voluntary, and it also turns on whether it's facilitated or not facilitated. And there's consensus between Mr. Carrim's treating doctor. If you read paragraphs 90 to 94 of the paginated pleadings, I don't need you to go there, I'll just give you a note. Paragraphs 90 to 94 at record pages 53 to 54, and this is also the sequence that the Commission's own expert agrees with. And if you look at paragraphs 18 to 19 of Annexure MT1, I think I've given you that already, you'll see that there's a synergy between that. So if any direction is made regarding Mr. Carrim and any voluntary medical examination, we would ask that the chair takes into consideration the involvement of Mr. Carrim's treating clinician. We also know that there's a threat of a referral for prosecution if Mr. Carrim does not appear again, whether advised or not advised, to not appear based on his medical condition. All I'll say in that regard is if the Commission feels, and when I say Commission, I mean the evidence leaders through the Secretary, or is it through the Chairperson through the Secretary, feels that an offence has been committed and that a referral for prosecution must be made, then the evidence leaders must do what they deem appropriate, and Mr. Carrim will also do what he deems appropriate, including leading evidence, whether at a pre-prosecution decision stage in front of the NDPP or at a post-prosecution decision stage in court, that he was medically and legally advised throughout, and that any prosecution will fail because there's an absence of willfulness, and that will be demonstrated on the evidence. But I don't think you have to worry about that so much. That's out of your hands once any such recommendation would be made. I'd also just point out, and I'm trying to sweep now in the 15 seconds I have left, I just want to point out three interrelated propositions, if I may. The first one is that you will know on the last occasion, not when my learned friend Ms. Hassam was here, but when my learned friend Mr. Chaskelson, who's not in his usual place today, was here, there was some debate between whether or not, if Mr. Carrim doesn't appear in front of the Commission again, and Chair, this takes us back to our recollections may vary, because what I seem to remember is after you and I had that discussion about voluntary versus compelled, the discussion then moved to what are the inferences that can be drawn in the ordinary course about the so-called unanswered questions that Mr. Carrim would not have answered by the end of this process if he never comes to the Commission again. I see the chair is nodding, so at least I'm remembering that correctly, I think. But the point that I would make is at that time, and in its letter of the 24th of June, the Commission's evidence leaders were emphatic that if Mr. Carrim doesn't come again, they're not going to entertain this business about a postponement or no postponement. They were going to ask the Commission to make conclusions, or even on an inferential basis, on the basis of those unanswered pieces of evidence, and if necessary, to make a recommendation. And all I would point out is that the sudden change in now seeking to compel Mr. Carrim here seems to stand at odds with that, and the Commission must take whatever decision it wants to take regarding how it deals with Mr. Carrim in circumstances where it has direct evidence in front of it explaining his non-attendance, as it were. The last 2 points I'll make, and it is really the last 2 points, I'm 1 minute over time, is that there are many new allegations that are introduced in the answering affidavit of the Commission. And you know that on the papers, and particularly in the correspondence, I'm going to use my favorite A word again, there's a statement made about trial ambush in the sense that not the entire case is sought to be answered is made clearly for Mr. Carrim and his legal team and the deponents on his behalf to answer, and then they are ambushed after the fact to say that you've failed to answer this or that you're being deliberately misleading or inaccurate, whereas there are innocent explanations for these things. And if the Commission just showed its hand earlier, then it could have been dealt with earlier, and we wouldn't need to go 17 rounds in exchanging affidavits and supplementary affidavits, because we'd know the case to meet. Chair, you'd remember you said to Mr. Chaskelson the last time, put it on a piece of paper, those questions you want answered, that was supplemented by Commissioner Khumalo. It's the same complaint, with all due respect, that we shouldn't be drip-fed information. We should know what the Commission has in mind so we can be helpful to the Commission in answering whatever we can, whenever we can. And lastly, may I just say that on the issue of the relief, the terms of the relief are obviously to be finalized, but on the underlying request for the postponement to a specified date or to some other date is ultimately unopposed. And that's Mr. Carrim's submissions in 1 hour and a bit. Thank you, Chair. 1 hour and 3 minutes.
Oh, thank you very much, Mr. Premier. Let me just take you to page 24.
I'm there.
Yes. Please read paragraph 67.2. And after that, 67.3.
Yes.
And also go to 71. Read 71. I'm not reading these because...
I understand why.
Chair,
yes.
sorry to interrupt, but what page are you referring to?
25.
I said 24 initially, and then it's 24. Page 24 was the first reference.
67.2
Paragraph
and
67.2. And then 67.3. And then I was moving on to the next page, 25, paragraph 71. Now, I want to ask a question that relates to the information that has been asked for repeatedly, which is the name or names of the auditors/accountants of Mr. Carrim's companies. That's number one. Number two, the financial statements of those companies. That information was asked for a long time ago, I think in March already. I think initially when Mr. Carrim was testifying here on the 8th and 9th of March, I think, and he promised or undertook to furnish that information. In fact, I think in respect of the auditors, he furnished the name of an entity that eventually denied that it was auditing any of his companies. But subsequent to that, that is the oral undertaking in open session, there has been engagement on that issue, and Mr. Shaskalsin has repeatedly made the point about this information continuing to be outstanding and not being furnished. So it's something that's been out there in all of our minds. Now, I refer you to these 3 paragraphs to make the point that, one, the person mentioned in 67.2 is Mr. Carrim's PA. And she's even described as his quote-unquote virtual PA. Quite importantly, here's what is said about her. It is said that when Mr. Carrim's bank account or bank accounts, I'm not sure whether it was more than one, was aware in the process of being closed by F&B, this virtual PA played a very crucial role in that process. So it seems to me that this is someone who is closely involved in Mr. Carrim's affairs. Now, the other person mentioned in the other paragraphs is someone very close to Mr. Hassim and someone who has in his...
Mr. Carrim. Not Mr. Hassim.
Oh, I'm so sorry. I'm sorry, Mr. Hassim. And it's someone very close to Mr. Carrim and someone who has been appointed to run Mr. Carrim's businesses in his absence. Now, if you look at, which paragraph is it now? Let me see. Yeah, I think it's 20, content of page 25 about, oh gosh. I've lost my place now, but you will all know what I'm referring to. I just have page 25 now, I would imagine. I doubt that it's there, but maybe it is. But the point is this. The deponent to Mr. Carrim's affidavit, the founding affidavit says, I do not know the auditors of Mr. Carrim's affidavits. I think I can mention that it's his wife. What the ruling says should not be mentioned are the names, I think, and other identifying features.
He also has 2, so...
One of the wives is the deponent. Thank you. So that's the wife. She says, I do not know. And she says, nobody else knows. So this means the virtual PA, who I assume that as a PA, she must be working very closely with Mr. Carrim. And the fact that she even assisted very closely when the bank account or bank accounts were being closed shows the proximity. I do not see the basis on which Mr. Carrim, with regard to who the auditors are, would have been cagey about that information. Not to the PA. I do not see how he would have been. Also, I may not be able, because I do not know the historical involvement of the person now running the businesses prior to him doing so after appointment. I do not know his historical involvement in the companies. But point is, once involved, what would be so difficult in him getting information with regard to these two issues, who the accountants are, and even getting copies of the financial statements? Just what would the difficulty be? Also, this person who's now running the businesses is not the only person. There are other people who have been in place working in those companies. That information cannot reside in Mr. Carrim's head only. I find that very, very difficult to understand. In fact, I want to say this or suggest this to you, Mr. Premhead. You probably are aware of the Gauteng High Court judgment in the case of truth verification. If I'm not mistaken, I think it was written by an EL of AJ, not the old freaky EL of JP. And the principle enunciated in that case was later made or adopted by the Supreme Court of Appeal. But the point is this, and perhaps let me clarify up front, that that principle relates to respondents who make fanciful or patently false statements on affidavit. And that authority, jurisprudential authority, exists because on paper, where you do not test the testimony of witnesses in a witness box, it's very difficult for courts to say that person is not telling the truth. But the usefulness of this authority is this. It says, if what a witness says is either fanciful or patently false, it should be rejected out of hand and on paper without the need for oral testimony. So even if, as I say, this principle has been used in respect of respondents, I do not see why it cannot apply to applicants as well. Where am I going with this? I feel, as I sit here, subject to what you say, that the idea that nobody within these companies, in particular the person now running the businesses, and this PA, nobody can furnish this information. Nobody knows anything about this information. Subject to what you say, to my mind, this appears to be patently false. Your comment?
Natal Scrap Metal and Oxford University Press also endorsed that proposition on consideration of the Plascon-Evans test. So I don't know if those were the SCA authorities you had in mind.
That would have been a movement or a development on the Plascon-Evans.
No, but I know the proposition that you're making.
Yes.
Can I direct your attention to paginated page 74, particularly paragraph 40.1, as it relates to I'm using this word in inverted commas, an inference that is perhaps being made about the role and level and intensity of the EA or PA or whatever she's called, and the extent to which they might have business knowledge. And the starting point was, and Chair quoted it, was her involvement when the banking accounts were being closed and so on. With all due respect, I would suggest that 40.1 attenuates that because it speaks to the very limited and I'm going to say rubber stamp, and you'll understand why when you see that paragraph, that rubber stamp manner in which she acted. So I'm not sure, with all due respect, in terms of what is in front of you on the evidence, that she does as intensive a role as perhaps Chair was suggesting. Obviously, Chair will draw his own conclusions.
Open quote, managed the replacement, close quote.
Yes,
that's an advised or conscious choice of word.
Yes, and then look at line
managed.
But look at line 3, how she managed it and that process. She had access to and used an electronic signature during that process. So the point is that her involvement, and I'm speaking carefully because I'm not giving evidence.
I'm not sure that the third line suggests that all that she did was to sign electronically. I'm not sure about that. I believe in context that that's mentioned as part of the things that she did. She signed. It doesn't suggest on my reading that all that she ever did was merely to sign electronically. That's not how I read this. She managed. Otherwise, manage would be meaningless if all that she did was just to sign.
I accept what you say, but I would also then ask you to go back to 67.2 on page 24, because if you look at who she works for, it's not Mr. Carrim himself, it's the wife. That's stated in that paragraph in the first sentence. And then you'll see what she does is, all she does is she screens my husband's calls and emails, liaises with the banks, including in relation to the closure and the replacement accounts, facilitates payment for staff.
Sorry, page?
24?
24.
The paragraph 67.2 that you took me to, Chair, at the beginning.
67.2.
Yes, point 2. So I was just saying that the first sentence contextualizes who she's actually working for. It's the wife, not Mr. Carrim per se. And then in the second sentence, you'll see what her activities involve. And her activities are described as screening husband's calls and emails, liaises with banks, including in relation to the account, and we've gone to that page already, facilitates payment of staff, and directs matters requiring attention to the appropriate person. So I accept Chair reads that in a different way to I do, because Chair says that's indicative of a more central role that perhaps suggests she could provide these answers or whatever the case is.
Yes,
I don't read it in the same way.
I do not see after, towards the end of the paragraph, what you've just read, I do not see how her role can be diminished, not with all of the things that are itemized there as her duties. I do not see how her role can be diminished.
I accept what Chair puts to be. I'd say it can be diminished because it's not a decision maker qua decision maker. It's clearly that she plays a supportive role. And so she doesn't have this as expansive ability as Chair is perhaps suggesting to do the kinds of things that Chair is speaking about. So that's the first thing I would say in respect to that individual. The other page I would ask Chair to look at, and I had it a second ago if you'll bear with me, is paginated page 351. And all I point out is paragraphs 51.1 and 51.2, particularly the last sentence on 51.2 on paginated page 351, because that in part speaks to Mr. Carrim and the ability to obtain that information and why even what has transpired before transpired in the way that it did. Insofar as the other individual which Chair mentioned, which is back at page 24, paragraph 67.3, if I'm not mistaken.
I think, was it not also 71? I've closed
Yes,
it.
no, 71 as well. That was on page. That was
Yes,
on page 25.
I meant paragraph, not page. I meant paragraph 71.
Paragraph 71, page 25,
Oh,
which
okay,
speaks to
okay.
the same individual that is mentioned
Yes.
in 67.3.
Okay, yeah.
Yes. Again, all I would say regarding this expansive role that he's playing or he's not playing is look at the fifth line in that paragraph 67.3, starting with he does not make. And I would say that that sentence is a direct answer to the chair regarding what he knows or doesn't know or couldn't know. In particular, that
Mr. Premier, providing information has nothing to do with making strategic decisions
Yes.
and new business decisions. It's historical information.
yes, indeed, which is why the sentence I was going to direct you to, Commissioner Kumalo, reads in terms, given his age, he does not possess the institutional knowledge of the businesses that resides with my husband. So even if you're interpreting that first sentence against me about providing information not being strategic decision-making, which I can accept, the second sentence in particular speaks in terms to his ability to provide the information or otherwise. If you reject the explanation on paper, that's what you'll do, but that's the evidence you have in front of you. So also insofar as the same individual is named at paragraph 71, page 25 is concerned, you have to read those two things consistently with all due respect, which says that the individual concerned is doing nothing other than acting in a holding pattern or in a holding capacity, but doesn't have the institutional knowledge going backwards and also doesn't have the strategic insight and knowledge going forwards. But I accept, Commissioner Kumalo, that might be an unsatisfactory explanation.
You have not answered the second part of my issue, which was, how can it be that within these institutions, all of them, there is not a single person who knows something about the accountants or auditors? How can that be? How can that be? How is it that this information resides only in Mr. Carrim's head?
I want to choose my words carefully because I'm not going to give evidence as to why that is or isn't the case. But I think it was Commissioner Baloy, you'll forgive me, on a previous occasion when Mr. Carrim was testifying, there was a debate between Commissioner Baloy and Mr. Carrim about how particular decisions are made or not made, and are there proper books of account, and what's the regularity of what's going on inside this business from a corporate perspective. And Mr. Carrim at that time did not say much other than to say how it appears in front of you is what it is. And without putting words in his mouth, all I will say is that businesses operate how businesses operate. They sometimes operate imperfectly. They sometimes operate less elegantly than they should operate. Whatever inference you want to draw from that, you will obviously draw, but the fact that it's not so elegant and bookkeeping or company board resolutions are not maintained in the way that the Companies Act wants them to be maintained is the very basis that most of us have a job as lawyers, because these things happen in the real world in the way that they happen. So I can't answer with a positive version as to what the chair puts to me, which is how is it that it can only be one or should there be others? I have no instructions in that regard, but having regard to what has previously occurred, where Mr. Carrim was put under some pressure, and I say that respectfully, put under some pressure to account for his business operations, which appeared to be less than perfect, he himself couldn't address that in any great detail other than to say that the businesses were and are what they are. And that's as far as I can take it, Chair. I mean, yeah, I'll leave it there.
Can you please assist me? I wrote only paragraph numbers of the doctor's report. Where does it start? Please assist me. I want to take you somewhere there.
Sorry, Chair, can I ask for a clarity? Is it one of the doctor's
The
reports or
very
the
first-
affidavits?
The affidavit, the very first one, not the supplement.
Paginated page 30, Chair.
30. Thank you, Mr. Premier. Oh gosh, how could I not have? Because I can't read this again, nor can I describe it because it will
Paragraph
go
number,
to
Chair.
the wrong terrain. Let me just see. Okay. Oh gosh, I'm sorry, I did not underline this. But I seriously want to engage you on this. I can't vocalize the point, otherwise it will. Can we take a 2-3 minute adjournment? Please, I want to vocalize this outside.
Okay.
Let's adjourn. think an explanation is owed to the public. This was not turning what I ruled would be an open session into an in-camera session. No. The reason for going out is that everybody will recall that earlier I asked on a totally different point or issue. I asked Mr. Premhead to read certain paragraphs for himself, and then I put questions to him. The reason for doing so was to avoid divulging the sort of information that I said, or in my ruling, should not be divulged. So that's why those paragraphs were not read publicly. Now, this time around, I wanted to do the same thing, that is refer Mr. Premhead to a paragraph for him to read for himself. The reasons were exactly the same. The problem this time around was that I did not find my correct note which directed me to the paragraph, and I was only able to find it once we were outside. So Mr. Premhead, I believe, has now already read the paragraphs. Now, here's my question, Mr. Premhead, and it relates to both paragraphs. Why is it that if Mr. Carrim could do what is stated in those paragraphs, why is it that he cannot likewise do what he has been required to do, which is to furnish the information that has been requested repeatedly?
Paginated page 45, paragraph 53.1. I can't read it for obvious reasons, but I'll ask that.
Oh, sorry. For the record, let me just mention, because I did refer you to paragraphs by paragraph number.
Yes.
This time around, for the question I've just asked, the relevant paragraphs are paragraph 25 and 66.
Chair, I think it was 69 on page 25, and then, oh, is it not?
Page 49, paragraph 66,
Yes.
and page 25, paragraph 69.
Yes, I did it, yes.
Yeah. Thank you.
Paragraph 25.
Thank you.
Yes.
Okay.
So that's the first answer, is the one that I gave, is paginated page 45, paragraph 53.1, which adds some color perhaps as to why something that is described as a simple issue or decision or divulgence is not as simple as it is. I would particularly ask the commissioners to look at the sentence beginning second comma on line 3 of that paragraph. That's the first part of the answer. The second part of the answer is paginated page 48.
Sorry, but what do you make of the word interactions there? Would that be the sort of interaction that the doctor is talking about here?
Yes, that's my submission.
Okay. All right. Please continue.
And on that page, if you look at the sentence beginning third, which is 4 lines from the bottom, that adds further color and context. The second answer I will give is paginated page 48, paragraph 65. It's a long paragraph, but the part of it I would want to emphasize is the last sentence starting at the top of page 49, which is just above the paragraph the chair referred me to, which is 66 on page 49. Starting rather. And it's 3 lines. So why I point your attention to those paragraphs is for 2 reasons. The first one is you've heard me already. I'm not going to repeat myself, but Chair views those 2 other individuals who I'm not going to name as having a greater role perhaps in the running of the businesses. I pointed out the fact that according to what the affidavits say, that is perhaps not correct, but obviously Chair will make his own assessment. And then the second reason I'm pointing you to these particular paragraphs is to say that even if it's as simple, in inverted commas, for an instruction to be given by Mr. Carrim to those individuals, those 2 paragraphs need to be borne in mind in respect of the instruction and the ability to give that instruction.
How I read this is this. What comes before 66, which is the paragraph I referred you to, what comes before 66 deals with why Mr. Carrim would ordinarily not be in a position to be of assistance. But what is in 66 qualifies all of that. It even uses by contrast. So it's contrasting what's stated in 66. So you can't read what comes before the contrast in isolation, as it were.
Yes, but with all due respect, I think if you look at 67, for example, the next paragraph down from 66, and if you look from the 4th last line from the bottom, regarding what the doctor says is his clinical opinion, then what Chair says to me is the qualification in 66 in respect of what comes above in respect of 65, which is the paragraph I relied on, is itself further qualified regarding Mr. Carrim and his ability, and what the inherent risk is throughout the proceedings. May I
ask this, and I hope this will be the last question I'm going to ask. Why is it that Mr. Carrim's founding affidavit, which is followed by a supplementary affidavit, does not deal with the... No, I will drop that.
Because it deals with that has to go to who the deponent is.
Yeah,
That's my answer.
I will drop that question.
But can I just say that my third answer to you, Chair, and this speaks to the context of the instructions that I said I would undertake to give. I'm reading from my phone and I'm paraphrasing, so this can be dealt with formally after the fact if needs to be, but I am told as follows. Contact was made by my attorney with the deponent of the founding affidavit, who contacted the treating doctor whilst he was consulting with Mr. Carrim. The purpose of that was to take an instruction on the issue that Chair and I were debating earlier. And we are advised that Mr. Carrim has suffered another medical incident and that no instructions can be obtained by him in respect of what Chair has put to me. and this is in the context of this facilitative process that we've been talking about. I'm also told that the clinician has expressed his frustration to Mr. Carrim's attorneys because, in his view, his client's position is deteriorating as a result of the pressure being put on him by his attorneys in respect of commission and commission business. And so what that relates to is exactly what I pointed out to you in those paragraphs I flagged, and that's the situation we find ourselves in.
I've remembered the question I wanted to ask. The mistake I made was to want to relate it to Mr. Carrim's wife, the deponent, to the affidavit. What I meant to do was to say, why is it that Mr. Carrim's doctor does not deal specifically with this issue? You will have noticed that...
About the, sorry, Chair, specifically the issue, the accountant-auditor issue.
Yes, why I raise it is because that's quite pertinent, and the doctor has dealt quite extensively with some matters of detail, even dealing with issues relating to his whereabouts. And if I read his reports correctly, I do not recall that he deals with this aspect at all, and to explain why Mr. Carrim cannot furnish the required information. I might be wrong. Maybe it's somewhere there. That is somewhere in the reports.
Well, and I think this is the best answer I can give you. If you look at paragraph 53 on paginated page 44, that will tell you about the doctor's intervention, so to speak, in Mr. Carrim's business affairs, or what he did in respect of Mr. Carrim's business affairs. A similar point is made.
But that's about him not running his businesses, which explains why someone else has been appointed.
Correct.
It doesn't answer the one issue. Such and such information is required by the Commission. So 53 does not answer that.
No, correct.
Yes.
But I was...
That's not running his business.
No, correct. The point that I was going to make is 53 and 55 on page 45 give you the context of how the doctor enters the equation, for lack of a better phrase, which is to give the family certain advice regarding what happens to the business. The doctor himself never says that he gets involved in the business per se. He has a facilitative role where it's appropriate to play a facilitative role. And there are instances where sometimes that facilitative role is more restrictive, not less restrictive. And the answer for that is that paragraph I gave you on that same page, paragraph 53.1, page 45. So the reason it's the best answer I can give you is because the doctor himself says that whatever matter has to go to Mr. Carrim through the doctor is not just simply relaying a telephone message or relaying a question, but that the doctor himself has to make a clinical assessment at that moment in time, for example, about whether the question, if put, would cause a deterioration or not, or whether, even if the question is put, the answer given is a good answer or a bad answer for whatever clinical views the doctor themselves may have. So I can't speak to why he did not deal with that specific issue isolated as a line item, but you've also heard me that when instructions, as a real-life example of what has happened when instructions were sought, but that adds context as to why he might not have dealt with it. That's as far as I can take it.
Thank you. That's my last question. Thank you, Mr. Premhead. Yes, Ms.
Thank you, Chair. Is it my turn now?
Apologies to Ms. Hassan.
There's
No,
1 hour and 51 minutes.
No. You. It was what, a couple of minutes only. So it was my. It was by 15 minutes. Ms. Hassim?
Chair, I will be extremely reasonable, and I won't ask for an equivalent amount of time
Yes,
as Mr.
which will
Premad.
end at what, 9 minutes to...
It's 9 minutes to 4 now.
Yeah, so 9 minutes to 5. Please, yes.
So, Chair, can I do this? Can I just address the last topic you were debating with my learned friend and just close that off? Because I was going to deal with it in any event in the course of my address. But since you are on it.
The way the issues, or we'll deal with that at the end. Maybe do that at the end. The issues about possible rulings. The two issues Mr. Premad raised right at the beginning.
No, I'm talking about what you were just debating now.
No, I'm saying I said I would raise those issues
Yes.
with you when you begin your
Yes,
argument.
yes.
Should I perhaps address those right at the end?
Those were the issue of the footage
Yes.
And the redaction of the record
and
through
the
you,
redaction
Chair.
of the record.
Yes. Oh.
Can I just deal with this topic that you were
Okay, all
debating,
right, all
and then
right.
I'll begin with those.
All right.
Turn to those rather. So just on this, because it's fresh in your mind, because you've just been having the debate with my learned friend. The few points I wish to make about it, because I must admit that I find it quite an extraordinary claim that has been continually held since the time the Commission first asked for those documents. Well, first of all, one is not even a document, it's just the name of the auditor. That's all. It's a very simple request. Why I say that I find it extraordinary is because that request was made as far back as when Mr. Carrim appeared in this commission. That was on 9 and 10 March. On 10 March, it was itemized what the specific, it would form part of a list of requests that we had. We itemized the requests. In fact, I'm sure if we go back to the transcript of the 10th of March, somewhere towards the end of the transcript, it will be there. So this request is months old. That's the first thing I'd like to say. The second thing is that if we look at paragraph 66 on page 23, the paragraph reads the first sentence. In fact, let me just read the paragraph. Before 13 April 2026, before 13 April 2026, my husband was fully involved in his businesses. And then she explains now what that involvement entailed. But there's no explanation to us as the evidence leaders or to the questions that have been posed by the commissioners why these documents and this information could not have been provided between 10 March and 13 April. There's just no answer to that. Instead, what my learned friend does is he goes to the various paragraphs that have been debated just now. For example, on page 74 of the paginated bundle, where the chair, I think it was the chair who directed my learned friend to paragraph 40.1 and the person and the PA and the issue of the FNB accounts. And my learned friend tries to say, well, actually it was just a rubber stamping exercise because all she did was place an electronic signature. That's not borne out by the text in that paragraph. That paragraph doesn't say that's all she did. It says that's one of the things she did, is that she appended an electronic signature. But that's not all she did. That's not what that paragraph says. And what my learned friend is doing is with respect, taking liberties with the construction of these various paragraphs, and he's straining to defend an indefensible proposition that there is nobody in the company or in any of these companies which do business in the amount of hundreds of millions of rands who can say who the auditor is or where to find the financial statements. And I'll just make one last point, because I mustn't, for the sake of completeness, on page 25 on the debate in paragraph 71, that his son has stood in for him. What that paragraph says is that he assumed overall responsibility for overseeing the businesses and ensuring that their operations continue in his absence. He is a central point of contact, attends to matters requiring attention, oversees the payment of expenses and the continued performance of existing obligations. And then read that with 67.3, which my learned friend went to explain, well, that the role of the son is that he doesn't make strategic decisions. Well, yes, that's true. 67.3 says he does not make strategic decisions or decisions concerning new business. So we're not making any queries in relation to new business. We're making a query that falls smack bang in the middle of what Mr. Carrim's son is responsible for, as articulated in paragraph 71. So those are our submissions on that particular topic. Now, I don't need to go there later on in my address. So, Chair, on the question of the redactions, we have no objection to that. On the question of the CCTV footage, what I'd like to say is that, and what I would like to make clear at the outset, is that the point of the evidence on Mr. Carrim's movements is not put up to try to disprove a psychiatric diagnosis. It's not put up to...
Chair, I must just interject.
I apologize. It slipped out.
This is now the second incident where slippage is occurring. It happened the last time as well. And I would ask through you, Chair, that the evidence leaders please pay extra special, careful attention to the choice of words, because of the exact reason we asked for an in-camera hearing. This is now the second occasion it's happened.
Chair, may I apologize? It's in the course of speaking off the cuff.
It should not happen. It simply should not. And as Mr. Premit says, this happened at the last hearing. Mr. Shaskalson did exactly the same thing.
I'm aware.
It should not happen.
My profound apologies. It was entirely unintentional.
Chair, may I just say, and I'm sorry to do this whilst my learned friend is now on her feet, but the fact that I've had to object has itself now drawn attention to something potentially. And so my client's rights are now really being prejudiced because, and I make no statement about Ms. Hassan, who is a consummate professional, and I fully accept it might have been an accidental slip. But even the fact that I've had to record the objection now elevates the issue and creates the very damage that we've tried to protect my client from. And I'm in an invidious position where I am where I am. And so I would ask, Chair, not that you can control the media or anybody else, but just to remind people about their responsibilities in what they say publicly regarding the impact that can have on the dignity and privacy rights of someone who's made an express claim for confidentiality to avoid this exact situation. And I'm sorry to interject my learned friend while she's on her feet, but I have to now place this on record as a matter of principle that we're heading into dangerous territory.
Thank you, Mr. Premit, for now, let's leave it at the point that I have made, the admonition that I have made, and let Ms. Hassim continue.
Thank you, Chair, and I do reiterate my apologies. It was entirely unintentional. It's difficult to take out from one's head all of the information we've been looking at and reading and dealing with over the last few days. What I wanted to say was that the point of putting up the evidence on the movements is not to disprove any diagnosis, not to use it to challenge the clinical findings of a treating doctor. But it is important because what it does is it bears directly on Mr. Carrim's demonstrated ability, his day-to-day functioning capacity. That's what the movements go to. And it also goes to something else, which is, and I'll come to it later, that it's about the reliability and completeness of the information that was before the treating doctor at the time when he deposed to the affidavits that we now have in this application. So that's the relevance of the movements.
Are you saying, because the issue as I understand now is about flighting or not flighting?
That's right. So,
are you saying you require flighting for purposes of what you've just explained?
No, Chair, it was just a preliminary point to explain why we go here at all, that it's not simply for the purpose of showing that Mr. Carrim was in fact in Durbanville on the 14th of July. It's not merely for that fact. It's more than that. But I can continue to make my submissions to the second point that I'm raising about day-to-day functioning without flighting the footage. I will make that.
That's exactly how I understand it. I do not see what stands in your way to make those submissions without flighting. I simply do not understand. But as you say, you've just said now, you are able to make those submissions. So
I'm perfectly.
Yes.
I don't need to rely on the footage in order to make those submissions.
Yeah.
And
because there's the admission by Mr. Carrim through the deponent, his wife, that he was indeed in Durbanville and at this particular shopping center. That he went to Woolworths and this other place. I can't pronounce that name starting with a K, with many vowels in it.
Kauai. So I'm going to talk about that evidence, but I don't need to flight the actual CCTV.
Thank you. So that takes care of Mr. Premi's, one of Mr. Premi's 2 points.
I think both, because we also have no objection to the redactions.
All right, thank you. There was, what was the third thing? Oh, yeah, there was the issue about the geolocations.
Oh, yes. I think in the context of the sensitivity of what we're dealing with, and perhaps, Chair, I should just refer to the ruling that you made yesterday, because that's the constraints that are governing my ability to make submissions to you candidly. So the ruling, Chair, would you indulge me reading out paragraph 2?
Please.
Because then it might help the public also understand why we're talking in this coded way. So paragraph 2.1 says the legal representatives of Mr. Carrim and the evidence leaders may not, during the hearing of the postponement application, mention Mr. Carrim's medical condition, the nature of the treatment he is receiving, the identity and nature of practice of the health professionals attending to Mr. Carrim in respect of the medical condition, and the medical facility where he is admitted. 2.2, publication or dissemination in any format of the information referred to in paragraph 2.1 is prohibited. 2.3, the legal representatives of Mr. Carrim and the evidence leaders may not, during the hearing of the postponement application, mention the names and residential and business addresses of Mr. Carrim's family members. That's the relevant part of the ruling. So, Chair, I am not going to flight the geolocation spreadsheets. They are in our papers. Everyone on Mr. Carrim's legal team side has seen it. The commissions have it. I don't think it's necessary to do that. I think if we were to do that, we would run into trouble. It's not possible to redact every single entry, and some entries are relevant to where perhaps Mr. Carrim's family members are. So we won't flight that either. So, Chair, and then consistent with this ruling, what I propose to do is, and I'm going to try to stick to a script a little bit, because when we are in open debate, then mistakes happen. With your approval, I intend to refer to the two doctors as Dr. Initial and Dr. Initial, to distinguish between the two. Would that be acceptable to the chair?
Why not use the first doctor and second doctor?
Okay. Okay.
And you can simply say, for example, the first doctor being the one with the substantial reports that we have in front of us. And I'm not even sure who the second doctor is.
Could I say our doctor, our expert, and their doctor?
Good.
Something like that. Okay.
Thank you.
All right, so I'll proceed in that fashion then. I think the next and the point, and it was the first point that was raised, substantive point that was raised by a learned friend, was that somehow we're not really opposing the evidence leaders, the postponement application, but and that we've conceded something. I'm not sure how that arises. The heart of our opposition as the evidence leaders is that the Commission should not grant a postponement without requiring an independent medical examination. That is the heart of the opposition by the evidence leaders to a postponement. And the reason for that is because we've had a history of postponements where the length of time that we are told that Mr. Carrim will be incapacitated has varied and grown each time. So in the beginning, it was a few weeks, then it was 8 to 12 weeks, then it was 6 months in the latest round of affidavits. So it's very important to the evidence leaders that we have a fixed date for the postponement, number one, and number two, that postponement is conditioned on an independent medical examination. I'd remind the commissioners that this is the 5th postponement that Mr. Carrim seeks, and we've set out the history of the delay at paragraphs 7 to 24 of our written submissions. I'm just going to turn to those submissions. I don't need to go through the details. All I'll point out is that what one sees when one looks through the history of that correspondence and the postponements and the delays is that Mr. Carrim's attorneys seem to believe that a postponement is available for the asking. One example of that is at page 67 of the correspondence bundle. If we could just look at page 67 of the correspondence bundle. And if you look at paragraph 9, this is a letter that was dated 13 May 2026 from Mr. Carrim's attorneys. If you look at paragraph 9, it was again in an attempt to get a postponement of the next hearing. And all we are told in paragraph 9 is we confirm that that we have now received the further medical report. This report is highly personal. Suffice to state that our client has been laid off for at least 8 to 12 weeks, and that was all. No medical certificate or report or note or anything accompanied this. It required requests from the attorneys for the Commission to obtain the necessary medical report to underpin the postponement request that was made. So that's the history that we're dealing with here, which is why the evidence leaders feel so strongly that getting finality and a specific date is so critical. We then come to the latest. I'd rather go to the most recent history on the postponements. The last postponement was to 15 July. Up until that point, all of the postponements were granted, were permitted, on the understanding by the Commission and the evidence leaders that Mr. Carrim was hospitalized and that his movement was restricted. That's what we were led to believe. It was only when there were the 2 whistleblower reports on the 14th of July that the issue of Mr. Carrim's movements were put into question. The evidence leaders then obtained the CCTV footage to corroborate what we'd been told by the whistleblowers. Mr. Carrim was then afforded the opportunity to bring a substantive application for the postponement. And in that application, an opportunity was provided to address the latest information regarding Mr. Carrim's movements around the Cape. And this is addressed in 2 affidavits. The one, as we've already been talking about, is by his second wife, and the second affidavit is by his doctor. What we were told in those affidavits is important. Their accounts, and I'm not going to go into the detail, it's summarized at paragraphs 39 to 44 of Ms. Berger's answering affidavit. What we saw there was a particular picture that was painted by the 2 deponents, and particularly by Mr. Carrim's doctor. That picture was one of restrictions on Mr. Carrim's movements and interactions. We were informed that any leave from the hospital would be authorized for specific purposes, that there were passes that were subject to strict conditions, including searches, etc., including on the return of the 14 July excursion, which was said to have been a 4-hour chaperoned excursion that took place between 1:30 in the afternoon and 5 p.m. in the afternoon. That was the account that was provided by their doctor. It was supported by Mr. Carrim's wife. Now, it's important, commissioners, to go to those affidavits. So let's look first at what Mr. Carrim's wife says, and that's at paragraph 60 of the founding affidavit. if I could ask the commissioners to read paragraph 60 and its subparagraphs, where the 14 July incident is explained. I'd like to place emphasis on 60.2, where it says, we departed the facility at 1:30. Then 60.3, and the description of the Kauai engagement. 60.4, and 60.6, specifically where it says we returned to the facility by approximately 5. And then there was a consultation that they both, I've emphasized the word we in 60.6, attended. In paragraph 73 of the same affidavit, the deponent summarizes all travel since 13 April 2026. And I draw your attention to paragraph 74, where the deponent says, my husband undertook no other travel during this period and did not travel to Mahikeng or any other location in the Northwest. There's a second affidavit, which I'm going to come to, in which this is a different picture is painted. And what the deponent says later is that that trip to the Northwest took place during the week when Mr. Carrim is with his first wife. And so, says the deponent, she did not know about the trip, and that's why she didn't say anything about it. What my submission on that is that that's implausible when we have regard to her own evidence that she communicates regularly with the first wife, and you'll see that at paragraph 15 of this affidavit, of the founding affidavit.
But what about the fact that she says this was the first wife's week, and that she might have missed this visit to Mafikeng or Mahikeng because of that fact?
Yes. I'm saying it's not plausible because they communicate regularly. She explains in paragraph 15 that they communicate, she and the first wife, including about...
Does that mean every and anything?
No.
Of necessity?
No, Chair. So let me then go to paragraph 15. It's because what they communicate about is Mr. Karim's well-being.
Yes, yes.
And his health.
Yes.
And updates on...
But as I understand it, it was Mr. Carrim who wanted to go there to see,
yes.
Was it his daughter, I think, to see
yes.
his
I have no objection.
His daughter.
Yes.
Now, so it wasn't as if I'll be with our husband in Mahikeng, but I'm concerned about his health because the travel might do this and that to him, in which event the first wife might have had to tell the second wife. Now, this is just a visit to the daughter, which was quite important to Mr. Carrim, because as I understood it, he had not seen her for...
Chair, we don't even need to get into that. We don't take issue with his wanting to visit.
But my point is, with nothing that has been suggested about his health and him going there, I do not see why it would have been necessary for the first wife to tell the second wife about the Mahikeng
for this
visit.
reason. for this reason, Chair, because there was a medical incident.
Sorry?
There was a medical incident.
By the way, which resulted in his...
In the second wife, accompanying
in
Mr.
his
Carrim.
return. In his
Correct.
return. Okay.
Correct.
No, I get it. I'd forgotten about the sudden need for him to return. Yeah.
That's right. And it was the deponent who took Mr. Carrim to the doctor and accompanied him and was with him during the consultation. And so that's why I say.
So your point is it's unlikely that the second wife would have forgotten about this incident.
It was specific.
Yes.
I'll tell you why.
Yes,
Because it wasn't a broad question, tell us about the movements. It was a specific question was asked about movements to the northwest, because that was something that became contentious.
No, I get the point.
Then we have the doctor's version on the 14th July in his first affidavit. And we'll find that at paragraph 45, and I think it's page 43. 43, thank you. So in paragraph 45 is where the description of the 14th July incident is. And what's important here is the confirmation that it was 4 hours, that it was for the purpose of purchasing toiletries, over-the-counter flu medication. In 46, the doctor says, in terms, the facility's records reflect that he departed at approximately 1:30 and returned at approximately 5. He goes on to say he doesn't know anything further about the precise movements during the 4-hour period for which it was authorized. And then says, but in any event, these kind of excursions are not unusual. I'd also like to take the Commission to paragraph 39 of the affidavit of the doctor, because, and that's at page 41. Here too, the doctor says, in terms, I deal next with the facility's leave regime, because I understand that an impression may exist that the facility is a place a patient may enter and leave at will. That impression would be false. And then he explains there's only 1 or 2 ways that a person could leave on the pass of the treating doctor. Or the only other way is if the person discharges himself. What happened next was that the evidence leaders obtained geolocation data. That's the data of Mr. Carrim's cell phone that tracks the movements of the phone. We know from the first from the first deponent that Mr. Carrim keeps his phone with him. We presented that information to Mr. Carrim's legal representatives on the 17th of July. That then prompted 2 further affidavits. So if I can just go to the first, it's the supporting founding affidavit. Sorry, it's not supporting, it's a supplementary founding. What we see now, what page is it on? It's page 58.
That's where it starts. You want to take us to which?
To the paragraph. I'll do that, Chair.
Oh, all right.
Just trying to find my own reference. Right, I've got it. It starts at paragraph 27. Page 67. And that's where the account is amended. It's confirmed in paragraph 27 that Mr. Carrim was at a shopping centre, that he was at Woolworths, that he was at, she says he then purchased a meal from Kwai, finished his meal at Kwai, and thereafter obtained flu medication. He was supervised throughout by his security detail.
And an important contrast here is that he did not buy a takeaway and go and eat in his car. He actually sat down, had a meal in Kwai or whatever it's called.
Yes. Yes, at Kwai,
The owners will not be happy with me.
I think they'll be very happy with the free advertisement that they're getting. But so, Chair, the discrepancies are, that's the one. The second is that if you look at page 68, paragraph 28.3, I'm not going to, I can't read it out.
But is the second point you want to make the fact that this pass was not was it 4 hours, the shorter period mentioned? It was not for that, but
Much longer period of time.
Basically, I may be exaggerating if I say close to the entire day.
It was
8 hours or upwards.
It was almost
of 8
12 hours.
12. Yeah.
So, as confirmed by this deponent, who says when he arrived at where she was in the morning.
I'm doing that. That is going straight to the number of hours to avoid reading. But
Okay.
I'm not even sure that that's what you wanted to read.
No, that's the second point, which
Yes,
is that
yes.
the discrepancy in the time.
The hours were much longer
Yes.
than what was.
So it's two. It's the time of departure and then the time of return, which was about.
And the fact that they did not depart together, which is what was in the first affidavit.
The first one was the we that I'd emphasized. They did not depart together. And the second thing is that they did not consult together either with the doctor upon return. And then the final thing is that consultation took place much later at night than just after 5 o'clock. The deponent also corrects the facts on the travel on the 9th and 10th June to the northwest. And what, yes, those really are the main things that I wanted to make clear from the first deponent's affidavit. The final thing I'll say is that she does also confirm, and that's at paragraph 20 of her affidavit, and this is important given the replying affidavit that came later last night. Paragraph 20 is yes, page 65, where the deponent confirms in the middle of the paragraph, I am unable to identify every such occasion, and that is travel and leave excursions from the facility. Subject to this qualification, she says, I accept that the geolocation data generally reflects my husband's movements. I do not dispute the accuracy of the data or seek to explain it away. We've explained in the answering affidavit the analysis of the maps and the geolocation data and what they show. And what they show is that almost every single day, Mr. Carrim leaves the facility. And that on most days, he's out of the facility for at least 8 hours, sometimes longer. So which is what my learned friend was objecting to, the inverse inpatient reference that was made in the answering affidavit, was that he spends more time outside of the facility than he does inside the facility, is really the point of that. So what we get now is a materially different picture from what we first had. And when I say what we first had, I'm saying let's go back. I'm not going to do it now, but if you go way back into history from April, the picture keeps fluctuating. And it fluctuates recently when Mr. Carrim's, when the deponents are provided with objective information from the Commission that changes the version that they initially gave. So that information is not information that is in our knowledge. That's within their knowledge.
Please continue.
So what the crux of the point here is, Chair, is that these shifting accounts in the affidavit are important because they show that each time that the deponents are presented with, confronted with objective evidence concerning Mr. Carrim's movements, the explanation changes. Second, and this is important because of the ruling that we seek from the Commission, it underscores why an independent medical opinion is now imperative. And without impugning their doctor's integrity or professionalism, it's apparent that he has not been placed in full possession of the facts concerning Mr. Carrim's comings and goings from the facility. So his own medical assessment and the report that was furnished to the Commission appears to have been based on a flawed factual foundation. So that's another reason we say that the independent medical opinion is required.
The doctor, you've referred us to 4841, where the doctor states that a patient may only leave and underline only in one of two ways, which is a pass by the doctor. And also if a patient wants to discharge themselves. But in the later, should I call it what, a supplementary affidavit?
Yes.
In that one, the doctor now makes a suggestion that other people may, I hope I understood it correctly, other people may, I don't know whether actually issue passes or allow a patient to go out, but other people now are involved. Whereas in 40, he said only only one of two ways, a pass by the doctor or.
So now what the doctor says, and it's at paragraph 16 specifically, is that if he's not available, then the nurses will authorize.
That's the point I'm making. Thank you. Yes.
So which is a very fundamental change from the first affidavit. You don't need to have been presented with this data that we provided him with of the geolocation of the phone and the movements that we obtained independently in order to make an accurate statement from the get-go about how movements take place in the facility.
And it is quite telling that you have these movements in the allegations on Mr. Carrim's side, not by one person only. The second wife also moves or changes her allegations once confronted by facts that contradict what she says. And unfortunately, this is happening with the doctor as well. A patient may lawfully leave the facility in only one of two ways. But later, once we have the geolocation and the times when Mr. Carrim would be out of the facility, and suggestions of much, much longer times than what we were made to, or given to understand, the doctor as well, just like the first wife, moves and changes, and now tells us about the possibility of nurses also issuing passes.
So we didn't ask for the specific question of passes to be addressed in the founding affidavit. That was done of the doctor's own volition. So if the doctor is providing an account of how the system works, why was that not part of the account in the first place? Why did it come up only when presented with different evidence? The second thing is that, and that's why I read it out earlier and said, he said so in terms that the facility records will show entry and exit. That changes in the second affidavit. And you'll find that at paragraph 18 of the supplementary affidavit.
That's at page?
Page 84, I'm told. So just paragraph 16 on that page is the nurses. And then paragraph 18 is where the doctor explains that, in fact, what he said wasn't correct because the facility protocol is not followed, that, in fact, the practice of keeping records is that it's just not honored. There aren't any records. The doctor also tells us that he himself doesn't keep records. He doesn't keep his own notes of when he issues or authorizes pass-outs. But he only tells us that in the second affidavit. Sorry. Bear with me, Chair, please. I'm trying not to make a mistake again, so I'm going a little more slowly. The most charitable interpretation of the doctor, he is relying on what Mr. Carrim tells him about his movements. He now knows that he's not being told the truth about the movements. But all those facts were the facts that he based his information on when he gave us these reports. Those reports do not hold true anymore. So my learned friends...
although that charitable interpretation would not apply to the categorical statement that doctor makes, which is people go out only, and he specifies the circumstances under. Yes. So your charitable interpretation cannot apply.
Maybe I'm being too charitable. But the point
I'm not suggesting you should not be, but I'm just saying it cannot apply to that categorical statement.
No, it can't. Nor to the. I'll leave it there. I agree with the chair on that. My submissions are more to what it means then for the opinion that he expresses, in which he says to the Commission, this is the difficulty and again, what I wished to say at the outset was that the point of it is not to challenge the diagnosis. It's to say, what we're concerned about is functionality. What is Mr. Carrim's ability to engage with questions and information and evidence that may need to be provided to the Commission? That's what we're concerned about. We're not concerned with dislodging anything else, although it may become necessary, and I'm not going to preempt the independent medical assessment that will come. That will give us a better picture, of course. So we can't rely on that. So to say that this report by the doctor is definitive falls on that basis. But the argument that the doctor's report is definitive is also extraordinary for another reason, because it itself is a breach of the professional guidelines that are referred to by our doctor in his affidavit.
I assume you will obviously address the issue raised by Mr. Premhid, that applies in the context of forensic what? Yeah, which Mr. Premhid submits. That's not the instance here.
In fact, it's exact opposite. It is exactly the circumstance here. I'm coming to that doctor's report, but it's precisely, those guidelines were prepared for precisely the scenario that we're facing today. So I'll come to that. For now, what I wish to say...
I must say, I didn't quite understand why this is not forensic, and which is why I put the question to Mr. Premhid, but we'll hear you when you get there.
Thanks, Chair. What my learned friend argues is we must accept the opinion of their doctor. That opinion, as we will see when we get to our experts' report, is provided in breach of those guidelines, those professional guidelines, which say that a treating doctor should not be the person to provide an independent assessment, and of this is the critical thing, of the individual's, the patient's capacity, which the Commission is expected to consider, right? The objective determination of the capacity. So we're not talking about diagnosis, but it's about objective assessment of that person's capacity to participate in these proceedings. The guidelines say that it should not be provided by the treating doctor because the treating doctor is inherently subjective and an advocate for the patient, and I'll come to it because he says more things, and I'd rather refer directly to what our expert says. But so that's the thing. This is the first thing, right? But we must accept it, says my learned friend. And then what they say is, and with the support of their doctor, they say that then the witness must be insulated from any examination by an independent specialist. And no one is able to then assess whether that conflicted, what we say is a conflicted determination of capacity by the treating doctor is in fact reliable. Because we've gone through the passages, I'm not going to go back there, the paragraph 73 and 73 of their doctor's affidavit saying that there should not be an independent examination. I don't know yet where we stand on, I know there was a discussion about interposition of another physician, etc. That's not what we are proposing in any event. We're proposing something that is entirely squarely within the professional guidelines. So they say, and they've been saying to us, and Chair, let me just say in response to the question you posed to my learned friend about, sorry,
I wanted to, don't forget the point you wanted to address now. But I wanted to say, is it not semantics to say the IM, is it E?
Yes.
That the IME issue differs from interposing a different doctor? I don't quite see the difference you appear to be seeking to draw, because you would still be bringing in a doctor that's not the treating doctor.
That's right.
So why you would say that's not interposing another doctor, I don't quite, it's not a serious issue really. It's
maybe not, but it's important because we want to address the concerns that have been raised.
Okay, all right.
And it has been addressed by our expert, who explains that doctor doesn't take over the treatment of the individual.
The suggestion about interposing is not about this doctor that's being interposed, taking over. It's not about that. It's just for purposes of also doing an assessment.
Yes.
with a view to either confirming or not confirming what the treating doctor has said. So I'm not quite sure that I get. I still do not get the difference you are seeking.
Okay, that was my understanding of the difference. But if the interposition goes to what the chair is now saying to me, which would include that, well, then
that's all I meant when I used the word interpose. That's all I meant.
Well, what the guidelines say is that it's not only permissible, it is required that there is an interposition then, in the sense that there's an independent assessment that's testing for a particular outcome, and that's why it's forensic. So
back to your point then, the point you wanted to make. I hope you have not forgotten it.
Well, Chair, oh, yes. Chair, you posed a question to my learned friend about the lack of a response to the evidence leader's request for an independent examination, and we've set it out in the answering affidavit. There was a correspondence from I think, May, if not earlier, in which that was requested.
And don't forget that correspondence was preceded by an undertaking by Mr. Carrim sitting in that witness box. So there's that, and then the correspondence.
And then the correspondence, which went unanswered on that point. We did get answers to other parts of our correspondence, but not to this. It's in our answering affidavit. This history is set out. Until we pressed for an answer on whether they would agree to an independent medical examination. It culminated in the hearing that took place, I think, on the 25th of June, which was the debate that you were having with Mr. Premid about what exactly was said in that hearing. And I think on that score, I'd rather just go back to the transcript and have a look at it. Our understanding was that there was an objection to an independent medical assessment, and it was quite plain in our understanding. But we can go back to the transcript and have a look at that.
May I request both counsel to furnish us, say, not later than the end of day tomorrow with the relevant part of the transcript?
Certainly, Chair.
Thank you.
So what we're told is, accept our guy, accept what his say-so. No, you can't have an independent assessment. And then it gets even more absurd, because the next claim is that no one is able to assess, the treating doctor's determination is unanswered. As we heard, well, it's unanswered, it's unchallenged. And so it must be accepted. So it's a circular reasoning in which...
It's exactly for that reason that I said it cannot lie in Mr. Carrim's mouth to say this is unanswered.
Yes.
Not in the face of what I understand to have gone on, but as I said, I accept that my recollection may be inaccurate.
Well, let me say this. I've not heard, and we know because apparently there was a need for an instruction, so there was never a response to that. At least from my learned friend's perspective, there was never a positive response to this, which is yes or no. So why not? That's the question. After so many requests, the stonewalling is no independent medical assessment, and then it's triumphantly, but you see, our doctor's unchallenged, and therefore you have to, and you, the commission, must be now bound by that doctor's assessment. So I think what I should now do, and I would say this, that if their doctor had given a response to our doctor's affidavit, we might have also, perhaps there would have been a shortcut through this. But there is no response. Our expert is unchallenged, in fact. And I'd like to go to our expert's report. What page is it on? Page 125 is
And
where the
please-
report
please
itself.
Be careful what you read.
So I'm going to go very slowly. And I think what I will do is just refer the commissioners and my learned friend to paragraphs of the report and try to deal with it in that way. But what I want to begin with saying is that this expert has attached his CV. He is the former chair of the professional association that regulates the very field in which their doctor practices. He's extremely experienced, and he is the co-author of the guidelines that he refers to in this report. I'd like to go to page 126, paragraph 5.
So maybe before you do that, if you could just refer to, without necessarily reading it, paragraph 3, because it sets out the purpose of this report. And I think it's important on the back of Mr. Premet saying that this expert has not countered.
Well, yes, no. So this expert was not asked to do an assessment on paper of Mr. Carrim, nor could he have been able to do so because all that he was provided with was their doctor's affidavit. And their doctor, which is something that I should actually point out because it does go to the reliability of that report, doesn't set out the details of things like the treatment protocol, etc. And I don't want to say too much more about that, but there isn't that kind of detail in any event. So it wouldn't have even been possible for our expert to give a meaningful opinion based on that affidavit, which wasn't setting out the full details of the condition. So what he was asked to do instead was to comment on whether the objection, on whether it is clinically appropriate not to have an independent medical examination. That's what he was asked to comment on, and specifically to comment on the objections that were made by their doctor about the interposition or whatever the interposition is defined as. So there was no request for it, Commissioner Baloy. And he would not have been able to do it even if he was requested because of the lack of information. And so what he does at paragraph 5 is consider the affidavit and the objections. And in paragraph 7, you'll see that he respectfully disagrees.
I noticed that your time is up.
My goodness. Chair, I now have to claim equality of arms.
Sorry, by how much did you overrun, Mr. Premier?
51 minutes.
No. I'm not talking. I'm not talking. Remember, right at the end, after Mr. Premier had said he was done, I'm referring to that stage. Not when we then engaged him, after he had said he was done. So the overrun relates to before that lengthy...
Yes, it was 3 minutes or something like that. The additional 50 minutes comes from the panel's engagement with me.
I'm not even counting.
Agreed. So equality of arms is 3 minutes, they're not 51.
Miss, how much longer do you want to be? Considering fairness to Mr. Premier, I may have to increase the 15-minute reply, time for reply.
A very charitable approach, Chair.
But how much
I'm indebted.
But
how much do you...
what I'll try to do is spend less time on the legal principles. They're set out very clearly, I think. In the heads.
Take that as read. Take those as read.
So may I have 10 minutes, Chair?
All right, 10 minutes then.
And if I can do it in less time, I will. And one way to do it is to refer the commissioners to the paragraphs, the relevant paragraphs of our experts' affidavit. The statement, it speaks for itself.
Yeah.
The disagreement is in two respects. One is that it disagrees that an independent opinion should not be obtained, and second, he disagrees that if there were to be an interposition, that there would be therapeutic harm. In fact, he says not to do so, to require the treating doctor to provide the opinion threatens that therapeutic relationship between the doctor and his patient. So I'm just going to say paragraph 10.
At page 127.
Page 127, if the commissioners could just read paragraph 10. I can't deal with it reliably. It would be too risky. But it explains why the independent medical examination has become part of the necessary part of the guidelines, because you need an objective view in the context of.
Okay, you've made the point that it deals with why. We'll just focus our minds on that.
Yes.
You don't need to go through it.
And specifically, just one sentence. These challenges, I'm not going to say what the why are the challenges, but these challenges, if you read in the middle of the paragraph, may hamper the goal of insurers and the courts making sound decisions.
All right.
And then I recommend paragraph 11 at page 128.
Okay, we see that.
And paragraph 14. And then finally, paragraph 19, the conclusion.
Got that.
Then, Chair, what I would also commend to the Commission is the actual publication, which is attached to the report. I'm not going to go there. It's a minefield. There are just bombs all over it, and I don't want to make another mistake, but it's an important report. What I want to say about that report, it's published in the journal of the field, is that it's authored by several highly regarded experts in the field, and it's...
I saw reference to it saying international. Am I mistaken? Or am I thinking about anything? I did not see peer-reviewed.
I believe it is a peer-reviewed journal. Okay. But I could be, I'll stand to be corrected, and I can double-check whether it is, in fact. It is the journal of the profession. Mm-hmm. It's accredited. I saw that. Mm-hmm. I can't remember if it said peer-reviewed.
In our field, in the legal field, it would never be accredited if it is not peer-reviewed.
Indeed, yeah. Indeed so. So, and the one other thing you might have seen is the reference, because part of the literature, this is not a purely South African approach, these guidelines. So this report, these guidelines that are published in the journal also rely on medical literature from other parts of the world. And we referred to one, in fact, we pulled out an abstract of that article for the assistance of the Commission to show that this is not something that is unique to, it's not something that comes out of Mr. Expert's head. I'm stopping on that now. Yes. All that remains then for me, all that remains then, this is the most harrowing submissions I've ever had to make given the constraints of the ruling. And so I'm going to now draw to a close very quickly, because all that remains for me to say is that we've set out the authorities. The closest analog is the Kwelane judgment by the Constitutional Court. It's in our heads of argument. That judgment also cites very established principles on postponement, which requirements of postponement applications, which I've no doubt the commissioners can recite in their sleep. But importantly, what it says is that if there's a request for a second opinion and an independent medical opinion, that should be permitted. And the foreign authorities support the same, and then, of course, Michael versus Linksfield and so on, that a commission and a tribunal and a court are not bound by an expert opinion. The foreign authorities are useful because they are in a similar field as to the condition with which we are dealing with here, and it explains what the standard is for sufficiency of evidence and, importantly, independent expert evidence on the issue. And so I commend to the Commission those judgments. And
I wanted to clarify your expert's report, because you refer to it in the evidence leader's affidavit. You say there's no reply to what you refer to.
There's no reply to our expert.
Yes.
That's correct. I mean, other than what we've heard from Mr. Premid, I mean, their doctor, their expert, hasn't challenged the affidavit. So, Chair, we request that a postponement on the Never Never must be rejected. We request that the 14th of August be fixed as a date for Mr. Carrim to appear, and that in the intervening period, that there is an appointment of an independent medical examiner who will provide a report, and that might affect then the date of the 14th of August, but at least it will be on the basis of an independent expert. Thank you, Chair.
Thank you, Ms. Sim. Can we take a short adjournment? I won't indicate a time. We'll indicate when we are ready. Let's adjourn. Mr. Premier, 20 minutes?
Chair, very generous.
Thank you.
Chair, can I start where Ms. Hassam ended, that there's apparently been no reply to the Commission's experts' report? You'll find that reply at paragraph 16 of the replying affidavit, at pages 334 to 335, which I'm not going to read for obvious reasons, except to please point your specific attention to what is said at paragraph 335, on page 335 at paragraph 17 and paragraph 18. Because with all due respect, several inaccuracies have been raised about the quality of the affidavits and the reports presented by the treating doctor. And even though my learned friend says that the Commission is not impugning the treating doctor, in effect, that's exactly what they're doing, both his bona fides and his clinical expertise. And in the affidavit that is filed and those paragraphs and pages I referred you to, and that it's confirmed by the doctor himself, that's the full answer. In fact, what our doctor says in response to their doctor, if I can use that phraseology, is that it actually confirms our doctor's position, which is if there's going to be any such interposition, that our doctor has to be involved in that process. And in fact, if we read their doctor's report, their doctor says exactly the same thing in terms. If I'm not mistaken, at paginated page 129 and paginated page 130, this is of their doctor's report, he actually says the following: the Commission should even advise the independent doctor that the treating doctor is the treating doctor, wishes to be engaged by the independent doctor. And he goes on to say, in my experience, I have done something similar. He goes on to say at page 130, it is my opinion that the engagement between the independent doctor and the treating doctor should occur before the interview by the treating doctor, the independent doctor, so that the independent doctor understands the treatment plan, etc. So the point is, and why, and this chair goes to that IME forensic distinction, is to say the kind of exercise that the Commission's doctor is speaking to is a different exercise to be performed by an independent clinician. Our doctor has never pretended once to be performing an independent medical assessment inquiry. He is the treating doctor, and he's giving his clinical opinions. And this report does not dislodge that. All it says is that if there's going to be the subsequent process, this is how it must be, it must occur. And whilst I'm there, in response to this question about the instructions and why was it never responded to voluntarily or not voluntarily, when Chair and the Commissioners read the correspondence bundle, you'll read the correspondence bundle at page 123, going on to page 124. And at page 123, all I'll emphasize is that paragraph 10.1, which says, before our client takes a final position on the Commission's request for independent examination, the evidence leaders are required to identify a series of things, and then over the page, it goes on to 10.2. I only highlight that because it's not as if it's accurate to say that there's been no response. Consistent, Chair, with the debate that we've had before, can it be voluntary? Can it be compulsory? Do you have a power to even order a voluntary one? Those are what those questions are directed to. And with all due respect to the Commission and the evidence leaders, there hasn't been a response to that. So never mind what I put on the record earlier regarding the medical incident of my client when an instruction was to be taken. It's actually the evidence leaders who haven't responded materially to those questions, which my client expressly says through his attorneys will allow us to take a final position on this question of the medical examination. Because of course, Chair, if there are insufficient answers to those questions, particularly the question at 10.2 in bold, which is on page 124, statutory authority, it doesn't matter whether it's voluntary or compelled. If you don't have the power, you don't have the power. That's an ultra vires question, admin law 101. So on the question of whether there's this medical exam or not, that's the fullness of the answer.
That's exactly the level at which you and I engaged the virus
Correct.
question. Is there power?
Correct.
And in a sense, once that issue is raised, you have no power. That would supersede or not the conditionalities at page 123.
Correct. It would. But the point that I would make in that regard is that if the Commission believes it has the power, then it must exercise its power and do so. But we can't be caught in an endless loop where the question is asked, where's your power? There's no direct answer, and then you get accused of not answering the question or giving a position where knowing the source of the power is a fundamental issue that requires clarification. And obviously, if the Commission decides it has the power and makes such a directive, and there's a challenge to be raised to that power and the exercise of the power, then the challenge will be raised. But it's all this indirect inferential reasoning rather than directly dealing with the issues that I'm raising here in the context of what I've just flagged with you, Chair. That takes care of a few of my submissions. Let me move on to the next few. What my learned friend said at the beginning of her address is that it's an extraordinary claim that we've made that our client is unable to give the information that was sought as far back as March. Now, I'm not going to argue the point. I'm just going to direct your attention to medical opinion, which has not been contradicted. The first of that medical opinion you'll find at page 37 of the record, paragraph 26. And I would emphasize that when you read, look at what it says as lines 2, 3, and 4, starting with it materially and ending with the words identified triggers. That's medical clinical opinion as to what or why the information can't be given.
Mr. Premier, this doctor only saw your client from when? Because the period from March until 13 April, he cannot express an opinion on that. He simply does not know what the position was. He was not there.
I'll respond to you in 1 second, Commissioner Khumalo, if I may. Commissioner Khumalo, I've asked Ms. Madlanga to find a particular reference for me that answers your question, because my understanding of the doctor's position is that the phenomenon the doctor observed, diagnosed, and treated after he came on board as the treating doctor suggests that actually the condition could have arisen and materially impacted Mr. Carrim even prior to when it was diagnosed and treated thereafter. So I accept your...
Yeah, but that's speculation.
Well, it's... And with all due respect, I'm not sure if you can say that having regard to what the doctor has himself said, but be that as it may, if it's speculation or if it's not speculation, that can be tested. And the point of the matter is the doctor's view is that what I've observed from the incident when I came on board onwards suggests to me a long-term medical issue which may have impacted things before. I can't take it further than that. So I gave you the first reference to page 37, paragraph 26. The other reference I'll give you is on page 96 at paragraph 51. And I would ask you to start reading from about midway in that paragraph. In the 8th line, when it starts with the word when. And I would ask you to read after that next sentence in the 9th line that starts in a state of blank. And then it goes on to speak what a consequence of his giving information in those situations might result insofar as accuracy, reliability, recall, or anything else is concerned.
At what line do you stop?
Oh,
below when? Below the line starting when? At
No,
which
no,
line do
I'm
you
saying
stop?
the entire paragraph, but I was emphasizing those
okay.
particular portions, the one starting when, the one starting in a state of blank,
Okay.
and then the next one that starts with any information. The last reference, or second last reference I'll give you, is at paginated pages 48 and 49. I think we've been here already. We've gone through these paragraphs. I'll just give you the places where I would like your attention, please. Just look at what is said in paragraph 65 at the end of paginated page 48 that starts with, I had raised this concern. And what he says at the end of that page, interaction, words, 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 until the full stop. And then I would say, when you're looking at page 49 at the top, still paragraph 65, look at what is in the third last line that starts with rather, and what the conclusion is regarding any information that may have been given or may have been procured. Whilst you're at page 48, 49, please also look at paragraph 63, and then what follows. Commissioner Khumalo, I say expressly, I don't think that answers the challenge in the way that you put it to me, but I've asked Ms. Madlanga to find that reference. The pressure is on her now.
From 4 May, I get it.
Yes.
But from
No.
March, April.
I know. But what he does not say, importantly, is that the phenomenon only started on 4 May onwards, because it's an ongoing phenomenon that he's treating. But I take the point, and that's the response to you. You've already heard me on, are we impugning the doctor or aren't we impugning the doctor? May I just say this? This doctor has made himself available to the Commission in numerous instances. And the peculiarity of what we're dealing with here is, if you took one step back from listening to my learned friend's submissions and my submissions about who's expert and whose expert is correct, or whose one's medical opinion is of greater validity, you would almost be in a situation where we were in a trial where you were cross-examining two experts and running two experts' evidence against each other. As in expert against expert, not even expert against expert in respect of Mr. Carrim himself. The only reason I point to that is that if that's the Commission's real concern, then the elephant in the room is they think that the doctor is a liar, and they have the weaponry available to them to test whether he's a liar. And all these inaccuracies, whether they're of a material kind or not a material kind, I see Chair is getting ready. Maybe I should stop.
Please, you overdo this thing of reading what a person does. I mean, should I not lean over? Should I not place my hand on my file? Please, Mr. Premier.
Oh, sorry, Chair. I thought you were going to engage me on what I was saying. That's why I preemptively stopped. I also have the other problem when the judge is trying to intervene and I don't then yield.
I remember at the Constitutional Court you reacted to two of my facial expressions.
Yes, indeed. But I don't mind that because you found for me on that occasion, so that's fine, Chair. Unlike what happened in the interdict yesterday, but that's besides the point. Chair, what I'm saying is that if this doctor is so unreliable, or his evidence is so open to doubt and to question, why on earth would this doctor under oath volunteer himself to come and give evidence and be cross-examined under oath? The approach of the Commission, with all due respect, has not been to take a benign or neutral position towards Mr. Carrim, the deponents of Mr. Carrim's affidavits, and even the treating doctor. it's been that, and I'm speaking in forceful language, but I preface what I'm about to say with the fact that my learned friend didn't put it in these terms, but this is the conclusion. And we must call it out for what it is. In their view, the evidence leader's view, Mr. Carrim is avoiding accountability at all costs. He's using the deponents of the affidavits and treating clinicians to aid him in order to do so. And that's why they want to unpick, with all due respect, the most direct medical evidence in front of the Commission in order to go after Mr. Carrim. But the one thing they haven't done is they haven't called the doctor to be cross-examined by them, and he's volunteered himself to do so. So that's why this weird world in which we exist, with all due respect, is a difficult one for Mr. Karim's legal team to have to engage in, because even when the doctor volunteers himself, instead of bringing a rebuttal witness to directly deal with his clinical views, which is a possibility they could have done, or by calling him through a subpoena to come give evidence in camera and be cross-examined, they want to put up all kinds of geolocation data and CCTV footage to impugn the doctor's medical views through the back door where there's no clinical basis to do so.
No, Mr. Pramit, I think it's grossly unfair that you would formulate the position of the evidence leaders to impugn the medical opinion. They are lay people. They're lay people. They could never pretend to do that, and I've not understood them to be doing that. That is different to speaking to the facts alleged by the doctor. When the doctor says the hospital protocol is that you can only leave in two circumstances, that's not a medical view that he has expressed. He's alleging a fact, and it's relevant information to be brought to the attention of the commissioners through the commissioners through the evidence leaders, and the geolocation material, as Ms. Hassan says, what has always been the impression is that Mr. Carrim is in hospital. He's confined to a hospital, right? And once there was information that, in fact, he doesn't spend all his hours in a hospital, that's relevant information to be brought to the commission. So you have absolutely no basis to criticize the evidence leader's position as being to impugn the medical opinions of the medical conclusions and opinion of the doctor. I would be shocked if that's what they were doing.
Me too, with all due respect.
My first question would have, and that's not what is in the papers. My first question to Ms. Hassim would have been, on what basis? In the same way, in fact, that I would like to ask the question, the deponent to the replying affidavit is a lay person. On what basis could she pretend to answer the Commission's expert views, as you have referred us to a paragraph, right? Is that an answer really in response to the concern raised by Ms. Hassan that there is no reply or answer to the Commission's expert? So let's not fudge things for whatever purpose we're seeking to achieve. As I see it, or as I understand it, the simple position is this: there are certain facts that have been relied upon by the deponent to the affidavits of Mr. Carrim, supported by the doctor's affidavit. All that has happened is to answer those factual or to raise issue with the facts as set out, and none of it speaks to the medical conclusions. I differ with you there. Maybe my co-commissioners agree with you, but I differ with you. I do not see that.
I actually agree with Commissioner Baloyi. What the evidence leaders have done is to say Mr. Carrim must be subjected to an assessment by an independent doctor. And that's exactly because they, as evidence leaders, cannot purport to contradict the Mr. Carrim's doctor's opinion. That is why there's this insistence on let Mr. Carrim be subjected to an assessment by. It would be that independent doctor that would counter all of the clinical conclusions reached by Mr. Carrim's doctor. So at this stage, the point you make has not been reached, at least not on my understanding.
Well, but that
yes.
Sorry.
But of course, a point is made, but on what Commissioner Baloyi refers to as facts. A point has been made that with regard to those facts, even what Mr. Carrim's doctor says, there has been a shifting
Yes.
of the goalposts, even by the doctor
Yes.
himself. That's a factual issue, and the evidence leaders are perfectly entitled to challenge the doctor on that.
I accept that, but then I would ask, my next question would be to what end and to what purpose? Because on the question of factual discrepancies, both of the deponents to the affidavit full square deal with the circumstances under which they were expected to depose to affidavits and the pressurized circumstances that they had to deal with various issues. And that's explained at pages 75, 76 for the one deponent, and with the other deponent, specifically on the medical records issue, you'll find that at 84, 85, and 86. So if there's an issue about the facts, so to speak, and the conclusions or the inferences that the commissioners are being invited to make as a result of these so-called inaccuracies, there's actually an explanation.
They are not so-called. They are inaccuracies, and Mr. Carrim's case, as we sit here, actually accepts those, that they are in fact inaccuracies. Hence the shifting of goalposts. So they are not so-called.
I withdraw the word so-called. To the extent that there are inaccuracies on the papers, they're dealt with fully, and the surrounding circumstances around how those inaccuracies arose are fully dealt with. It's not uncommon in urgent applications, for example, that sometimes a deponent doesn't fully remember what it is they otherwise ought to have remembered. And it's only when they are advised of something in an answering affidavit that then in the reply they give the fuller account and context because of the pressured circumstances in which they were deposing. So all I'm saying is that let's accept the inaccuracies are for what they are. It's maybe unfair is too strong a word, but it's unfortunate to draw any adverse inference by the mere fact of those inaccuracies in circumstances where there's also an attempt to explain how those inaccuracies arose. But to the extent then those inaccuracies relate to movement and what can be said about Mr. Carrim's medical condition as a consequence of the facts of that movement, it's not a purely factual inquiry, because what the doctor says in terms at paginated page 44 of the papers, at paragraphs 49 and 50, is he says that the danger in analyzing the facts of those movements would potentially lead you to draw an inaccurate clinical conclusion, because the fact of those movements is not necessarily antithetical to the treatment he's receiving. In fact, in another part of the affidavit, he actually says that it might form part of the therapy process. So I accept what Commissioner Baloyi puts to me. Commissioner Baloyi rightfully says that they're not impugning his clinical diagnosis, they're just relying on these factual issues to say there's a problem here, and I'm being loose in my language. And so let's accept that there's a problem here, and then say what's the clinical opinion in respect of that so-called problem that's on the papers in front of you and not challenged. And that's what the doctor warns the commissioners, from drawing an inappropriate conclusion on, that those mere facts are elevated to considerations that impugn, or not even impugn, that open to doubt the clinical diagnosis, even if that's not the direct intention of disputing those facts. And what the doctor's evidence is regarding those facts is that they are what they are, and they might be what they might be. But you can't draw in, based purely on those facts, you must be very careful in what conclusion you draw. And I'll put it no higher than that. So I think that's where Commissioner Baloy, I was dealing more with the conclusion and the conclusions to be drawn from those facts, whereas I think, Commissioner Baloy, you were focusing on those facts themselves, and I hope I've attempted to answer you in both respects why there's a danger in the exercise that we were just going through. Yes. Oh. I thought Ms. Madlanga had something for me. She doesn't. So that's on the issue of are we impugning or are we not impugning, and to what extent are we impugning? Just, Commissioner Baloy, one thing that you raised, which is correct, the deponent is a layperson. What business does she have engaging with the report? If I'm not mistaken, there has or should have been a signed confirmatory affidavit from the treating doctor in respect of the content of the replying affidavit. And even if it doesn't say it in terms, I consulted with the doctor on X, Y, and Z, and he tells me, here's the response. I would ask in a generous reading of that replying affidavit and the fact that it's confirmed by the doctor that the so-called medical responses are medical responses from a non-medical person, but confirmed by the medical person themselves. It's not just the deponent offering her own opinion or thoughts influenced by the legal team or anybody else. So that, Commissioner Baloy, I hope is a satisfactory response on those particular issues. Chair, I think I've dealt with everything that I need to. Might I just take an instruction, please? Oh, yes. I'm indebted to Ms. Madlanga. Commissioner Khumalo, back to our debate about the timeline and the date and when it started and everything else. The reference I had in mind starts on paginated page 36. It's the heading you'll see there under paragraph 18. And then through you, Chair, Commissioner Khumalo, over the next page, well, it starts at the bottom at paragraph 22.
18 says exactly what I said.
Yes, agreed. And then I'm asking you to read 22 at the bottom of that same page, particularly where it says health conditions appear to predate the commission. It then talks about his history. And over the page on page 37, I would say that I would draw your attention to the last line, starting 3 lines from the bottom on page 37, paragraph 22. It starts with, I emphasize this because the underlying blank, blank, blank. I know that might not be satisfactory to your question. I'm just giving you the reference that I had in mind when I answered your question.
It's also factually incorrect.
Thank you, Chair. I'm indebted.
Thank you, Mr. Premier.
Chair, may I ask a clarity, please, before we break up? In passing, you said that we must give by the close of business tomorrow the transcripts.
Just on your and my debate the last time on the power issue.
Yes.
Or lack of power, as you
yes.
argued. Yeah.
Yes.
Yeah.
Is
Just
it all right
that,
if...
Because, yeah, in the context of you talking about there having been no resistance, as I understood you, by Mr. Carrim, to the possibility of voluntarily agreeing to an assessment. That's the context.
Yes, yes. Is it okay if we mark the transcript?
Yes, yes, yes.
Okay.
Please. Yeah.
Thank you.
Thank you to both counsel. Obviously, we can't make a ruling now, and I'm loath to give a deadline by which a ruling will be made. Let me just say, a ruling will be made on a date that will be announced by writing to Mr. Carrim's attorneys and also being publicized in the manner in which our spokesperson ordinarily does. We continue on Monday, 9:30?
9:30 on Monday, yes, Chair.
Yes. Let's adjourn and resume at 9:30 on Monday.